conferencia está por comenzar. Los invitamos a ingresar al auditorio.
Welcome to the 6th edition of the Marval Summit on Compliance, Anti-Corruption, and Investigations. And also, please welcome Santiago Carregal, Chairman of Marval.
Buenos días a todos. Es un placer darles la más cordial bienvenida a esta sexta edición de la Conferencia Internacional sobre Compliance, Anticorrupción e Investigaciones en nuestro estudio Miembros Empezando del año 2018. Hubiera querido darles estas palabras de bienvenida
I would have loved to greet you in person, but unfortunately it hasn't been possible due to professional commitments. This year we have over 36 experts of international prestige who have generously accepted to share their experiences and learning lessons in the subject matter. So I would like to thank you for your enthusiasm, for your predisposition that actually will make this conference all the more enlightening. I thank you all in the audience, both in person and virtually online, who have joined today and who will follow the streaming through our platforms. It is a huge pride to see the number of people who have registered and the geographical distribution of attendees. We have over 2,400 registered participants in attendance from 4 continents. It is great to see how the prestige and the international interest that this conference sparks is ever increasing. You've seen that this year we've included some new topics in our agenda, such as AI use in all matters of compliance and the analysis of most adequate methods in order to provide responses vis-à-vis cyber attacks. However, that does not take away any relevance to fundamental aspects of compliance understood as the most strict compliance to ethics and integrity norms and the compliance with regards to the legal framework. This is fundamental for the public sector and private sector at large, and of course is applied to our firm and is actually present in our ethics code. These have been fundamental pillars for the growth of our firm, and this year, 2023, when we are celebrating our 100th anniversary in existence for the provision of legal services to our clients, we want to emphasize our commitment to these values. When we started our compliance practice at our bureau, compliance was little known in Argentina. And at the end of today's edition, after 6 editions, we will have had the opportunity to listen to over 130 experts of international acclaim, 21 of which are partners in our firm. Compliance is then a leading topic, a leading subject matter in a country, across the region, and elsewhere in the globe. Since the pandemic and geopolitical crisis have been able to halt the advances on compliance. So I wish you all a very enriching conference, and may all debates and exchange of ideas that may serve be a source of inspiration in order to continue working for a more transparent and ethical future, both in the public sector and the private sector as well. I'm now going to give the floor to my partner, Gustavo Morales Oliver, who leads the compliance anti-corruption investigations at our firm, for him to share the vision on the state-of-the-art on the national and international spheres. Thank you, and enjoy the conference. Good day, everyone. Welcome to this 2023 edition of the Conference on Compliance, Anti-Corruption and Investigations that we are hosting here at Marval, Farrell and Mayral. Taking up on Santiago Carregal's words, our chairman, who for the first time was unable to join us here in person. It is a pleasure to see how interest has actually grown in the subject matter, and the attendance that's for this conference that started back in 2018 in a spontaneous way, getting together among a group of attorneys at law from different countries who work on these issues on a daily manner, to share learning experiences and to continue developing our practice. Today, we've reached a situation where all of the attendees have anticipated their interest, and those of you who have also joined online have expressed your interest. And it's great to see that we have over 82 countries attendees. So again, more than 82 countries have expressed interest, and that is why we see this high level of attendance. My intent today is to share what we see in the compliance, anti-corruption, and investigations practice here in Marval that I'm responsible for leading. We are fortunate to participate in international, national, local cases, work with people from different industries and interact with other law firms, with other consultancy firms and experts that are in the practice at different places, sites in the globe. So year after year, we try to share what we see at present and vis-à-vis the future related to compliance, investigations and corruption. This time, and always trying to be ever more specific and concrete and to give way to the different panelists that will be joining, I'm going to actually share three main ideas that we see in this practice on an international level. First of all, the evolution of compliance. It is clear that compliance was born years ago when we most likely were not going to be able to fill in the room as we have today, or to trigger the interest that we see in the online attendees with something related mainly exclusively to anti-corruption. But nowadays, if we talk to people who believe to be practitioners of compliance, we need to ask further, what type of compliance, for example, and maybe say, well, I'm into sanctions. So economic sanctions that, although they were indeed existing before, they had a momentum as of the war conflict between Russia and Ukraine. So we're looking at a war conflict, a geopolitical conflict that instead of getting away from the focus of compliance, it actually exacerbated it. So we look at issues also related to technology, to privacy. Technology is the third aspect that I'm going to tap into during my introduction, and we're going to talk a lot about technology then throughout today's agenda. Truth is that in terms of technology, this also triggers aspects of privacy of data. And at times, I think that we will stop talking about sharing of data because the data are all out there in the world. So privacy shared also with technology companies is a huge component of your areas of compliance. Additionally, regulatory frameworks is key. If we talk about anyone in the pharma industry, this is essential for their compliance practice. Topics that have to do with antitrust, topics that have to do with trade compliance elsewhere as well, of course, and the classic historical alongside anti-corruption. We could say it is part of anti-corruption, and that is anti-money laundering. And as if this were not enough, we've seen an exponential growth in everything related to ESG. We have not yet covered all of compliance, but we also have ESG. We have lawyers, attorneys at law, lots of regulations, programs that move forward. And of course, it becomes ever more complex because it is ever more broadening and encompassing. So the evolution of compliance shows that regulations are multiplied year after year. We have not yet comprehended one, and then we have a new one. And an international bureau or law firm, you need to know now regulations from a broad series of countries, understand how they juxtapose, understand the regulators in one country and the other one. So the scope of compliance within firms and for us who are external consultants are ever growing. So we will see this ever growing complexity. We will see an ever growing complexity and overlapping with legal aspects. It is clear that when there is litigation, it'll be only legal aspects, maybe an internal investigation, but when there is a risk analysis to develop policies, it'll be very difficult for the legal team to join that investigation. But juxtaposition and overlapping is huge. There is a challenge then to face. We will need to understand each other, understand regulations, and understand the changes that emerge. So as of the idea that I want to share, that is, where are we heading for with regards to these topics? So who's a true driver of the evolution, of change, of the impact in terms of compliance? So with the broad scope that I've just described. Normally, when you discuss these topics with different companies, there are different questions that arise. The first one is, what's the regulation in place? The second question is, what are the cases where authorities may have imposed sanctions? And then, of course, comes, oh yes, but then. But I'd say, I'm not saying this is right or wrong, if it's true or false, if it's fair or unfair. The perception is that authorities are slow and do little. That is the overall perception, and I'd say this is the case in every country across the globe. There's also the perception that regardless of the country we're in, we will look at authorities in the US because they tend to take the lead. But still, it is believed that they do little and slowly. However, you also have the stakeholders. We start to see how decisions made by companies are vastly determined by what business partners do, by what clients do, by what creditors do. So, when it comes to looking at the actual momentum or burst forward in actual time, it is not just about looking at authority and enforcement, but actually thinking about stakeholders. Stakeholders react rapidly and strongly. And what's interesting is that they don't necessarily have all of the information, but they don't need it. And actually, sometimes they don't even want all of the information. But those who want all of the information go slowly, they do a lot of research, and when decisions are made, maybe we hardly remember what happened back when the facts actually happened. But that between enforcement authorities, it is very important to understand what's the true driver behind the actual impact of all aspects of compliance in the behavior of companies. The third aspect, and the last one that I want to share with you with regards to where we're heading for in this subject matter, has to do with technology. And I've just mentioned that, particularly with AI. I think that we're not really comprehending the change that we're about to attest to. It's very difficult for us to envision that change. We will have a special panel addressing this topic. We will also hold dialogues at different panels. We will give for space so that you may learn from different experts and how this issue is seen. But let me just give you a heads up on what I believe. I believe that today we think about AI as a new tool, that if you're fortunate enough, compliance officers will allow to have training sessions without so much effort, enhancing your policies without requesting for an external consultant, so you may allocate that budget to certain other things. But I think that that's minimum. benefits. And in the future, we won't even consider that relevant, because AI will not only participate as a possible tool for compliances from the prevention side, but also will be participating. And one of the topics we will be discussing is how new is this? We will be addressing AI 2023 edition, because it seems that it was not existing before. ChatGPT was born in 2023, so now we have AI, and that was not AI before. So we will learn from experts, and we have experts clarify this. But with all of these new tools in 2023, this will also, or in turn, help with other tasks that are much more complex in compliance departments, such as internal investigations, that also have to do with what we do as external consultants. And more interestingly, it will also help all enforcement to do their own investigations. And this investigation may be related to investigating after there is a suspicion or something has occurred. But this will be also about investigating ongoing when there are red flags, for example, and act accordingly. And furthermore, AI will participate in the business of companies. It will be embedded in the company's operations. We are now in 2023, and I ask myself the following. Will there be a time when we will be having a meeting such as this one, and we will be discussing that there is an AI bot called ChatGPT, or you name it, that will be making the presentations vis-a-vis customs? Just to set an example. Vis-a-vis any regulator, because ultimately those presentations have to do with gathering information, presenting that information, something that AI does quite well. So will AI be able to incur in any misconduct, in any crime, commit any crime? Will it depend on anyone giving instructions? If that were the case, who will be responsible? Who will be liable? People from compliance were not able to foresee, so where do we stand there? That topic will be quite complex, will stir lots of advantages and tremendous challenges. That is, we believe, from Marval, the main aspect of interest looking into the future. And I insist, we still have not been able to comprehend and master everything that we have at hand, but there's a lot more coming up. So our message is we need to stay flexible. We need to stay quite alert to what's going on. What happens with for compliance goes even beyond the new regulations from different countries, and we need to be able to react to those changes in the best possible way, as you know, always with restricted resources. So there will be lots of topics for everyone. You will not really be bored today. There's no doubt about that. And the continuity of growth compliance, at least from our perspective, is, we believe, secured. So that said, I welcome you all once again, and we're now going to move to our first panel with Delia Farina Rubio, Global Chair.
Muy bien. Delia.
Delia, what a pleasure to have you here. Now, face to face, we were able to achieve that. And just if you haven't met Delia, she's a global chair for Transparency International. And some people say you're based in Germany. I understand that's your position, but you're actually based on a plane. Actually, accurate description. You're a true global citizen, and it is a pleasure to have you on two sides. For example, on the one hand, you acclaimed career with everything related to anti-corruption throughout so many years. You were very passionate about this topic, and there are some who believe that your involvement in this area came as of your participation in Transparency International. But on the other hand, or on the side, we have the huge advantage of having your presence here, knowing that generally part of your daily role role has to do with addressing these topics with presidents from different countries across the regions and different worlds, with ministers participating in forums such as the OECD, also engaging with NGOs operating across the globe, discussing with CEOs, most important at the World Economic Forum at Davos. So we want to learn from you about everything that you want to share with us. And let me start with a question that refers to your experience in all of this. You have a very global vision of all of this subject matter. So the first question goes to you. What do you see different in the fight against anti-corruption vis-a-vis what you saw 20 years ago? Are we still trembling, with the same stones, or is that a nature that is not changed? Or do you see the world enhancing its fight against corruption? Or are we standing at the same place? Thank you so much for your kind introduction. I think that we've made huge progress, but at the pace we're moving, corruption has really changed, much more accelerated, in a much more accelerated fashion, much more in a much more complex, much more sophisticated fashion. There are new features, new actors and stakeholders that pose new challenges. So transparency is now turning 30 years of existence. I started with these topics 40 years ago, so it has nothing to do with how we started working around this. And there are also aspects that have to do not just with the fact that there are new actors such as organized crime or different networks penetrating states, exerting pressure on public policies. That is the corruption that we many times see, but rather that the economic context sets new forms of corruption. When we started off, the corruption we were referring to was what we would term the small corruption, that is, corruption of citizens that would claim for something he believed had a right to, and then the public official would say, yes, but you need to provide me with certain money for that favor. So when we had the globalization as an economic context, we saw this corruption sustained, but there was a new form of corruption, what we call the Odebrecht, for example, or Siemens. There was a big corruption, transnational corruption, involving not just the citizen or the public officials, but the maximum authorities of every country and the leaders, top leaders of multinational companies, money laundering to offshore companies, etc. But nowadays, what we see is a new form of corruption. Today, we have a piece of news in our headlines in the newspapers that should be really making a lot of noise. That's in a port in Tierra del Fuego, granted to Chinese companies. So we see a new geopolitical context, and this is what we believe has been termed geopolitical corruption or geostrategic corruption. That is the use of corruption as a mechanism by the state to, or certain sectors of the economy in order to set the rules by essentially kleptocratic states that through their co-oligarchies co-opt economies. This, for Latin America, is something that is only emerging, is already in place, and we have seen this for many years. We have a base camp in China, in the south of our countries, but this in Africa, for example, is fully in full-fledged. And when we see this corrosive capital, so this geopolitics that corruption is using enters the state, changes the total format of economy and corruption because of the actors, stakeholders, because of the power they have and the influence that they exert. So the fight has made us that in 30 years, and you were talking about regulation in your presentation, we have the judicial infrastructure that we have. When we started off, there were no international conventions or anti-corruption offices, no international financial units, etc. Now we have all of those instruments in place. The thing is that those tools need to be adjusted because they're not always the adequate ones. And it is still not enough to have laws. Rules are necessary, but they're not enough to face corruption. Absolutely. It's not that, I mean, regulations will not per se have those outcomes. They are necessary indeed, yes, and you all know this. You are lawyers. It is a kind of narrative, of course, but we need to move into action. We need to land that speech or discourse or narrative into action, and that action into real impact in order to attain the outcomes we seek, the defensive values, freedom, liberties, facilitating environment for everyone, because something that's important with compliance, and when you talk to the private sector in Davos and elsewhere, is that many people in the private sector have realized that transparency or integrity is a good business for companies, because this allows them to compete with certain security in a fair setting.
Absolutely. And let's get deeper into this idea that the rules by themselves will not lead us to the expected results. Probably we will need authorities from different levels, from different countries, who should enforce the rules and regulations. So how do you see the world in that regard? Let me share with you that we discussed with some colleagues that even we who are compliance experts, can spend hours and hours talking about whether a bill is well focused, well directed, whether the rules are well drafted, and whether we need more laws to regulate more conducts and behaviors. But it's very hard to think, how can the enforcement be improved on the part of authorities? And an improvement may mean a benefit for the private sector, more transparent enforcement, a fairer and faster enforcement of the rules, because the dilation to solve the problems is more negative than being able to fix problems in a faster way to close the issue and continue. In terms of speed, rules and regulations have a role to play, because processes take too long, to the infinite and beyond. You know that the rules and regulations contemplate many windows of opportunities so that we, lawyers, can file our applications, so on and so forth. But the laws should contemplate that. Now, something that really makes processes very slow is the issue of mutual legal assistance mechanisms or legal support mechanisms among countries. That we just discussed this with the Association of International Law that is about to file a bill or a project. And one of the points they mentioned is that all international cooperation mechanisms are based on a legal framework of the 19th century. So if you are a judge and you are investigating a case, and you need information about a bank from Delaware, and you need to send the request to one foreign office and then to another foreign office, and then they still need a piece of information, so the process goes back. And all those things happen while money moves at the speed of a click on someone's mobile phone. So this is a regulatory aspect that must be corrected. However, the enforcement and implementation also depends on the structure of the organizations and entities that we create. Australia, after so many years, they reformed the Anti-Corruption Act to finally create the proper and adequate authority, enforcement authority. So the three essential conditions for these bodies to work include independence, resources, and authority. And so based on, or in these three elements, we may have a trap. Political independence. If the Anti-Corruption Office depends on the minister and reports to the president and depends on him and on them, no matter how independent that person may be, that person won't be able to control each and every step of the chain. So resources are also a big part of this. When we work together, when a piece of legislation must be approved, the legal promoters have the law approved in the official gazette, and that's it. But they don't pay attention to the fact that 3 months later, the national budget will be approved based on that. So, and I always share this example, and it's an anecdote from Central America. Many, many years ago, an anti-corruption prosecutor was created, and I was there visiting the country on behalf of a multi-government agency to examine and assess that figure, that person. I contacted the person, and he said, okay, let's meet at the shopping center coffee store. Okay, that called my attention. I was going to assess the anti-corruption prosecutor at a coffee store. And we started our discussion, and the people from the coffee store approached our table with a phone, and they said, "Mister, you have a call 1, 2, 3 times." And so I suggested, "Let's go to your office." Okay, let's go to my office, which is upstairs, but I don't have a secretary in my office. And here, the coffee waiters make as if they were my secretaries, and the guy from the coffee store gives me the internet to conduct my investigations. Okay, the man was sincere, he was honest, the law was in place, but the detail is that the prosecutor had limited budget to perform his job. So his hands were tied, and he couldn't do more than that. So there are many aspects, many details to focus on beyond the approval of a good law. We need to also pay attention to the budget that will finally implement what the law says, or tech resources. You talked about AI, which started in the 50s. And from civil society and in law firms like yours, probably they used AI to detect corruption in big corruption cases. So those red flags, those possibilities of detecting corrupt behaviors that can be made with AI. However, if you have an anti-corruption prosecutor who doesn't have those tech tools, whose employees are all working in a paper office, that it is really of no sense. I absolutely agree. It's like the strong push stops when the legislation is approved, and that seems to be the end of the story. But then we have another sector of society that operates on its own, and people, general society, do not pay attention to that. And this happens with other sectors. And in Argentina, we've had examples of laws that were very much discussed from the civil society, and after almost 2 years, the law would not be implemented. And in healthcare, for example, when the presidency of the nation was asked about it, they had forgotten to dictate the enforcement executive order. So everybody was applauding at Congress, right? And the people had that in mind, but then they forgot the final enforcement paperwork, I would say. Good. And I would like to mention something that I know that you've explored along your career when you talk about real-life corruption. Let's forget about the books. Real-life corruption works as a mechanism to earn money and win power, right? So it becomes, let's say, a geopolitical tool. Now, that money, those funds derived from corruption, we are talking about an amount of money that cannot be hidden under a chair or in a suitcase. So you've studied this quite a lot. How does this money move around the world? What happens with that? It is a central issue because, and probably you've seen every year in January, our corruption perception map. Some countries in yellow and many countries in shocking red, where we are located as well. So the money lost to corruption in those countries which are perceived as corrupt in public sector, that index doesn't measure organized crime or transparency. The index measures the public sector of a country because it started 25 years ago when corruption was different, right? Now there are other tools as well. So the money lost in countries perceived as corrupt ends up in the yellow countries, because corrupt countries are corrupt but not full. So they are going to put their money in the countries that offer guarantees, privacy, security, so on and so forth. So those countries in yellow have a key role in the fight against corruption. I'm not an official who asks for some bribes for vaccination purposes. So this is part of what I call the corruption circle. I'm going to say it in English, by the way, because I haven't found any translations in Spanish. The she circle, to steal, to hide, and to enjoy. So this is a corruption circle. The northern countries are those who facilitate the hide and the enjoy, including real estate industries or the luxury industry or the industry of art in Switzerland, for example. So, of course, the banks also make profit with the corruption-derived money or filling in so many reports that we cannot control at the FIUs. So those countries and those sectors have a central responsibility. They are the famous gatekeepers. They should be controlling and asking the right questions, but they are part of corruption. They help hide the money and then give the possibility for corrupt people to enjoy it largely. So, let's talk about some mechanisms. Everything related to transparency records of final recipients. This has made progress a lot. Without knowing who is behind an account, who is behind the business, it is very hard to start an investigation, as you may know. So the registry of the UK, the business property registry, they used to register Donald Duck, the Disney Donald Duck, as the owner, and nobody would check anything. So that is a pantomime of the fight against corruption. However, progress has been made. The U.S. has approved important pieces of legislation. Now they are still discussing all the regulatory part. For example, now companies will not be able to say that they don't know who the owner is. The law would not authorize that. However, the rules of the law would allow for people to say that they don't know the owner of the business. So that is just one detail that puts the system in danger. Now, if we talk about banks, quite regulated, other less regulated professions, in Europe, for instance, the discussion is around the client-lawyer privilege. That's the whole thing, because for us, that is a sacred privilege. And that is why the bar associations internationally are screaming out loud at these type of things. So that could be a barrier, undoubtedly. Something similar happens with accountants. However, internationally, accountants are working to self-regulate so that they can have more due diligence, to know their clients better, to work more as gatekeepers. So one thing is to work at global level, and another thing is, I mean, people say there will always be one person doing that. So that would change the rules of the game, and they would become facilitators. So I guess that associations of professionals should have the capacity to, again, avoid having facilitators, despite the associations maybe point to a different direction. Then there are more informal sectors, harder to regulate. At the World Economic Forum, we have a task force with gatekeepers that includes the real estate sector, the large real estate holdings in the north. That also includes the arts industry, which is very little regulated, as you may know, but is key in order to hide money and enjoy it. And we are working with this task force on a self-regulation initiative to set certain principles so that all professionals should follow, as long as they have a true anti-corruption commitment. So again, some things are being implemented, but along the road, every step we take also finds a barrier. And there has been a setback, and I said it at the OECD a couple of weeks ago, was the resolution of the European Court of Justice about the access to the beneficiaries' records. With an increase in the privacy of business people. We as lawyers know very well that there are conflicts of rights many times and conflicts of interests. However, there are interests higher than privacy of a person when these type of investigations are at stake. So what the court did was to go back 5 or 6 years from the progress made in that regard. Right now, they are rewriting a European Union directive and the investigation journalism, as well as some compliance and corruption agencies, as well as Transparency International. We are trying to review the rules to access those records so that the resolution of the court cannot be a true obstacle. Anyways, we have to say it many times, judges are functional to this circuit. So it is a complex system, right? We need to see it from different angles. Okay, we have 1 minute before the end. What can you tell us in this 1 minute? Thinking about our common origin, or background, which is Latin America. What can you tell us about the fight against corruption in Latin America as a region? Okay, very worrying, very worrying. Okay, 3 seconds were enough, thank you. I can give you more. I mean, here, we started with this discussion, right? Is that we met a few years ago when I said corruption is a topic that affects us all. Think about the train accident that happened here in Buenos Aires, many lives ruined. Think about the port of Beirut, the explosion, a huge part of Beirut destroyed, many people dead. Think about the earthquake of Turkey. where the re-elected president for many years through dark agreements had lowered the requirement levels in construction in the areas where damage was highest, where the construction company itself would make the audit, the compliance audit of its own construction quality. That is terrible. Okay, I have never heard of that. So, we are the victims. That is the truth. We need to fight all together. And this is studied in corrupt countries. Even natural disasters produce at least 5 times the loss and expenditure in non-corrupt countries. So it's an issue that creates real problems. That is the point. And the good thing is that we always have something to talk about. Yes, and we haven't talked about technology, by the way. You're right. So it's been a pleasure. Thank you. Thank you very much. Next, we have a panel on World Bank and the IDB. Thank you.
Nuestro próximo panel lo vamos a hacer en inglés, so we are switching to English now. We are glad to have Bobby Delonis and Jose Hernandez Toro. They are both members of the World Bank and the IDB, the Inter-American Development Bank, respectively. Thank you, Bobby, Jose, for joining us today to discuss a few of the issues that you handle on a daily basis. So first step, let me make sure you can hear me well. The connection is working fine. Yeah, all good? Perfect, perfect, perfect. So let's start. We have about 38 minutes, okay, to go on with our conversation. So let's start hearing from you. I mean, the basics on how the World Bank and the IDB are different from other banks, right? I mean, what is essentially what you do that makes you stand out? And then we will jump into the sanctions regulations that you deal with that have impact in public and private sector projects. So let's start there. Let's say, Jose, if you want to go ahead.
Thank you, Gustavo. So we can start very briefly what are multilateral development banks, or MDBs as we call them. They are international financial institutions, which includes the most commonly known, the World Bank, Asian Development Bank, the African Development Bank, among others. And MDBs are comprised mainly of donors and borrowing member countries that provide financing advice for the purpose of economic advancement in developing countries. So they provide financing for development projects for millions of dollars only. And MDBs are mostly governed by boards that represent their member country governments. And so finally, MDBs have privileges and immunities. They are ratified by member countries by their respective parliaments. And the staff is fully completely considered international policy.
So let us know, how may a company, in the private sector, know whether they are involved in a project that it's impacted, by financing from either the World Bank, the IDB, or other of these MDBs? How would we know? I mean, whether it's relevant to keep, sanctions regulations coming from your banks into mind when structuring these deals?
So I would say in general, or more often, the the bidding document will be the document to start. They often will advertise the program that is financing the contract. You also would like to look at terms of reference, the request for expression of interest or proposals, or in some instances, the contract itself may include reference to the source of financing and may indicate that the contract is being financed by an entity.
Okay, so let's suppose I can think of a scenario where a company may say, you know, I was completely unaware that the World Bank was behind this or the IDB was behind the financing in this project. So therefore, I should not be subject, you know, to any kind of investigations or sanctions by these entities. Would that, you know, argument work in any way?
The short answer will be no. Not knowing that an operation was financed by an entity will not matter for purpose of an investigation. It will not impact jurisdiction. Operational documents generally will refer to operations that are financed by the MDBs. So it's preferable that companies participating in MDB-supported projects know about the MDB's involvement. And that will be for setting expectations, right? So that they are aware that there are rules and procedures and policies that they need to follow.
Okay, so first takeaway from this conversation, ask the question whether MDBs are behind the financing for this project. Okay, first note there. So Bobby, let me ask you, so what are the rules, right, that this type of banks actually apply? You know, why should we be concerned on whether there could be sanctions? What missteps may companies be involved in that may result in a sanction by these banks and, you know, ultimately losing the financing and being banned from participating in these kind of projects in the future?
Right. Well, thanks, Gustavo, and hello, everyone. I think to sort of start in answering your question, it's worth thinking about what Jose just said. What are the MDBs, right? So as development institutions, we want to make sure that the development projects that we finance are effective. You know, the World Bank works for a world free of extreme poverty, shared prosperity on a livable planet. We don't accomplish those goals if our projects aren't effective. So we have a range of rules that apply to our projects. Some talk about how they're designed, how they're implemented, rules that apply more to our borrowers or to private counterparties on our private sector operations. We have rules about procurement, financial management, environment, and social issues. What's relevant for this audience is our rules on integrity. We care deeply about fraud and corruption issues for some of the reasons that Ms. Ferrer-Rubio just mentioned. Fraud and corruption harms our projects and it harms development more broadly. You know, our project funds are wasted if we've seen cases in INT's past where money that was supposed to be spent improving a road was spent to build a home for a project official. And the road degraded because anyone who's paying bribes isn't paying that out of their own pocket, right? They're taking that out of the work that they're doing. And so because we're concerned about that, we're concerned about long-term governance impacts. If a country is perceived as being corrupt, that can reduce foreign direct investment, the IMF found, by up to 5%, which has a significant macroeconomic effect. And we owe a fiduciary obligation to our member countries to make sure that their funds are used for their intended purposes. So in this area, very specifically, we have rules that prohibit fraud, corruption, collusion, coercion, obstructing one of our investigations. And then depending upon the MDB, some of them also have rules about misappropriation, anti-money laundering, and you know, financing of terrorism. It depends on the institution that you're talking about. But the core is fraud, corruption, collusion, coercion. And you can see those, as Gustavo said, or sorry, Gustavo, as Jose said, in framework rules that apply to the project. We have guidelines. You can see it in our procurement rules. And then those also will sometimes be reflected in specific documents that companies may see if they're bidding for a contract that we finance or if they're signing a contract that we financed.
All right, so you described a number of regulations there. I mean, quite an important list of conducts, right? So in addition to being mindful of local regulations, whatever, you know, the business project is going on, companies should also be mindful of regulations by MDBs, again, multilateral development banks, involved in the financing. Okay, so are these rules the same for all the MDBs? I mean, how do they differ? How are they similar when it comes to one MDB or the other, let's say the World Bank or the Inter-American Development Bank, for example?
Sure. So each MDB is a different international organization. So they're a little bit different, but in this area, they're very, very similar. We have harmonized standard definitions across these development banks of what is fraud, what is corruption, what is collusion. Those are harmonized. And then there are common principles that we've worked together that even though each institution may have slightly different rules, there are common elements to them for things like if we were seeking to impose sanctions, how we would assess what sanctions should be imposed. We have common principles and guidelines for that. We have common principles and guidelines for if we're sanctioning a large or complicated corporate group, how do we go about determining which pieces of that group might be sanctioned? Each institution has their rules, but they follow these common principles. And then similarly, if a sanction is imposed, oftentimes the MDBs will require business integrity programs to be implemented or improved as part of a release from sanction. And there are general principles that help guide that as well.
All right. So, I mean, you are making it somehow easier, right, for the private sector because you have a set of harmonized definitions of certain conducts, as you described, which is not the case, when you compare regulations between different countries. As I always say, even the definition of bribery is different from one country to another. So they all sound similar, but they are different, right? So good for you guys. You're making it easier with the harmonized definitions. Thank you for that. That being said, where can one find those rules and regulations? I assume the website for your banks, but I mean, how will it be possible to be really aware of all of those regulations and where are they published?
Right. So as Jose said, to start with, in many instances, you may see references to those rules if you're competing for a contract that we finance in the bidding documents or in the contracts if you were successful and received one that you sign. But as Jose also said, it's not a requirement, it's not always there. And Gustavo, I would agree with you. The place to look really is on our websites. I know they're very large websites for all of the MDBs, but the integrity offices, the investigative offices, have their own web pages that include and usually a key documents labeled thing. So for example, at the World Bank, if you go to worldbank.org/integrity, we've got links to these rules where you can see them and learn about them and get copies of them. Oftentimes the bank's sanctions offices will also have websites where these rules are references. And in addition, if you're participating in one of our procurements, the procurement documents and rules that govern those processes are also all public and are also all shared on our websites, and they include these rules as well. So if you're wondering what rules apply to you, as you said, Gustavo, they're harmonized, but you always do want to look for the rules of the particular institution that's involved. So if you see a bidding document and it says it's financed by the IDB, even if there's not background records, it's worth looking to see specifically what the IDB's rules are, and that's where you can find them.
Excellent. So when we were preparing this panel, I remember you guys told me about this common mistake, right? And in understanding that MDB rules are either contract-based or notice-based. So tell us a bit about that particular point.
Right. So one of the things that's very interesting about our work, because we work for international organizations, what we are applying is international administrative law. So these rules and the sanction systems, the investigative offices that apply them, we're not operating based on contract. We're not operating based on notice. We are implementing aspects of our organization's charters. So these are all processes and rules that are inside the MDB. They apply to the project as a whole, as Jose said, and then they flow down to the participants that are in that, whether they know about it or whether without a contract with the MDB specifically. Those are not prerequisites. In practice, a few MDBs and instances may have chosen to limit certain aspects of their work with prior notice, but most MDBs don't require it. So for example, in the World Bank's instance, if we're lending to a project implemented by a government, our rules simply apply to everyone that receives funding under that project and anyone that's making decisions influencing how that funding is used. Our anti-corruption guidelines apply to everyone. And this issue is actually even been raised before our sanctions board. We had a case which resulted in decision number 130, which dealt with a company that had won a contract where the rules weren't referenced. And the board agreed with the bank's policy, which is, no, the rules apply to the project and therefore to the company as well.
All right, so we were just a few minutes ago discussing with Delia Ferreira Rubio that rules without the system to implement and enforce those rules mean very little, right? So what do you guys do? I mean, what type of procedures do you have in place to investigate cases and impose potentially sanctions when wrongdoing has been proved?
Well, I guess I can speak at sort of a very broad level about how the rules connect, and then Jose, maybe I can hand to you to talk a bit about the investigation specifically. So if you look at our rules, those guidelines that I referenced earlier, like the anti-corruption guidelines for the World Bank, they state what we investigate. They contain those definitions of fraud and corruption and collusion and coercion. They also reference the legal tools that we use to conduct our investigations. So for example, the World Bank's anti-corruption guidelines have an express requirement that parties have to cooperate with an INT investigation. And then they also have a reference to the policies for the sanction systems that we apply if we think our rules have been broken. I think we can get to that a little bit later. Jose, do you want to talk about investigations?
Well, yes. Once we start on investigations, we have, through our authority to conduct audits and reviews, we are able to access or request information that we deem relevant to an investigation. So that will include, it's very broad, that will include any documents, any communications, financial records or anything like that that will deem be relevant to our investigation in order for us to determine if in fact there's a prohibited practice related to an operation that is financed in this case, by the IDB.
So what type of misconduct would you usually investigate, Jose, when dealing with these cases?
Well, as Bobby mentioned earlier, we go investigate fraud, corruption, collusion, coercion. There's also, for example, for the case of the IDB, misappropriation. There are other MDBs that have included definitions for theft, for AML and CFT violations. So those are, in general, what kind of irregularities or prohibited practice, as we call them, we will investigate. And it's related to what Bobby had mentioned before. It's part of our fiduciary responsibilities. MDBs are required to ensure that the proper use of funds. And for that purposes, we have set up this, or the MDBs have set up these investigative offices and an administrative sanction system to prevent, investigate, and sanction those prohibited practices.
I like it how you guys continue to explain that there are fiduciary duties, right? That there are some people you have to respond to. Some people will be asking questions about this, right? Why did you use this fund, in this particular project, which ended up, for example, in corruption or collusion or any of these types of wrongdoing that you have identified. But how will these investigations that you conduct be similar or different from investigations conducted by, the usual type of authorities that companies deal with, which are enforcement authorities in different countries?
Well, I'm sorry, Bobby, I will take this if you don't mind. In general, it is like a national law enforcement investigations in terms of for example, the techniques that are applied. It will differ that it is in an administrative investigation. And MDB's offices, investigative offices, for example, won't have subpoena powers. However, through those rights of audits and inspections, we are allowed to conduct those investigations. We request information, access to financial records, communications, conduct interviews. So in those terms, it will look like a national law enforcement investigations. We can hire experts to conduct technical reviews. And often we have cooperation with national authorities that provide for information sharing through MOUs or cooperation activities, or cooperation agreements, I should say. And also investigative offices could refer findings to local authorities. And I have, for example, a case where there was a bridge that collapsed in a rural community in Central America. And while we were in the process of investigating if the collapse was due to fraud, we were contacted by the National Controller Office, the Contraloría, to see if we could assist with their investigation. So we told them that we were in the process of procuring an engineering study to see what was the cause of the collapse. So the Controller's Office informed us that they
did not have the funds to do their own study and asked if we would share our results with them. So we were able to do the study, which found the fraud in the quality of the concrete utilized to construct the bridge. And then we authorized the company hired for the study to share those results with the controller's office. And eventually, ultimately, the company responsible was sanctioned by the IDB for 12 years for that fraud. So, and going back to maybe the causes of corruption, there was a collapsed bridge. Luckily, fortunately for us, there was nobody at the time. So there were no injuries, no death. But could you imagine what would happen if that bridge would have collapsed when people were crossing by?
It's interesting. This is another example of how corruption has impact in real life, just like you described. But it also shows one of the situations that we face many times in dealing with this type of cases with clients, that corruption cases tend to involve a number of authorities investigating the case. Sometimes it's different authorities from different countries when we are talking about cross-border conduct, but this may also be the case. This is a bridge in one particular place, just one country involved, and it was the local authorities at that country and you guys investigating the case. So that makes it much harder, right? Because you have different angles to investigate, different techniques, and more importantly, different resources, right? And I won't ask whether the local authorities got more resources or you did, right? But I'm sure that at least there should have been some kind of a difference there. So from the point of view of the company, and from the point of view of counsel to the company that is under investigation, what could this company, what could this type of counsel expect in regard to the issues that arise in the subsequent steps that you take during the investigation? By the way, either of you guys can go ahead with the answer to any of my questions, jump and make any comments you want, okay?
Thank you, Gustavo. No, I will start, and Bobby, you can jump in at any time. So expect an in-depth review of books and records. We will conduct interviews, we will request information. Those audits and inspection rights that I've been mentioning apply broadly to all information that we deem relevant to the investigation. And like you were just saying, Gustavo, it's a multi-jurisdictional approach. So MDBs have ability to conduct investigations in multiple countries without jurisdictional limitations. So while prohibited practices in the MDB have parallels to criminal codes or might have parallels to criminal code, our system is quasi-judicial and administrative in nature. So it's strictly with administrative penalties, and our evidentiary standard is the preponderance of the evidence, as opposed to a criminal case where it will be beyond a reasonable doubt standard. So as international organizations, and you're gonna see this repeated a lot, we are not bound by any national legal system. So national precedents do not apply. And of course, privilege and immunities are gonna be there that protect the institution and staff for being subject to local codes. Bobby, I don't know if you want to add anything to that.
I think I just underscore one aspect, Jose, of what you said, which is the breadth of the information that we're entitled to access under our rules. We need to understand how our funds were used. We'll sometimes have companies, for example, that will say, well, I'm using a project-based accounting system. So I'm going to give you the accounts for just this project, but I'm not going to let you see anything that's in our broader accounts. Well, if we see transactions of funds moving back and forth between the project account and the general account, which can be common, then our offices need to see and are entitled to see those broader sets of records as well until we're satisfied that we understand how those funds were used. So that's a really important aspect here, as Jose said, and that cooperation is very important for everyone.
So let me pick up on that. So let's suppose that you start investigating a case and the company decides not to cooperate. So how would you move forward? What would it mean? What would this mean to the company, right, in terms of the particular project that is under investigation and future projects involving your banks?
I can start, Bobby, and then if you want to jump in. Well, as Bobby was mentioning, cooperation is very important, and not cooperating could be subject to an obstruction charge, which will be a separate prohibited practice to any if we find any other prohibited practice occurred. It's also it could be used as a mitigating factor if we decide to move forward with a sanction. The fact that the company cooperated early, provided that information, could be we use that as a mitigating factor that could lower the sanction for the company.
Bobby, any comments on cooperation? I mean, companies refusing from cooperating?
Yeah, no, I think Jose covered it. There are big benefits to cooperation and the possibility of abstention for obstruction if one doesn't cooperate. So, we're very much trying to incentivize that, and there's real reasons to work with us if we're conducting an investigation.
So any other comments you may have on how companies may react? What is the best way for companies to engage with an MDB in this type of investigations? I mean, do you expect companies, for example, the usual suspects, in let's say, in corruption investigations,
identify issues in their operations that may have a touch on something that an MDB financed? I can speak from the World Bank's framework, but it's as consistent with what Jose said on the Inter-American Development Bank side. There could be substantial mitigation provided for admission, for cooperation with an investigation, for conducting an internal investigation, and then fully disclosing its findings to the World Bank or another MDB. And if you go and look at past World Bank sanctions that are imposed, involving my office, we will and can enter into settlement agreements with companies, and you'll see a number of past settlement agreements where companies may even potentially avoid debarment entirely and have just a conditional non-debarment sanction, which we'll talk about in a moment, but means that you remain eligible to receive contracts and participate in projects that we finance, subject to certain conditions, usually surrounding integrity compliance measures in the company. From our perspective, that's about the lowest sanction that we can offer. So we're very, very much in favor of voluntary disclosures, and there are very significant benefits to doing that with us.
Yes, but I will agree totally with Bobby. We also have what we call the negotiation resolution agreements, which are settlements that we go into with the companies where they fully cooperate, they do internal investigations, they establish a internal compliance program, or they improve their actual compliance programs. And that will provide for them to have a quick resolution of an investigation and take credit for that cooperation and for that investigation, which will lower their sanction significantly.
All right, so it's clear that incentives for cooperation and self-disclosure are out there. What about the possibility of the company, you just mentioned this, Jose, running its own internal investigation? Would you say this is a good idea? Would you prefer that you conduct the full investigation and the company just sits and waits for your results? What would you think is the best approach for a company in this type of cases?
We always welcome companies that conduct their own investigation. Of course, we work with them to establish the terms of what that internal investigation will be, what the results that we are going to expect from that investigation. But it's very welcome from us when we see a company that is cooperating and agree with us and has the ability to conduct their own internal investigation.
So at what point in time would you expect the company to tell you that it's conducting its own internal investigation? Would you like to hear about that, in the early stages, so you can comment on what is going to be done? Would you like to hear about it when the company thinks it's finished, so you can make some additional requests? What would be the best approach in your experience?
I will say, and Bobby, you can jump in, the earliest, the better. If we can be informed at the early stages, it will be preferable for us so that we can have input on what will the internal investigation would look like. Of course, it is something that came out of some sort of investigation and we only get the results. That's also a good starting point for us. It shows the cooperation from the company. I don't know, Bobby, if you have anything else to add to that?
No, I would agree. I mean, I think, Gustavo, in some senses, it touches on your point you made earlier about the fact that you can have a circumstance where national authorities may be interested in conduct and MDBs may be interested in conduct. Similarly, if an MDB investigative office is conducting an investigation, we want to know what happened, introducing an internal investigation conducted by the company can assist in that, but it doesn't mean that the MDB investigation would stop. What we'd be looking for, as Jose said, is have that investigation be done as part of an approach of cooperation, an approach of mutually wanting to understand what occurred and make sure that it's addressed if misconduct happened. And so the earlier that conversation happens, the more those types of coordination questions can be addressed. I think the better that is for everyone that's involved. We would want to know what was found at the end too, but working those pieces together and having those conversations, I think from our perspective is valuable and important, because every case is different. Even when I was mentioning earlier about the benefits of voluntary disclosures, each case is assessed on its own merits and on its own facts, and that's true for investigations as well. So the earlier, the more fulsome those conversations, the more cooperative those conversations, the more efficiently and effectively it works for everyone.
All right, quite clear. So let's look a bit at the dark side now. What are the usual mistakes that companies make, and how could they be avoided?
Well, I will start by, to understand the authority to investigate and review books and records, to have access to those records, to have access to communications, so to avoid any charge of obstruction. Keep in mind that it's an administrative procedure, and is handled following the policies of the MDB, and is, like we said so many times, not subject to local laws. And one common mistake that I hear is always, in case of law firms represent, well, my client didn't win the contract, so why are we being investigated? Well, anyone who submits a proposal, offer, or engages with an MDB for financing if subject to sanctions procedure. So even if the contract was not awarded, the fact that you voluntarily participated in an operation or a contract that is financed by an MDB, our offices have jurisdiction to investigate and sanction for any prohibited practice.
Well, that's a big note, right? So if someone missed that, make sure you watch it on YouTube later and take a good look at that point particularly, because just by participating, even if you were not awarded the contract, you are subject to these regulations we are discussing right now by MDBs. So, Bobby, we have discussed regulations, we have discussed investigations, we need more, right? There is a sanctions system, and there are, let's say, authorities at both of these banks that would particularly apply these regulations, penalties, and even the possibility to appeal against that initial decision. So, Bobby, can you please describe to us the basics of the sanctions system, please?
Sure thing. So this is another area where the MDBs tend to have fairly similar systems. They have a number of common features. The jurisdiction of these systems, companies, nonprofits, individuals, entities that are participating on our projects, these systems don't apply to our staff. We have separate systems for those that are inside the organizations, but they're different. And they don't apply to government officials. Now, there's some exceptions there if they're consultants or if they are a public official that might also have a business on the side. You could always address them in their capacity as running their business. But it's focused on the entities, as Jose was saying, and we've been discussing, that are participating in our projects from the private sector. The systems usually have multiple tiers. There's typically two. The first will be an evaluation office, or at the World Bank, it's the Office of Suspension and Debarment. And then the possibility of having a case contested up to a sanctions board or sanctions committee, depending on the MDB. The systems have independence. Those decisions about whether a sanction should be issued are not made by Jose's office or by my office. They are made by separate independent offices within our organizations. And at the contested level, so at the World Bank, the Sanctions Board, the members of that board are also independent of the bank. They are appointed to time-limited terms. They are prominent international arbitrators. We've had a few Supreme Court justices, and they're conducting a de novo review, fresh, of the case from the start. So that's how we ensure that independence. There's a good bit of due process. We also balance confidentiality. The case is confidential until it's decided, but then the sanction, if one is imposed, is public. There is a publicly listed sanction on a public debarment list. Each of the MDBs have them. And then there are also fully reasoned public decisions that are issued through these systems. We already mentioned there is the possibility of settlement. And then also there's the integrity compliance program component that we touched on as well. That's another common element of these systems.
All right, so you mentioned significant due process, right? So somehow we will have companies will have a chance to defend themselves, provide the any evidence that's available to them, and as you described, cooperate with the investigation and try to provide what they have to say. So we've been through the investigation, we've been through the process. What type of sanctions can be imposed?
Yep. Well, there are a number. The standard sanction that the MDBs could impose is what's called a debarment with conditional release. So what we're doing is we're using our procurement systems to fight corruption and promote integrity. So a company would become ineligible, or an individual would become ineligible to participate in a project that we finance or to receive a contract that we finance for a stated period of time. That's the debarment. Now, the condition release is they also would need to, in a settlement context, we talk about cooperation. On both sides, we talk about taking integrity compliance measures to improve their performance, improve their systems and controls. The goal is both to best protect our organizations, again, fulfilling that fiduciary duty by ensuring that when a company that is excluded comes back into the market of our contractors, that they aren't going to just repeat the same misconduct. But we also want to use that as an opportunity to promote compliance more broadly, kind of like what's being discussed at this conference. So we have an office at the World Bank, for example, the Integrity Compliance Office, that they're applying guidelines that address specific cases and they interact with sanctioned companies. But they also promote integrity compliance at events and outreach and trainings more broadly. And we try to combine those two things. That's the main sanction. There's also the possibility of a straight debarment with no conditions. It's uncommon. The conditional non-debarment I mentioned, where you have to fulfill those conditions but you remain eligible. And then there's the possibility of imposing financial restitution if we can quantify what the amount is. And at the lightest level, a public letter of reprimand, but those are fairly uncommon.
And what is cross-debarment?
Sure. So a group of 5 of the multilateral development banks that have harmonized all of their sanctionable practice definitions and have similar sanction systems will automatically apply each other's debarment decisions if those debarment decisions are for greater than a year and are for one of those harmonized practices. So concrete example, if you were to go to the World Bank's debarment website right now and look at what the first entity on the list is, it's an Italian company called Todini Costruzioni Generali SPA. INT, my office, did not investigate that. That is a cross-debarment of that firm from the Asian Development Bank, which investigated them and gave them a 6-year debarment for corruption. And that's why they wound up on our list. So that system's automatic, but it's worth noting that other organizations may choose on their own to apply in some fashion the debarment decisions of the MDBs. They are very impactful. So UN agencies, for example, may apply them in their own procurement systems. We've heard that there are some national laws in some countries or in portions of countries, states and provinces that will consider MDB sanctions decisions when making their procurement choices. And it gets caught by due diligence firms. One of the more entertaining phone calls I had once was with someone with a very heavy accent from the New York, New Jersey Port Authority, because they were considering contracting with an entity that we had sanctioned and they wanted to know what we could tell them about it. Obviously, they don't cross the bar with us, but the questions are asked, and it's worth knowing about taking these systems and investigations and potential consequences seriously.
So we're reaching the end of our panel. My final question for both of you is whether these MDB sanctions can be appealed with national courts in different countries.
No. The short answer.
That's a strong answer. Okay, you have a position there.
Yeah, well, for the reasons that Jose said, these are systems that are inside the organizations. The organizations have privileges and immunities under national and international law. And so the sanctions decisions and whether they are contested stay within the organizations.
All right. I'm wondering if companies may have had different views on that in the past. But on that note, we have reached the end of our panel. Thank you both. Bobby, Jose, you have been extremely clear about all of these topics, and this is truly valuable information for many of the companies watching on the other side of our broadcasting online. Thank you so much. We will be back in 1 minute for our next panel with compliance officers.
Thank you.
Thank you.
Good morning. It's a pleasure to have such a big audience today and also via streaming. So in this panel, we are going to talk not much about legal content, but rather a more practical view of what a compliance officer is like today in Argentina. So today we have Maria Archimbal, Chief Compliance Officer with YPF since 2021, Florencia Crespo, who is Head of Ethics and Compliance for Argentina and Uruguay at the brewery and malting company Quilmes since 2020. And so the challenge we have ahead is to see the differences that may come up when it comes to having the same or similar position in so different companies. For instance, Maria, as part of her professional background, she has experience in several public entities and state-owned companies, and she has always had some practice in the private sector. And Florencia comes from the financial sector and now works in the retail industry. So the idea is to have a rich discussion here with your experience. Florencia, from the financial sector, ever since you joined Quilmes, how has your role changed? What is the differential that you perceive from being in the financial or in the retail? So it's a pleasure. The role has improved and has changed, and it's regulated by the central bank and depends on the nature of each institution. Or, well, you work to give a response to the needs of the regulatory agency, mainly in relation to money laundering, anti-money laundering, sanctions, so on and so forth. So we focus on that. Now, in the sector where I currently work, which is more retail, which is not regulated or semi-regulated, things are absolutely different. So you have the possibility of setting the goals yourself as to the company's mission in terms of compliance. So, for instance, I have 3 big working groups in my scope. One is core compliance, related to codes of conduct, donations, internal investigations. Then we have antitrust and data privacy. So the good thing about these positions in unregulated or semi-regulated industries is that you have the possibility of managing many topics. There is no limit, so this is mainly the differentiating factor that you have in a regulated industry. Good. And you, Maria, face the challenge of being in an extractive industry, right? With a close contact and interaction with the public sector and a company that has a majority participation of the national state that trades in the stock exchange abroad. So it's a hard animal to tame, I would say. So what are your challenges with this distinctive aspect that YPF has? Good morning to everybody. Thank you, Marval, for this invitation to participate at today's summit. And as you said at the very beginning, Lore, it is a challenge, of course, but it's also fun. I find it entertaining in this complexity of the company. I have my background also and experience in the public sector, so there are some things that are easier for me because I was already on that side in the past, so I can see the whole picture. The company is a private company with a public securities that trade abroad, but the oil and sector gas is a highly regulated industry. So the engagement with the private sector and the public sector is close. It's an integrated company. You have downstream, midstream, and upstream with such a amplitude of business that make operations so varied. So maybe it encompasses a little bit of everything of the industry. So the challenge is permanent. And on top of that, the company is growing geographically. So in addition to the national regulatory framework, we also have lots of local regulations to apply. So the engagement with the public sector is very specific. And every province of the country has its own specificities and culture towards the public sector. So this is a challenge, but a fun one. In terms of companies like YPF, you can also find people who say this belongs to private law. Then you have a specific court ruling, or you have a certain prosecutor's office recommendations and resolutions. So exactly. It's very varied, and that also applies to the officials of the company per se. Are these politically exposed people? Are these public officials? The let's say the people at the company. So that makes it very interesting indeed. There are many international strategic partners that consider us a national oil company and an OC. So we have that category as well. Aspects that must be taken into account. The definition of bribe as well, according to each and every aspect. So we need to take advantage of the fact that we are all women here at this panel. So let's talk about the specific challenges that you've had along your careers for being women. The fact of being a woman and facing and being part of very masculine sectors. I imagine that traditionally in the financial sector, we've seen that it is considered a very much male-dominated sector, right? And also in the extractive industry, you need to interact with trade unions, plant workers. So, Flor, can you share your experience? Yes, I believe that everything that is related to gender today has really made progress. It's not the same as 20 years ago. Of course, there is a bias still in place. It's also expressed as a positive discrimination in the sense that, let me tell you the following, and I am sorry that you are a woman, so on and so forth. That happens a lot. So when we conduct investigations and the like, it's been useful, the fact of being a woman, to lower down tensions, those types of things. Some colleagues tell you, I was at a meeting yesterday and I was invited to solve this problem in the corner of the street. So for being a woman, those things don't usually happen, and that is a good thing. Of course, we should all behave the same way, no matter the gender. And another thing that we mentioned before, maybe not related to gender, but a constant challenge, which is the generational issue. Companies today have baby boomers together with millennials, Generation X and Z. So that is also a challenge, right? When you start talking about certain things, some people grasp faster than others, or a baby boomer comes and tells you, I have always told the fatty guy fat, and how do you tell me that that hurts his feelings? I mean, those things are very challenging today. Yes, and I share what you said. Sometimes in difficult situations, you either have to go to talk to the director of a company or you need to participate in an investigation, and maybe you interview people about uncomfortable matters. So if the person on the other side is a man, is like the man takes it less seriously, I would say, so he may be relaxed, and that is an advantage of being a woman probably in this type of roles. And Maria, what about your experience in the sector? Well, honestly, I have not had specific experiences that maybe challenged my professionalism. Of course, there are gender issues and the energy sector is male dominated all over the world. 22% of women, and here in Argentina it goes down to 18%, not to speak about women in leadership positions. So there is a gender bias. YPF, among its company corporate values, values gender equality and diversity. So it really works hard and trying to raise awareness about gender issues. There is a subcommittee of domestic violence. And by the way, this thing that Flor said, the gaps, the generational gaps that exist, not just in terms of gender, but also, and I go back to the public sphere, when people tell you this is the way it used to be done, this is the way we used to do it. We need to break down those barriers related to generations, gender, and many topics that are part of today's agenda to sort of break down those tight structures. And being a woman, in one way or other, helps lay those bridges or open up certain conversations that are hard. Sorry that I mentioned Flor so much, but she said it very well. It's the same language among teams, using these adjectives, these qualifiers. Hey, fatty boy, but I'm telling this in a nice, kind manner. But if the person feels bad when you say fat or fatty boy, I mean, it's something that we need to respect. But today, at least, the good thing is that we open up the dialogue. There are many more parts which are really important to consider. And the effectiveness of your role also has to do with understanding these new dynamics. Yes, and the new generations are also very helpful in that, right? The youth, their mindset is bigger, is wider, and they are asking for more. So that ends up benefiting everybody. Young people force us to rethink certain biases of certain things that, I mean, they dare ask questions. They do it without any issues. Maybe we were shy. We wouldn't challenge people in the past, right? We wouldn't speak up. Yes, and that's true. Young people serve as a good catalyst to start thinking in a different way for everybody. Good. And in your current positions, Maria, you've been in that position for 2 years, Flor for 3 years. How do you think your role has changed from the moment you started to the present? You can also share with us how your story has been in compliance, but well, yes, I'll go a little bit back because this morning, by the way, we were discussing with Delia about the evolution of compliance per se. At the very beginning, it seemed to be a position only to work in anti-corruption cases, in regulated industries to give an answer to regulators. However, today it has assumed different forms, and in LATAM and in Argentina in particular, it has gone forward a lot. Today, compliance officers today share tables that where we were not in the past, and that is a great point of progress. Today, any M&A operation would never exclude finance. So why would we exclude compliance from an M&A operation? And Gustavo said it at the very beginning, this overlap with legal or other areas, and I talk and I speak with colleagues who tell me, so you are from the audit area, right? No, I am not from audit, and I need to explain, but we need to be patient and explain and describe what we truly do, because compliance deserves its place, and I think that we are on the right track. Yes, I imagine that in the past, what used to be your position, I mean, was more limited. Yes, there is no limit today. Because compliance crosses every sector of the organization, so you don't have a limit to work. Your scope is so big. It will depend on each organization where compliance gets to. And if you don't have, of course, antitrust specialties, maybe it's not so necessary to have a specific compliance area in that regard. Good. And Maria? Well, I'll go back also in time. I worked in accountability, corporate governance, in internal supervision, and those areas. I was part of the board from 2012 to 2016. So when I joined the company again in 2020, I joined compliance. And let me share with you first a little bit about my career, because when I joined the compliance team, as any new team, you start, well, getting used to the dynamics and all that. And I remember that I said, this is so cool, but if from now to 1 year's time I was not able to grow in the organization, I don't think this is my place. Fortunately, 8 months later, fortunately, the possibility of becoming compliance officer appeared, and the first thing we did with my team after the board appointed me, we got together and we said, okay, what do we do now? Because the YPF compliance area was very new. In 2018, we had a code, several policies that made the program quite robust, but we had to go one step further. The board told me, why don't you become business partners? And I said, what is that? We got together with the team and we defined how we wanted the area to be for the future. And I remember the answer was unanimous. They said, we want to add value to the company. And I said, oh my God, this is a huge challenge. So as of then, we started rethinking about the program. And as she said also, in the past, compliance was just anti-corruption, but today you have ESG, good governance issues, compliance in relation to analyzing companies, not just in terms of profit or transparency, but the impact that the company has on the communities and the environment where they operate. So our integrity programs expanded. I am also part of the diversity committee. There's also a committee on domestic violence. Last year, together with the energy transition area, we combined our human rights policies. There's also a policy on a harassment-free workplace. So all those agendas of compliance that only focus on bribes and corruption now has become an area of expansion. And we work together with human resources, with ESG, and that is very, very rich. For what you are saying, I have the feeling that in addition to technical knowledge and commitment to the work, it's also very important in your roles to have soft skills, right? So have this plus in your profiles, not just be effective, be efficient, but have certain personal competencies and qualities, right? To be able to open up your minds and change certain biases. So what are the key qualities for a compliance officer to have? Well, the soft skills are key, absolutely key. I agree with that. And they are very helpful in certain aspects. In investigations, they are very important. It's not easy to sit down with a person and tell the person, I have a report against you. What can you tell me about it? I mean, this dialogue that you can manage, not everybody reacts the same way. Some people cry, some people react in a very bad manner. So you as a person need to be able to contain those situations. So again, going back to the skills or qualities for a compliance officer to have, one should be passion for what we do, because this is a profession that is developing right now. So if we don't take it seriously and passionately, then we won't enjoy it. And second, we need to be resilient, because sometimes you face this issue of you from audit area. No, I do not belong to the audit area. Nobody likes people to confuse their work. So I think that you need to, yes, evangelize perhaps what we do, about what we do. So resiliency is very important, and keep on working hard so that our role becomes and gets more and more relevant. And sometimes, someday, we will be at the level of what we see in the US or in Europe, even though it's not perfect.
There I cannot be really objective because I am also an ontological coach, so I actually pay a lot of attention to soft skills. And I think that aside of resilience that Flor mentioned, as a compliance officer, we need to, within the organization, we need to develop that confidence and trust for them to approach us, to work together and embark on projects. Because if we need to investigate, we really want to be on a preventative type of work. In order to build that trust, to build that rapport with the internal areas of the business, I believe that soft skills are super important for them not to see us as someone who will be hindering all of the processes, but rather that someone will be help. In my case, it is an oil and gas company, so compliance needs to be an area of service, and the first client that I will have is the internal client for me to really conduct a transparent, ethical type of work. And in this case, the fact of myself being a coach also helps me because I want to leverage the team on an ongoing basis. What may happen with compliance is that if you do not conduct something along the side of out-of-the-box methodologies, it may be a little bit boring. So you need to identify each member in the team, what's their potential. A system for them to develop that potential is super important within the company. So one of the soft skills needs to go on the internal side of the team, the other one external. But they are super important for me. Okay, we're left with a few seconds or minutes. So what's a piece of advice? And it's very briefly, 2 words. What's your advice for someone who wants to become a compliance officer in the company? I'd say that they should be permanently challenged to get the best out of themselves, because you spend a lot of time at the office, and if you do not really have fun with what you do, then it's very difficult. Yes, and also take up on the possibilities that this profession sets forth, or compliance in general, which is that, as Maria said, think out of the box, try to be a strategic partner for the business, bring about 5, 6 proposals that will keep you constantly challenged, and that's great. And not all professions allow for this. I was really, really glad to listen to you. I congratulate you and commend you on your wonderful work and tasks. It's wonderful to have professionals here at Marval that are of such a good caliber and so good as representatives of the gender. Thank you so, so much. Now it's time for a coffee break, so if you want to take a rest, stretch your legs, it's time to do that.
Hi, Gil. How are you?
Very well, thank you.
How are you enjoying the conference? Are you liking the panels we've had so far?
Well, first of all, it's fantastic to be back in Buenos Aires. It's been quite a while, I have to say. And it's incredibly impressive how the conference actually is. We're just having a chat here. I think I participated in the first 2 conferences when it was just still it wasn't streamed and significantly less people. It's evolved tremendously since then. And the topics, of course, have evolved as well. So great to be here and great to be participating as well as a speaker.
Okay, amazing. We are so glad to have you here. And I just found out that he was here in one of the first events, in one of the first conferences. So that's a great deal for us to have you here and to have you see the evolution of our conference. We've got new topics, new speakers every year. Is there any particular topic you would like to see discussed? Any particular panel or speaker you would like? You are expecting to see?
Well, I mean, as every year, I think the topics are incredibly well put together. I think just picking on some of the things in Gustavo's opening, actually. 2 things. So how broad the compliance discussions become. So, when I first spoke here, the focus was almost exclusively, at least the biggest interest was on the anti-corruption front. Now we obviously have trade sanctions, we have data privacy issues, and it's just become a much broader conversation generally. And the second one, and Gustavo picked up on that as well, and I think it's something which is going to change very rapidly going forward, is deployment, use of technology in investigations, compliance, and the like. So I'm super keen to hear what everyone has to say about these things. There are already quite a lot of good things shared with us, and we'll touch on some of these things in our panel as well.
One of our objectives in this conference is to try to find an international dialogue, to broaden our dialogue internationally. Do you think that happens here, and do you think that may enrich our form of work?
Well, 82 countries represented, apparently, right, amongst the audience. So absolutely, and I think it's actually also one of the evolution in compliance. Compliance is by nature very transnational. International regulations apply, and as a result, I think it's almost impossible to have a conversation around compliance without talking about globalization and international sphere. And I think you've done a great job capturing that here through speakers, audience, and also the topics.
Great, thank you. And what would you say are the main challenges that compliance officers or people working in the compliance area may face in the future, in the current future?
One of them most certainly is how to deploy. There's a lot of hype around artificial intelligence and these technologies, so how that will effectively be deployed, because it's not easy and it's not cheap. And the second one, I think, is a little bit more mundane, but a very real one, is, not every country in the world, not every economy in the world is performing particularly well. There are tremendous budget pressures, and we've seen many compliance teams in many different countries have to do more with less resources. So I think that will continue to be a challenge going forward.
And what would you recommend to face these challenges in the future?
Well, actually, the 2 points are sort of interrelated. There is quite a lot of productivity gain that can be reached. Obviously, these are longer-term investments, but using technology, I think that's probably the most important recommendation. The other is that's already always been part of the compliance story, but is really, really focused on risk-based approaches. So understanding the risk landscape well and designing your compliance program around, tailoring them around very specific risks as opposed to try to capture everything.
Well, we look forward to hearing you in your panel. I think that's in the 2:45. Okay, so I mean, stay tuned to listen to Geert Albers at 2:45. His panel must be very interesting because our conversation has been so far. So please enjoy the conference.
Thanks very much.
Thank you. Ok. Bueno, hemos llegado entonces a la final de la conversación con Geert Albers. Te agradecemos muchísimo. La verdad que los paneles vienen siendo realmente interesantes y es muy interesante la cantidad de personas que tenemos acá presencialmente en el auditorio. Tenemos paneles muy interesantes en lo que viene de la conferencia. Tenemos además un QR que van a encontrar en la pantalla de vez en cuando. Van a ver que aparece en la pantalla en los tags de la gente. Hola, ¿qué tal?
Rosario,
¿qué tal? Me encuentro acá con Roberto Silva, socio de Marval Farrell Mayral. ¿Qué tal, Roberto? ¿Cómo estás?
Bien, bien, bien. Acá
¿Cómo viene la conferencia?
Bien, disfrutando de este evento que la verdad que es de una categoría increíble. La verdad que es un evento buenísimo. Larguísimo también porque es todo el día, así que hay que felicitarlo a Gustavo no solo por la organización, sino por la estamina para estar todo el día presente con pilas y con energía en un evento que de vuelta es de una categoría increíble.
Este ya es el 6º evento del tipo que tenemos en Marval. ¿Cómo viste la evolución? ¿Qué crees que significa esto para Marval?
A ver, hoy justo coincide con nuestros 100 años, digamos, pero creo que han sido todos de primer nivel. No me animo a decir que cada uno es mejor porque todos los anteriores han sido realmente extraordinarios.
Y la verdad que también es impresionante la cantidad de gente que tenemos conectada mirándonos, la cantidad de personas que tenemos acá en el auditorio, que la gente no la puede ver, pero la verdad que es impresionante la convocatoria que hemos tenido. ¿Qué significa esto para Marval, para las relaciones? Generamos un buen networking en estos espacios, que es el objetivo principal de los espacios así de comida y de recreo.
Mira, doy fe de ambos porque ahora estoy acá presencial, pero hay una parte que la seguí virtual, así que efectivamente había muchísima gente conectada. Y sí, sin duda es un gran evento, además de su contenido, es un gran evento de networking, sin duda alguna.
¿Hay algún panel en específico, algún tema, algo que estás esperando con ansias escuchar?
No, algunos por mi actividad me interesan más que otros, pero todos son muy interesantes.
Y algo que puedas destacar de los paneles que ya hemos escuchado, si bien fueron 2 o 3 nomás, porque recién estamos empezando el evento largo, como bien dijiste, algo para destacar de lo que viene sucediendo.
No, me divertí con la anécdota del funcionario en Centroamérica que atendía en el shopping. Pero bueno, un poco en este último panel, el cambio de circunstancias de que al gordo no se le decía más gordo, es una cosa que a los que tenemos más años hay que acostumbrarnos porque es la nueva normalidad.
Sí, la nueva normalidad que la verdad que creo que la venimos llevando bastante bien, por lo menos desde acá. Así que bueno, te agradezco muchísimo, espero que disfrutes lo que viene, lo que sigue del evento. Y bueno, estamos acá para seguir conversando, ¿no?
Bueno, perfecto, muchas gracias y felicitaciones no solo a los que participan, sino a la organización.
Muchas gracias, que disfrute, por favor. Bueno, ahora se acerca conmigo Lorena Schiariti, que también es speaker del evento y socia de Marval. Hola Lorena, ¿qué tal? ¿Cómo estás? Lorena fue moderadora y speaker participando en el último panel que tuvimos hoy. ¿Cómo salió?
Bueno, para mi gusto salió muy bien. La verdad que estábamos, las tres ya nos conocíamos y me parece que lo que queríamos hacer, que era una charla relajada, contar un poco más de adentro, más allá de lo técnico, bueno, qué otras cosas tiene que tener un compliance officer, cómo está evolucionando el rol, cómo se siente ser un compliance officer. Eso era lo que queríamos transmitir y me parece que salió muy bien. Las speakers, la verdad que son las dos muy buenas, tienen mucha trayectoria, son muy profesionales, así que, y la verdad y también aprovechamos porque de casualidad se dio que el panel estaba compuesto por 3 mujeres, entonces, bueno, también ver qué desafíos o qué puede sumar como diferencial una mujer desde la empatía, desde bajar tensiones, así que bueno, nos pareció que salió bien.
Sí, la verdad que estuvo muy bueno el panel, muy dinámico, llevadero también, muy interesante el panel. Además, se dio la casualidad de que las dos speakers, si bien participan del mismo área, trabajan con distintas dinámicas, trabajan con distintos aspectos, digamos, de la industria. Eso es un poco lo que tratamos de hacer, como bien sabés, en este tipo de eventos, tratar de por ahí que el diálogo se amplíe un poco más, no sea siempre tan generalizado, sino para ir a puntos específicos. ¿Crees que eso se ha logrado en el panel y específicamente también en estos coffee breaks, por ejemplo?
Sí, la verdad es que me parece que sí, llegamos a completar ese doble objetivo de que, digamos, todo lo que es el conocimiento puro y duro de compliance y los principios que lo rigen y, digamos, los do's y don'ts de la actividad es como algo ya muy sabido, pero bueno, el lado B, digamos, el cómo se ve desde adentro de las compañías, la verdad es que nos parece que suma y más que nada en compañías tan distintas, ¿no? Tenés una compañía como Cervecería de Materia Quilmes, que es una industria no regulada, pero que hoy tiene un montón de restricciones en todo lo que es precios y tiene un montón de control del Estado, digamos, por normas generales. Y después tenés una empresa como YPF que tiene una industria que ya es de las industrias que en compliance se llaman como más riesgosas, digamos, porque hay mucha interacción con el sector público y además, bueno, YPF, esta doble naturaleza de ser una empresa privada, pero que tiene en cierta forma, o por lo menos la jurisprudencia, la procuración, le da un matiz más orientado a lo público. Entonces, bueno, son desafíos y cuestiones que todos los días, digamos, enfrentan nuevas visiones y nuevas oportunidades. Así que bueno, me parece que espero que la gente lo haya disfrutado. Nosotros quedamos muy contentos.
La verdad que sí, esperamos que lo haya disfrutado la gente, además lo pueden volver a ver en YouTube si quieren, va a quedar ahí. La verdad que un panel muy interesante. Y ahora volviendo un poco a Marval, a nosotros, que ya que sos parte de Marval, este es el 6º evento que tenemos de este tipo, la verdad que vemos que viene creciendo impresionantemente, cada vez tenemos más convocatoria, 83 países conectados ahora. ¿Cómo lo sentís como marvaliana y cómo lo ves evolucionar, digamos?
Bueno, la verdad es que orgullosa siempre de poder ayudar en este evento y participar. Siempre es un placer ver la sala, todo el lugar lleno de gente y que todas son gentes conocidas, digamos, todas caras conocidas. Es como que se genera una comunidad de intereses comunes. Y nos encanta que Marval sea la casa para este tipo de eventos, que Marval sea el lugar donde puedan venir los clientes y nuestros colegas, amigos de Argentina y del exterior a sentirse cómodos, a tomarse un día para repensar algunas cuestiones. Y bueno, más que nada en este año que estamos festejando nuestros 100 años en Marval, así que la verdad, una fiesta. Muchas gracias.
La verdad que muy interesante todo. Todos la estamos pasando bárbaro, es el 6º evento y creo que cada vez la producción, los temas, los speakers siguen evolucionando, siguen creciendo, tenemos cada vez más convocatoria, así que asumo que vamos a seguir por ese camino. Gustavo también, impresionante cómo viene generando todo. Te hemos tenido también como speaker en otros paneles.
Hoy me queda un panel hoy a la tarde.
Claro.
También.
Así que te tenemos realmente presente en los paneles y en el evento en general. ¿Hay algún otro speaker que estés esperando escuchar? ¿Algún tema en particular que te gustaría que se trate?
Bueno, la verdad es que todos los paneles están compuestos por digamos, autoridades, digamos, cada uno en su materia. Me interesa mucho escuchar la visión de los otros estudios que trabajan en estos temas, la visión internacional de los estudios, obviamente porque son nuestros pares y sabemos que, bueno, Inglaterra, Estados Unidos, digamos, son países en los que vienen trabajando en los temas de compliance hace muchos más años que nosotros. Entonces, bueno, tenemos un montón de cuestiones para aprender, camino por recorrer, pero bueno, mejor si lo podemos hacer aprovechando la experiencia previa, ¿no?, de los otros estudios.
Bueno, es un poco la idea, entonces, enriquecernos del diálogo entre todos. La verdad que creo que lo estamos logrando nuevamente. Y tuvimos paneles muy interesantes a la mañana, además del tuyo, si bien muy poquititos. ¿Algún tema destacado que te gustaría que se siga tratando, que te gustó que se tratara?
Bueno, la verdad es que siempre es un placer escuchar a Delia Ferreira Rubio, digamos, sus anécdotas, su visión, digamos, está en una posición clave que te da una visión global, te ubica en lo que está pasando hoy en el mundo, que bueno, es un placer, es como muy difícil de reemplazar esa visión y ese input.
Delia ya ha estado también en otros eventos, la verdad que es un placer siempre tenerla y lo que trae siempre a la mesa es realmente interesante y sobre todo innovador, me parece que por lo menos lo que siempre conversas de un lado muy innovador. Habla mucho sobre los enfrentamientos que tiene, sobre los desafíos que se vienen en el futuro y cómo el futuro en realidad ya está presente y nosotros venimos un poco detrás. ¿Qué desafíos sentís que podemos enfrentar quizás en el futuro en la práctica? ¿Qué desafíos sentís que por ahí no estamos viendo o que claramente lo estamos viendo y nos va a costar enfrentar?
Bueno, la verdad es que en Argentina hay muchas cosas por hacer, digamos, hay cuestiones legislativas para modificar, pero que
Hello, we are back for our next panel. This one is on how to properly react to cyber attacks. So for the panel, we have Diego Fernandez. He's a partner at Marval. He leads our IT law department. And we have two remote speakers connecting from the US. They are Victoria Beckman, Associate General Counsel at Shopify, and Jeffrey Collins, Supervisory Special Agent at the FBI Cyber Task Force. Victoria, Jeff, thank you so much for joining us. Just initially checking whether you can hear us well. Everything looks good on the other side. If you can say yes.
At least.
Yes.
Okay,
Yes,
good.
sounds great.
Good. So, okay, how to properly react to cyber attacks. I mean, both Diego and I have been lucky enough to work together in a number of cases so far. The type of cyber attacks that our clients face has been increasing, and they are getting more and more complex every day. But no matter how many cases we have participated in, I'm sure that you, Jeff, have dealt with many more. So it would be fantastic if we can kick off the panel by hearing from you, considering your extensive experience at the FBI Cyber Task Force, on how frequent cyber attacks have become and how complex they expect to keep getting in the near future.
Sure. Thank you for having me today. It's a pleasure to be with you all. I'm glad to share some experiences I've had in my career with the FBI. I've been an FBI agent for almost 15 years and have been investigating cybercrime the entire time. And so I've seen the evolution of tactics that the attackers are using. And to me, it seems like staggering losses. The amount of loss just keeps rising per incident. It very much affects a company's brand and image when they're subject to a cyber attack. That really the best tracking mechanism I think we have in the FBI is our website, the Internet Crime Complaint Center, where we direct the public to ask the public to file complaints whenever they see suspicious behavior or cyber attacks. And each year that Internet Crime Complaint Center releases an annual report. And they just released the report for 2022, and it shows the most frequent attacks, the amount of loss on average per attack, and sort of the trends that we can see over time. And just last year alone, for our website that we use, and I understand that not everyone in the world would put their complaints there, but I think it's a good indicator. There were over 800,000 complaints totaling $10.3 billion in loss. So in just 1 year, over $10 billion in loss. So pretty significant to see the amount of loss. The only other thing I would say is going forward, I just expect to see a more technical sophistication, very much targeted at an individual company where the attackers will do their research, and plan the attack just right so that they can, ask the highest amount of a payment in a ransomware example. They would, ask the victim for a staggering amount of money to be paid for a ransom. So I only see that increasing. I hope that answers your question.
Yes, absolutely. Actually, we especially made it the purpose of this panel to have a very short introduction on the different types of attacks and the statistics, because we can go on for hours on that side, right? The types of attacks have evolved. They may involve humans, they may not involve humans, they may involve tricking somebody, they may involve stealing some information, whatever. There is a lot to be read out there, online. There are many reports by the FBI, for example, and other organizations, so I encourage you all to take a look at that. But let's jump directly into a scenario where our company has been attacked. 5 minutes ago, right? So we are lucky enough because we have our associate general counsel. So that's Victoria, right? And suddenly somebody turns to Victoria and says, Victoria, you are the general counsel, you have experience, you have the power within the company. What should we do? Okay? What are the initial reactions, Victoria? We'd love to hear from you. We know you have vast experience, not only with Shopify, but with previous positions in the tech industry before in your career. What are the initial reactions that companies make, quickly upon learning that they are under attack? And what are the common mistakes that they make, and how may these mistakes be avoided? At least a few of them.
Well, thank you, and thanks for the invitation to be here today. Yes, regardless of whether a company is big or small and has a huge plan or not, normally there is chaos in the beginning, and there's confusion, there's some panic, because in the beginning of an attack, you don't have all the information. You don't know what's going on. You don't know what has been compromised. You don't know the consequences. Sometimes you don't have service or you can't provide information and service. So you have customers complaining. So preparation is key. And the lack of preparation is what ends up in committing the most common mistakes. Sometimes even having a plan, a lot of companies or a lot of employees within the company don't know how it works. So you may have a beautiful plan, a beautiful written plan, and people don't know how to report, who to report, how to escalate. So the most common mistakes that we see is lack of controlling the message internally and externally, which means internally only letting people who need to know about the incident, using the correct language. For example, in the United States, a data breach is a definition, and in actually most legislatures, so it's a legal conclusion. And when you receive an email from somebody saying, we just were breached, we had a data breach, if that later gets discovered or gets produced in a lawsuit, that's a conclusion that you don't get to that until you have analyzed. But then there's the email that says data breach. There's also kind of a rush to try to communicate what's going on, to provide service to customers and let them know what's going on. And again, in the beginning, you don't have all the information. And just kind of like in the movies, whatever you say may be used against you in a court of law. Whatever you're saying or statements that you're producing as a company are public statements that later are going to come to hunt you if you don't think about them properly. And so if you rush to give a message out and say, oh, well, only 100 records were affected, but in reality was 2,000 records, and then you have to switch and then say, well, no, this didn't happen, or we didn't do this, then that's going to create more confusion and also ultimately could create or trigger some legal liabilities. Also, it could also happen that there is a late notification. So trying to get all the facts of the investigation, then not reporting on time, not going to the FBI or going to authorities that can actually help you could also work against you. We have seen examples. Most recently, we saw Uber and their failure to disclose a data breach for about a year. And then again, having counsel or having someone who knows what to look for, the legal consequences that you have to, what the steps that you should do, you need to mitigate, you need to document what you did to mitigate. Those kinds of things are what we see on a daily basis.
Absolutely, that's a clear description, right? I like how you raise the issue of anticipating how what you're doing right there in the initial moments after the attack, those initial steps will be used, months into the future. Like you said, it will come back and haunt you, exactly. And we've dealt with these situations, Diego, a number of times. What can you add to Victoria's comments on those initial reactions by companies? I mean, it's chaos, right? I mean, everybody's running away. A lot of people are asking a lot of questions, right? So let's share with the audience what we have seen in a few cases.
So sure, yeah. I will complement what Victoria was saying. I agree with most of what you said, Victoria. I will start saying that probably the first thing that we see and this is based on the experience we have. There might be other experiences, so that's like a caveat I would like to say. You normally see that sometimes because there's no knowledge about how a data breach works or what it is, they're not taken seriously enough. And I don't mean that every data breach or every security incident is material to the company or the organization, but you need to have some way to analyze and make sure that you are not disregarding very quickly something that could be potentially very harmful for the company. And that takes me to what Victoria was saying, and we saw that Gustavo many times. And I will not be able to stress enough how important to have a plan is. And the plan is everything, in my opinion. You can't start analyzing what to do when you are hit. You need to do that before. You need to do it preventively, like having measures to avoid the attack. And of course, if you're not lucky enough, how to respond to that. And we have seen many times that many companies, large, medium, small, they don't have a plan. They don't know what to do. Sometimes because we come from, in this case, Latin America, I would say, the development of this, you were saying at the beginning, in the opening, Gustavo, compliance has been evolving over years. Mm-hmm. I think cyber is evolving too, and we are not there yet in many of our countries. So it is not that the company don't want to do what they should be doing, it's that they don't know what to do because there's no knowledge. The other thing is, even companies that have a plan, as Victoria was saying, it is very important, I would say is the most important part, that you spend all the time that you need, all the resources in building the plan that is perfect for your organization. Every organization is different. And once you spend a lot of time building that program, I can't understand why you would just depart from the plan when chaos comes. And we have seen that many times. People get creative because they are very, you have legal, and you can see that in every company. You have legal from one side, but then you have the business. The business is very worried. The clients are going to maybe go, and they start doing creative things that are not what the plan said. And Victoria was saying training is very important. So you need to have a plan. You need to train the company on that plan. You need to review that plan every year, maybe twice a year, and train the company to know what to do. On top of that, and not because we are a lot of lawyers here, you need to have, if you are hit, you need external counsel to help you with. It's okay to have, of course, in-house counsel, but you will need vendors, you will need IT providers. That plan should have in advance know what you do, who you will work with. If you have an IT vendor that will help you, for example, with forensics, you need to know that in advance. You can't start negotiating the IT vendor agreement when you are hit. That's my experience. And to sum up a little bit, Gustavo, what you were saying, communication is vital. So everybody, Victoria was saying, this is chaos. Everybody wants to say something. Everybody wants to ask, are we okay now? Are we okay? We don't know. We just started digging a little, and then later we can talk about the investigation, but we just started to know what's going on. We don't know what's going on. Don't make sure that communications, you have a leader who is the one saying what's coming in and what's coming out of the organization when you're hit, because many times, as Victoria was saying also, what you say, and you don't want to say something that is going to be used against you in the future, it is as important as the investigation.
Absolutely. I mean, we can go on comments on the initial steps of the reaction, like for hours. I would only add a couple. Make sure you're not relying exclusively on common sense. Okay? Common sense may help sometimes. Most likely this will not be the case. A cyber attack will put the company usually under a lot of stress, and as Victoria was describing, many legal consequences will arise from there. As Diego said, commercial consequences will arise from the way you handle the cyber attack itself and the type of communications you make. So be very, very careful not to be acting on the basis of common sense. Make sure you reach out to someone who has the experience and the know-how on how to deal with this to make it, let's say, a less complex situation for the company. Because handled the wrong way, you may certainly increase the danger and the negative consequences for the company. That being said, Jeff, one of the questions that always comes to mind, sooner rather than later, is whether enforcement authorities should be involved. So in your case, we are talking about the FBI, and we know that thinking about reaching out to the FBI happens not only in US-related cases, but also in cases occurring abroad because of the leading position that the FBI has in investigating cybercrime. So when would you say it's a good idea for companies suffering a cyber attack to reach out to the FBI, and why?
Thanks. I think that's a great question, because a lot of companies, maybe they suffer a breach and they don't want to tell anyone. They want to keep it inside, and hopefully they can deal with it on their own and have it not affect the company and their image. And I would say that's a mistake. That companies should, as soon as they're victimized in a cyber attack, they should reach out to law enforcement, whether that be local law enforcement in your own country, or the FBI. And the reason I say that, there's a couple reasons. One, oftentimes when we respond to a cyber attack and show up at a company to try and help, we find that the IT staff has made changes to the environment and maybe inadvertently destroyed evidence or log files, and or the attackers have had time to clean up their tracks and remove evidence of what they've done on those systems. So having the FBI or law enforcement show up to a company as soon as possible gives the company the opportunity to preserve evidence, and lets law enforcement give them some guidance on how to quickly recover from this. And so I think it's very critical that victims reach out to law enforcement as soon as possible. The FBI has FBI agents in embassies all over the world, and really that's not because we have any sort of authority in that country to act or investigate, but as guests in that country, and we work in a liaison capacity. So I personally had the opportunity to work in Japan for 3 years, and so I am able to help as an FBI agent with Japanese law enforcement and help in cyber cases, because these cases are so global. The actors are rarely just down the street that are causing this, but they're in another country, so we have to rely on those international relationships and cooperation.
Thank you, Jeff. So, Diego, we are discussing the initial steps of the reaction. We are evaluating whether to reach out to the FBI, whether we have a plan that was prepared beforehand, and we know the protocol to follow. But in any case, let's assume the case went public for any reason. For example, the hackers decided to make it public. Right? They announced it on Twitter or Telegram or whatever that they have hacked our company. This happens all the time, right? And they release some information there. that was seized from our servers. So more likely than not, our clients will start asking questions, right? And as many questions as they can dream of, right? So what can be done to properly address those questions on top of all of the concerns that we have described so far?
Well, that's a good question. And as you said, it happens all the time. Clients will want to know primarily if the data is involved and if there's any data there, whether it's their data or even the data of their clients that you are in charge of. So the basic question to that, Gustavo, is you need to start as soon as possible an internal investigation. Normally, it would be what is called a forensic investigation. You need someone who really knows how to do it and what to do. And my view, based again on the experience of the different cases we had, is that you need the point one is make sure that you control the communication. You are the one, the organization, the company is the one that has to make the narrative, and you want to make sure that you know what you want to do and who you want to share that with. And so you start an investigation, you kind of control, because we have seen when there's an incident, and depending on the security incident, let's assume that the incident it's material enough, and many clients are unhappy, to put it some way, and unhappy, and they are saying that they might move their business to another company.
Yeah.
And so what would you do if you are the one in charge of that client's account? You want to make sure the client is happy somehow, and they keep doing business with you. So you will start talking to them, and we have seen this with Gustavo many times. While you are making sure that you put everything together in the investigation and you control the narrative, you start to listen that commercial people are talking to the client. Why? What did you say to them? No, I just say that next week we are having a report, the forensic report.
Yeah. Explaining everything.
Yeah,
right?
like
what happened,
full
how
report.
we fixed it. Yeah.
You haven't even hired the company to do the report, and so it's like funny, but it's not, because you start getting a lot of expectations on your clients, and it is not now that the client is unhappy because you are hit with an attack. Now it's unhappy because you said you will have a report in a week, and you don't have it. You haven't even started the report. You don't know if you are having a report. I always remember Gustavo saying that one of the most complex cases of compliance around the world didn't have a report. Of course, there was an investigation. There was a report? No. They decided that it was worth not having a report. There were conversations, there were video conference, and etc., but no report. So make sure that you control that. The other thing that I think is very important, and again, it's not about being defensive with all the lawyers that we are here, it is important that Delia was talking at the beginning about the privilege. You know that we have this relationship with the clients that has the privilege, so you have a right not to share certain information because it's privileged. A good way to do that on an investigation is to hire the investigators through your outside counsel. So you structure the relationship with an outside counsel. Outside counsel hires the investigator. And so you try to protect as much as possible the results of the report. The report could be very ugly. The report could say that you missed everything that you have to do and that you were not diligent. It was not just that the attackers were really good. It was like you left the door open. And you don't want to have that in a report that can be, the regulator can ask for the report and you have to file it. So that's the other point that we normally see, Gustavo, that I think is very important. Another thing is, and this is maybe counterintuitive, like try not to share less is more here. Normally you know little or nothing during the first weeks of the investigation. It is very common that the investigation starts with there was no personal data and there was a lot of personal data. There's no IP of a client and there's IP that you have holding on a client. There's no material that we have an obligation of confidentiality with, and there's a lot of confidential information there. So it is, again, going back to the communication side, make sure that, and you have that on the plan, make sure that you control what you say, and normally there will be a lot of push from the different parts of the organization, but I think that is part of how to react a little bit when the clients start asking the questions.
Exactly. It's about being mindful of the level of uncertainty you are dealing with, right? So there is a lot you don't know. So why would you be, giving explanations to try to cover up for what you don't know? I mean, the right way is to conduct the internal investigation, find out what is possible to find out, right? Get evidence to support that, and upon those facts, make reasonable decisions to deal with the situation, decisions that meet the duty of care, right? So whomever is dealing with the result, the consequences of the cyber attack, won't put himself or herself in a situation where in the future questions will be asked on why a certain decision was made, and no grounds for those decisions will be available. So the internal investigation should be the way to go to clarify that uncertainty. So that being said, okay, we discussed, should we call the FBI? Should we initiate the internal investigations? Are we getting lawyers involved? But suddenly we get a request from the hacker, okay? So they are asking for a ransom payment. What should we do, Victoria? What are the elements to consider when evaluating whether paying ransom is a good idea or whether it's the worst we can do?
Well, first I have to say, because it's a room full of attorneys, as Diego mentioned, that this is not my employer's opinion. This is just my personal opinion, and I'm not providing any legal advice. But there's very few legislation that actually controls the actual payment of ransomware. There's no federal law in the U.S. that necessarily says payment is illegal. There are a few states, Florida and North Carolina, that enacted legislation last year saying that state agencies cannot pay for ransomware attacks. But there is a way for the government to control whether or not you should pay, in the sense that there is the OFAC list, which is this list from the U.S. Treasury Department, Office of Foreign Assets Control, that basically gives a list of countries with which is prohibited to engage in transactions for a U.S. company. So there are the usual suspects like Russia, China, those North Korea, where there's been cases where if there is some kind of tracing back to the attack to, let's say, Russia, then you could be sanctioned because you are technically engaging in a transaction by paying for the ransom with an organization related to Russia. And those are things that have to be considered, these kind of OFAC sanctions afterwards. However, it's a tough call in the sense that there are organizations that don't have any other way to get the information because they don't have backups, because they're losing too much money with having the operations not continuing. And then they have to make this risk analysis as to, okay, let's say we have to pay because it is the only way we're going to get access back to our information. So do we pay and risk sanctions? We also have to consider that we pay and we're dealing with criminals. So are they going to honor that payment and really give us our information? There is actually a lot of the attacks use this double extortion, which is, okay, we'll give you access to your information, but then later they will come back and say, we're publishing this information online, and now you have to pay extra for us not to publish it. So there is obviously a lot of considerations, but it is hard to say from a business standpoint, no, you cannot. I mean, in an ideal world, obviously, it is not recommended to pay ransom, and you should not pay ransom. But there are situations in real life where the business has to make this call as to, okay, knowingly, get into these risks because the not paying outweighs the benefits. So it's kind of a tough call for the business to make.
Yeah.
And hence, why preparation is important, because if you were prepared and you had backups, you had a way to recover, to restore servers, or to recreate servers, or to just say, okay, fine, we don't need the information, then you wouldn't be in this dilemma. And also you have to consider cost. A lot of times with clients and with people in organizations, they see the solutions now in cybersecurity as very costly to implement. But when they're in this situation where they have to pay the reputational cost and the economic cost, the legal cost of having been attacked by ransomware, on top of the ransom, if they have to pay it, that's when they realize it's actually more costly to do that, but it's too late.
Absolutely. So certainly a complex decision to make. Jeff, I'm sure you've been exposed to a number of these situations. So what can you say, considering your extensive experience with the FBI, about whether paying ransom is a good or a bad idea? And particularly, is it true that if cryptocurrencies are used, that payment will be untraceable, that money is lost forever, and there is no chance of identifying who received the payment?
So, with ransomware, paying it, I agree with Victoria, it's a complex business decision, right? You have to decide how much is your data worth, and can you recover it somehow? The FBI's official stance is that victims should not pay the ransom, that by paying it, you only embolden the actors. There's no guarantee you'll get your data back. We've seen victims that pay the ransom, they're given the decryption key, they try to apply that and restore their files, and it only further damages the files and makes them completely unrecoverable. So there's a lot of risk in even paying the ransom. So, but I've seen, it's very interesting. I've seen a lot of companies recently, and this is quite a recent trend, but companies that get infected with ransomware and just make the business decision that we don't care what we've lost, we're going to completely rebuild from scratch, and we are not going to pay any money at all to that attacker. And we've even seen attackers go online and complain about a company that they are unwilling to pay the ransom and try to sort of, shame them online for not paying the ransom, which is quite ironic. But, our opinion is don't pay the ransom. Come up with a plan that you can rebuild everything, you can restore the data, and you'll be okay. It'll be a very stressful, some very stressful days and weeks and months to get it all back to normal. But you can do it. It's possible. And then as far as your question about tracing cryptocurrency, it's difficult. Cryptocurrency is very difficult to trace. The nice thing about cryptocurrency is that most of it has a public ledger, right? So you can go online and see exactly how much was sent from one person to another. Now, the bad thing is you don't see a lot about those accounts. You look at those accounts, there's no, subscriber name and credit card number attached to it, and address or anything like that. It's just, to and from and not much else. But I would say that generally speaking, around the globe, law enforcement is getting better at tracing those, at seeing trends in where the money is going. And so it's not impossible to track people down with cryptocurrency. It's much more difficult, but I would say law enforcement's making some great strides there. And, it's difficult, I would say, to recover funds that are stolen using cryptocurrency unless law enforcement can arrest that person and the court can force them to repay what was stolen. But it's going to be very difficult for us to, get a cryptocurrency transaction reversed. But sometimes we have, luck with working with certain exchanges, cryptocurrency exchanges that will, work with law enforcement and honor court orders and reflect.
All right. So
can I add something, Gustavo?
Of course, yeah.
When Jeff was saying the start over again and have a backup, part of the plan that you have to have, and it will deal with where you have your servers and where you have your backups. Make sure that you have your backups in a position that if you are hit with ransom and you have all of your servers are deleted and you never ever recover that data, you have backups where you can start all over again. And that is one of the things that would let you decide more freely if you want whether or not to pay ransom.
Yeah. And on top of all of that.
And if I may.
Yeah, go ahead, Victoria.
I was going to interrupt and say, one of the issues with that is attribution. It is really hard to attribute an attack. And so when we're talking about what Jeff was saying in terms of authority, not only a lot of the attackers are in jurisdictions that, for example, the US cannot reach, but it is really hard for anyone to really say this was, Diego in Argentina sitting at the computer doing this, because there are very cheap ways and easy ways to have hidden VPNs, to do all kinds of things. So that's why it's important for companies to understand that it is going to be close to impossible to find the culprit, and even if found, to have any enforcement power or to recover anything. And companies shouldn't rely on that to have some remedy afterwards.
Absolutely. So again, another complex issue, right? And to make it even more complex, there is one more issue that comes to the table every time we are involved or working in these cases. It's not that we are involved in the case, we are working on these cases. And this is usually one that you deal with, right? Which is reporting the case to the authorities. And it could be that multiple regulations from many countries apply, and all of them require the company to disclose the attack. And it's funny because those regulations ask for as much information about the attack, the reaction, the causes, and what has been done as clients ask for when they reach out to the company under attack, even though everyone knows that information is usually not available. So what are the best ways to deal with this, Diego? You have 1 minute because we are reaching the end of the panel.
Okay, now I will try to summarize
Sorry,
that.
and then I will go back to Victoria and Jeff for the final comments.
Okay, now very, very quickly. Again, we go back to the investigation. The report will show you what data was involved in the incident. It might be personal data, it might not, it might be IP, it might be other documents. Once you have a good sense of the data that was involved, it is important that you know where the company is operating and whether the data has protection in different jurisdictions. And once you have the map of the data and the jurisdictions, you have to, probably you need to do that beforehand, as I said on the plan. You need to know in which jurisdictions, for example, personal data, which is in a breach, has to be notified to a regulator or the data subjects, if you know that in advance. And then at the end, they were talking before, there are some business decisions that you have to make. It's not just legal. You have to decide if you have 100 jurisdictions in which you have to notify, maybe you will not do that. You will choose, depending on the risk assessment that you do on the company, where you will notify because of different circumstances. But again, it's very important that you decide where to notify and what to notify, and whether you will say, I'm running an internal investigation, I will have a report, I will not have a report. Exactly making sure that you know what you want to share, that's, I think, the key here.
Again, another situation where you have to disclose information about something you are almost completely unaware about, right? Which is what happened and why it happened.
And sometimes you have 72 hours.
Exactly.
To make it even easier.
And it's not only about privacy regulators,
no.
Right? It's also about in some cases we've seen industry regulators.
Financial institutions.
Exactly.
You have a central bank. If you are a security company, you might go to the SEC, similar to in different jurisdictions. Yeah.
Exactly. So that being said, Victoria, Jeff, in that order, I will ask you for your final comments, any additional points you want to bring to our panel. You have 1 minute each because we are reaching the end of the time allocated for the panel. Victoria, you may go ahead. Yeah.
That's a lot of pressure. Okay, I guess my final comments will be that it is all in the planning, anticipating what could happen. I think that's the key. It is no secret that the attacks are getting more complex, easier to do. So companies are going to be attacked. We are all exposed to this, and the difference is made in how you respond to that attack. And I think part of that planning and that anticipation is very important to keep in mind the scope of the impact of an attack. It's not just that we may have to report a data breach. It's not just that we may lose information. It's, again, as I mentioned before, the reputational cost, the cost in the long run, the operational cost, the cost to even the organization in that they may lose key people because the CISOs, unfortunately, are the first ones to get fired. So there is a lot to consider, not just do we have access to our information? Do we have to notify our customers? It has to be seen in a kind of a global view, and why. And that's also why it's important to have representatives of different sections of the organization involved in incident response. It's important to have the view of the business, the view of the C-suite, finance, legal. It's not something that just the IT department can solve.
All right, thank you, Victoria. Jeff, your 1 minute final comments, please.
I would say it's hard to prevent these cyber attacks, right? For your company, you can spend millions of dollars implementing technology, put in all sorts of systems to try to prevent them, hire the right staff, but it's very difficult to completely prevent it. And so with that in mind, my advice to most companies is focus on the recovery. Focus on what you will do after it happened. And we've had obviously a theme throughout this event that a plan is very important. And I would agree completely. Come up with a plan for how you will recover. If you get hit with an attack tomorrow, how are you going to get your business up and running again? That's my best advice.
Thank you, Jeff. So that is the end of our panel. Thank you, Victoria, Jeff, Diego, again. We will be back in 1 minute with our panel on artificial intelligence and compliance.
Thank you. Good job, Jeff.
I think we're done.
Yes, I think we.
Muy bien.
Very well, and we're back. It was less than a minute. We have a very brief break, and now we're going to delve into our next panel, that is artificial intelligence and compliance. And just for the rest of the panelists to be jealous because you're not listening to us, we had an online voting. Many of you may have participated before the conference, asking what were the topics that triggered the highest interest in our audience. And AI was by far the winner, and we decided not to show the results of the votes. So it's not to exert any pressure on you whatsoever, but hopefully you will be meeting the expectations. That said, I'm going to now introduce you, Diego Fernandez, who's in charge of our IT law department at Marval. We also have Agustín Huerta. He is the person leading efforts at Globant and everything regarded or pertaining AI. He's the expert on technology. He is not a lawyer. You can tell that I'm not a lawyer, and I'm as informal in my attire as possible. So as not to give away my profession. Difference is that you've always wanted to become a lawyer. So here's Raul Sacani. He's a Deloitte partner as well, lead partner at Financial Crimes, and he wants to analyze how AI impacts on compliance from his role also at the IAE Business School role. That is, he's a director of Transparency and Governance Center. So out of these 36 minutes that we have left, Agustin, we're going to take it away with you. So the question is, what happens with AI 2023 edition? Is it that we have AI now, but we didn't have that before? Is this something that is, so to speak, a new stage? What are we speaking when we talk about AI 2023 edition? So what has significantly changed? For the first time, what we see is that users have actually spoken and communicated directly with that intelligence. So technological, what actually gives a basis for ChatGPT and the model with which we talk is a model that has been evolving in the past years. It's a family, very large models, and has indeed expanded. But it is the first time that, for the first time, you have an interface where you speak directly to a model. If you've watched any Netflix film or listened to any Spotify recommended playlist or anything, purchased anything on Amazon suggested by okay, that is AI there. Of course, as part of the experience, somebody will suggest I'm not directly talking to that. They may know me behind the scenes. They may bring suggestions to the table. But many of the cases thus far had been through in-person or personal suggestions. But ChatGPT, as of the interaction, the channels to which this was made, as of the ChatGPT app, that's the first key takeaway maybe for us. ChatGPT is an AI app. The last three letters, GPT, refer to the AI model that is behind this app. So the intelligence is not ChatGPT, it is actually GPT. ChatGPT is an interface that we have in place for that. There were a series of models that came out in 2022. We had already spoken about that, but these were through different channels that are more aimed at specific communities with more specific goals, such as design, for example. So I'm asking the same thing, and I'm asking them to draw something, and they may be as lousy as I am. But ChatGPT, conversely, as of the simple forms it has, the app is a most rapidly adopted app, 100 million users in 2 months framework. So what has happened as an impact is that when I go to lunch, for example, if you're talking, I overhear some conversations at a different table and say, please do not intervene, do not intervene. But in the years that I've been in technology, it has happened to me that all of the conversations are about ChatGPT. It has happened that there are new products in the business, but it's about AI. All conversations go around AI. This has helped me do this, and it's really surprising to me that I find this, that I learn this, and it's great, but I also need to refrain myself from intervening in those conversations that I overhear. So the evolution of technology that was already in place, and now there is a capacity for computing things that is ever stronger, ever enhanced. And I remember when we used to discuss this days ago when we were preparing the panels, that one of the wonderful factors is that this software has learned to learn. So basically, I will throw at it all the websites or books, and they may learn. Yes, it comes from a scheme. And generally, when we train these intelligences, you have the concept of supervisor monitoring, that I get all of the data package and explain, this is a picture of a cat, this is a picture of a puppy, this is a bird, etc., and explain that to him. But then there is a mechanism that is called semi-supervised. I explain that, I may tag, and maybe I may not say the same thing for the bird. But in this case, I provide them with a data bundle or package and say, okay, go ahead and learn. And then we may revise, we may review. That is a human-in-the-loop feedback. what is precisely this? It's a person, it's kind of a dog. You have the cookie for the dog. When that pet does something okay, you provide him with a cookie or the snack. And when it doesn't, you say you need to do this correctly to obtain that reward. So you need that machine to learn different behaviors from what we believe is acceptable, and that is we believe are human interactions. Great. So thus far, major development, very top-notch. It allows us to interact directly, very simple interaction. And those of you who have not used it, you need to go ahead and do so. We thought about having some demonstration here, but we were not really with time. So when it comes to software, maybe you can tell that person to draft a memo and to summarize that maybe to 2 pages on French Revolution. Okay, now let's draft it as if you were a literary author, and now turn that into a poetry. And that's wonderful. Yeah, and maybe use words only and starting with letter O, and it'll do that. Exactly. So, as you well said, that is one of the apps in which this technology works. It is similar for images, music, videos. That said, please share with us this other concept that we discussed a few days ago that has to do with hallucinations, because thus far everything seems great. Okay, it's about the example that you just said. Okay, summarize the French Revolution. These models, we call them generative because their main motivation, their raison d'être, is to create content. And in that creation of content, that goes beyond thinking about the veracity or validity of that content. And maybe you're going to read that, and if you read that in mass media, you would believe it. Now, the thing is that true? Is it not? 2 seconds ago, I was just sharing with Raul. I got a challenge last Friday, and I said, okay, I want to learn how many times the S&P 500 have called the term AI. Okay, that's a challenge. I said, okay, you're going to download all of the online calls. No, I said, I'm going to ask Google, which most probably somebody has already run this analysis, and I'm going to ask the bar that is equivalent to ChatGPT, but rather connected to real time. ChatGPT will say, okay, I'm just running through up until 2021. I don't have real time data. But for ChatGPT, I would have to feed it all of the information to date. But when I asked Google, I find all of the articles, data, sources, data from Bloomberg, FactSet, reliable sources. So I'm asking Bart then, and there's a series of figures that like, this is not what I read at Bloomberg or what FactSet. Where did you get this from? And there was a web address. There was a 404 error message. There was nowhere to find this information, and it led me to a company processing this information. Most likely, they have the data on a paid services, but I don't have a way to validate this, so I didn't trust the data. So, like, okay, Google that same question, and consultation from Google was less efficient than the one I had run. The results were less specific or less accurate, and had to do also with the fact that we know how to prompt. That is how we ask or we request this to the system. So after so many years of using Google, you have learned the tricks about how to ask Google. So with these interfaces, we're still learning, and those prompting techniques, you can aim at having a more accurate model, but you still have a strong component by which you may still be hallucinating, things that are not in real life found, and it will provide it with utterly convincing or compelling language. So last weekend, I read an article that is tapping into this, when we found a model using the same language we use, what we use as something humanely inherent is this conversation is something that I would not be holding with a dog. Our brain is so much used to having this conversation with human beings is that we try to ascribe it anthropological features. So there are very funny prompts that say, to ChatGPT. Why am I speaking so formally with you? Because we believe this is a kind of a top expert. So we treat him formally. Maybe you, if you deem it convenient, you may assist me with this need. So what this person said at the article is that it poses us with a problem or at a crossroads. There is something we are assessing when we talk to people. That person may perform in a certain field, and it is also competent in that field. We tend to misunderstand these two concepts. GPT can elaborate language, but it's not competent with regards to knowledge. And if it's not competent, then it's not reliable with regards to knowledge. It may assist you, but do not take that for granted or take that as something true. A very appropriate situation for the conference happened a few days ago. This was a judicial proceedings case in New York, where an attorney at law quoted certain, and you will find this in different Google time. Bart should actually know this. He conducted research using on any given proceedings on a judicial case, and ChatGPT said, yes, you have all of these arguments in favor, but the attorney said, okay, what is a case law for this? Well, all of that. There was a listing of that. The attorney went to the judge with all of that background, but he was not actually taking into account that the other party would request to see all of those rulings. And these were not existing when we searched for that. And he needed to explain to the judge that he had actually trusted GPT. This was the first time that happened, and we almost had a laugh after that. But it's clear that we cannot replicate that, because otherwise, of course, we would be subject to sanctions. We cannot invent or make up cases that do not exist, but ChatGPT can do that. That case has a second stage. When the attorney at law realizes those cases are not existent, he actually told GPT, okay, you almost lied to us, and he created the invented cases, and he made the case up, and he gave it to the attorney. So now there are certain previous cases that have been made up by GPT. You asked me, and I generated that. So there's a case. Okay, now this is a warmer. So this has been a warmer activity with respect to historical evolution of ChatGPT, hallucinations. Raúl, you've been investing a lot of time, amazing amount of time, in assessing how these new technological advantages may apply to compliance. I've seen you study lots of topics in compliance. I haven't actually seen you as thrilled as you are with this one. So share with us from IAE Business School what you've seen in research, and that is only beginning. But how is AI impacting on compliance? I've always been called a nerd, and maybe that's why I get along with AI. That's for the fortune of our interpreter. So if she stays to the end of the conference and listens to this panel. So I've always been called a nerd. That would be the term. So that's why I get along with AI. And this is also something that can apply to AI now. And I've actually said translator, which shouldn't be the accurate term because it's interpreter actually. So this bias is always present also when it comes to AI, because this person, this tool is trained with the things that we have generated. So what it has amazing about it is that it is incredibly good when it comes to AI to replicate the way in which we communicate. that has been trained as of what we do. So all of these biases that we may have, for better or worse, are also embedded there. This is a starting point in order for us to really discuss this, and we've seen and we've listened to a lot on the side B of all of this, but there's another side that is quite interesting and for which there's a lot of interest that has arisen, that is that the ball is already rolling, and there's no way we can halt that, because once you start using it, you actually see how productive it will become, once again, for better or worse, as of the use of these technologies. And truth is, if we are to stick to the idea that we shouldn't be paying that much attention because, okay, there were some precedents made up to pour into this case that was non-existent, but everything was made up and was created, it's not the fault really of ChatGPT, but rather about something else that we as human beings have. We don't necessarily do something that we should do. You will not give a junior attorney the responsibility of drafting the entire case to send it to the court or the magistrate. So what's interesting is that, for sure, in order to solve a case, AI provided that attorney 5, 6 additional options that maybe had not even crossed the attorney's mind. So if there's anything that is indeed wonderful and marvelous, and that's why we wonder at its use, is that it offers some very creative alternatives that actually add a lot of value to work. And there's where we actually start finding out what it has to do or how it taps into compliance. Because aside of this, okay, I'm asking ChatGPT to draft a conflict of interest policy, but I can really request something much more interesting. For example, okay, as per this context and thought or aimed at people from this industry, draft 5 different alternatives for conflict of interest policies. And we're going to start finding there. Of course, we're not going to choose one of them and load it to the internet, but it'll offer a series of ideas for us to explore that may end up being very interesting. Let me set another example. Lawyers at times ask us to draft or to write recommendations. What do you call them? Chambers, for you to really see who's a better attorney. Yeah, so I start writing these recommendations, and okay, Gustavo is top-notch expert, he is great, and let me run through by ChatGPT. Can you improve this? Can you enhance that? And that's a really wonderful text, much better than the one I had actually written. Should I not consider that? You're now going to what Agustin mentioned. Although ChatGPT is an excellent performer, you're talking about the analytical capacity of ChatGPT, of really generating better writing, better alternatives, maybe strategies you had not thought of, which is quite different than thinking or trusting, content that ChatGPT is providing. For example, when it's defining what a conflict of interest is, does that definition agree with what you have in mind or what you are discussing? I think this is the worst version of AI that we will have in the future. This is indeed evolving at hyperspeed. So all of the problem that we're looking at, hallucinations, etc. Now, version 3.5 of ChatGPT was run for the neurosurgery exam, and it cast 22% of errors and hallucinations. Now version 4 has a 2% of error and hallucinations. So this is really moving fast. I'm not sure if they will be solving neurosurgery issues, and most likely I don't want that to be solved. And you're going to ask me why. Yeah, share with us why. That is something you don't need to tell me, Raúl. Because you can actually gauge that temperature. You were talking about gauging the temperature. You can actually gauge the prompt's temperature. So the colder the temperature, the more exact or accurate and less creative. But I'm not sure if I really am after a creative prompt. And this is indeed something to pay attention to when we want this to be interpreted as the way you interpret a software. And here we have the whole debate around regulation. We want this to behave as a software. I want to audit it. I want to really be at peace of mind. If I have ABC, I want then to actually get D. And I want to be able to explain that. Very well. So what's richest here will not be that, but rather that through different prompts we will be getting a series of incredibly interesting, stimulating, creative responses. If I'm a compliance officer, I want to think how to enhance my training sessions. Super important topic in compliance. That when we have these training sessions, all of us accountants, lawyers, we do not really dress the way this guy to my right is dressed. So help me get more creative training sessions, and you will get lots of ideas. But we will get to a point now that Microsoft activates Copilot, and we will have a Word, Excel, this function enabled. We will get to a point in time, and I'm not sure if this will be in 2 years' time, 5 years' time, but we will be writing, sending emails through AI. The person getting this, the recipient will be reading this through AI, and will not have the chance to realize how far the penetration goes. So we are only beginning. This has already been started as a process, and there's no chance for us to halt this. And you're actually running short when you describe that. Yeah. Wait for general AI to come across. That's a different debate. So wait till every one of us in the room gets into that realm. There are lots of people who have not yet used it because it will make a lot of things easier. And when it comes to human beings, when it comes to doing things with less effort exerted, well, this is something that we all are for. And there are people who actually hide themselves to use that because it is banned at the office space, but they go maybe in the chat and they have the ChatGPT consultation and they send it through to their inboxes. So this is only beginning. Okay. So huge analytical capacity, a performer, as Agustin and Raúl said, as no other in terms of speed, capacity, not necessarily reliable or trustworthy with regards to certain content, at least. But, Diego, humanity, in all of their features and capacity and capabilities, tries to or wants to regulate it when they find something like this. And it's the same question I made to Agustin. Are we starting to debate anything on AI regulation? Was this existing? Where are we heading for? Please provide us with an approach, a viewpoint, a global viewpoint. Let us not just stick to one region. And share with us where we stand right now, what we can expect from the regulations of this phenomenon, actually looking into the future, that this is where we'll see the highest impact.
Okay, so this is the least exciting aspect, right? I come here to tell you what to regulate or not. So, Diego is the user fascinated by AI, and now I am the lawyer hat. So, regulations are split in two. On the one hand, there are many places that are seeing what happens to see whether regulation is needed, and then we may anticipate the many issues that will come up, but this other part sees what aspects to regulate. So we take a look at the US and Europe. The US is in the wait and see. I'll see how this evolves. So waiting for these markets to grow. And there's also a geopolitical race, right? And the Europeans, and I come from data protection, Europeans are usually regulators, and they have this draft on AI draft. They are based on a risk approach. They divided the activities into more or less risky. Some are completely prohibited, others are risky. They have to meet certain requirements. For instance, for products, including tests before launching, cybersecurity aspects, privacy aspects, and then there is a follow-up of the products in the market for the manufacturer and for the users as well. So most of the world actually has nothing. Argentina adhered to some UNESCO general principles. Last week there was some sort of reliable AI guide. Everybody knows what it means, but there is the typical struggle between regulating versus non-regulating AI. My personal idea, so the regulation should not kill innovation, I believe. And I point to Latin America and Argentina in particular, countries that need economic growth, need innovation. And if we don't have a regulatory framework that fosters growth, that is everything prohibitive, then who's going to invest in those frameworks? Maybe, well, Europe can afford to take some actions, but I believe that the North here should be don't kill innovation, respecting privacy, respecting data, but allowing for growth to start. Europe, as you said, can afford because it's a place where everybody wants to be. However, nowadays, some of these developments are not available in Europe because of the regulations they have. So I guess that will have an impact on Europe. If we have a technology that can improve your productivity, that can derive in better quality of life, so on and so forth, if you don't belong to that, you will exclude yourself from the world and you will start lagging behind. So I guess that the intentions of Europeans in relation to these things are okay. This is a very complex field, and collaboration is key. And sometimes I do not see that they find the most effective partnerships in the industry, the main players. It's like they don't have an ecosystem of their own. Unlike the US has an ecosystem of Google, of OpenAI, everybody is there. Actually, those are the partners that are providing the infrastructure in the first place. However, Europe doesn't have those players. They need to bring them from other places, and that is, of course, hard. If we talk about regulatory backgrounds of this type of disruptive technologies, maybe regulators want to take action quickly, just in case. As Raul said, users will use these technologies as long as they feel that it makes their lives easier. So regulators will maybe come late. If there was someone talking about cloning, cloning or clonation has many ethical complexities and it is highly regulated. The industry is regulated. The types of tools you need for cloning also have their own specs and regulations. They need a genetic scissors, for instance, something that is not usual. And it is also very tangible. A clone is something physical. However, AI is not, and it requires a huge intellectual effort to put it into a tangible level, to understand how it works. This is how I see it. Even when we talk about regulations, we see Europe as the pioneer, but GDPR, the data part, took some time until it was there available. I remember 5, 6 years ago when the GDPR started, we had to make adaptations. I remember I accept the cookies, I accept all cookies. Cookies have existed since the 90s. Okay, you're right, and you need to learn how to work with regulations. So I believe that we want to go faster now with AI. Nobody realized until many years later that the cookie thing was also an issue with sensitive information and all that. So it's like with AI, we are taking action so proactively. We need to take care of see where it gets. So probably in the future, Diego is going to tell us how it all went out. So there is a statement that has been going on regarding AI and ChatGPT that says that it will create an explosion of unemployment. So one of the key qualities of ChatGPT is its capacity to write code, programming, which is the core business of Globant, right? So what about these tools? Are they a threat to the job market, or the result is better? If I ask about earnings calls, it couldn't give me the answer because the knowledge was up to 2021. A few years ago, Apple launched Vision Pro. So again, if we think about how the experience is developed, someone needs to train an AI so that it gets to that level of knowledge. And for that, we need to have evidence. So the AI has learned everything that we'll generate. And there is a trail there that will be created by tech companies. So you know that companies want to be on the edge of technology. Only people can be there today. So AI will speed up heavy work, many things, work that is not the true value or valuable work. And rather, we will be able to take advantage of the tech edge that we all want to be, or we all want to get to. So we should not fear losing our jobs, but rather enjoy more, thanks to the productivity. Yes, actually we have a case why we are still far from that gloomy future. This idea that the ChatGPT makes up information. But it can give different things, new ways of seeing things. Maybe the lawyer in this example could have gone to check the evidence, to check the proof, to supplement this. So I believe that it will depend also on what companies decide to do with the free time. There are studies about how productivity is increased using these tools. And and the increase was by 30 and 50%. So what are companies going to do with that free time? Are they going to have more work? Or will companies shift those employees to other tasks where they can make the most of their capacities? Are they gonna get them out of the equation? We still don't know. These are the questions we need to answer. And the last question, Raúl, is for you. Artificial intelligence will ever replace compliance officers? Think about, think thoughtfully, ask ChatGPT. Well, nobody will remember this, don't worry, you can speak your mind. So, I personally think that no, but let me explain why. What are the assumptions that I'm thinking about? It will depend on each compliance officer, but there are compliance officers in highly regulated industries where it will take longer for AI to arrive. So how do we define the short and long term in these matters? 2, 3 years. But clearly, there will be actions that will allow the compliance officer to be more powerful, because they usually say, my team is not enough, and with this, they will be able to empower their potentiality. And there will come a time when some of the things that compliance officers do might be replaced, some of the tasks might be replaced by AI. And I suggest start thinking about emotional intelligence. If we talk about compliance, we think about people's behaviors, right? Preventing certain behaviors. But behavior is inherently human. AI may be very good at producing language, which copies people, but we are not just that. And there are many things related to behavior that the compliance officer will need to check, monitor closely whenever the business needs to answer a problem. Good. So with this note of peace of mind for our CEOs, we will close this panel. And I thank Diego, Agustina, Raúl. Thank you for your presentations. And we are back with compliance and enforcement trends and challenges in the USA and Europe. Thank you.
Panelists on this topic, which is compliance and enforcement trends in the United States and the UK. My name is Daniel Alonso, Dan Alonso. I am a partner at Orrick, Harrington, and Sutcliffe in New York. With me here is Lucas Lovicek, who is a partner at Quinn Emanuel in Washington, D.C. On the screen behind us, we have remote from the United States and the UK. We have Kim Nemero, who is a partner at Kirkland & Ellis. We have Richard Donahue, a partner at Pillsbury Winthrop Shaw Pittman. And we have Allison Geary, who is a partner at, I've forgotten the name of your firm, Allison, I apologize. Can you just say it? Mishkon de Reyes, right?
Correct.
Apologies, yes. So now we could, this topic, U.S. and U.K. in compliance, anti-corruption, and investigations, obviously we could spend a week on the topic. We have 38 minutes, and so we are going to narrow this down so you get the essentials of what's going on in 2023. Think of it as a better version of if we asked ChatGPT, what are the 4 things we need to know in this area, and don't hallucinate. That's what this is going to be. So I'm going to start with Rich Donahue. Rich, you're a former U.S. attorney for the Eastern District of New York. You're a longtime Justice Department official before you went into private practice. You have the pulse of the Justice Department. Tell us where we are. What are they focusing on today? We know about the past. We know about accounting scandals and FCPA. What's happening in 2023 with the DOJ?
Yeah, Dan, well, it's great to join you. As you know, there's a lot going on in the U.S. and around the world. The Justice Department has a lot of people, a lot of problems they must address, and so they get to have a lot of priorities. I'll just touch very quickly on the top 5 in the white-collar arena right now. First up is sanctions and enforcement. We've heard repeatedly that sanctions is to do FCPA. We've heard that from department leadership, and we've seen that in how they're allocating their resources. The Russian invasion of Ukraine and increasing U.S. PRC tensions have only gone to further enhance the DOJ's focus on sanctions and enforcement. Second, we've got crypto, of course. We all saw what FTX did and how it has impacted the world within the last year. Tremendous impact on the crypto industry. The criminal prosecutions relating to FTX are still underway. But to me, what's more interesting, actually, is the more recent, within the last week, SEC actions brought against Binance and Coinbase, because those are not focused on individual misconduct. They are focused more on the industry as a whole and the actual architecture of crypto and whether or not it will be enforced as a security here in the U.S. And it's interesting that there are apparently disagreements within the U.S. government as to how to treat crypto. So we'll see how those cases develop. Third, of course, is cyber. Cyber creates a multi-billion-dollar drag on the world economy. It helps prop up authoritarian regimes such as North Korea and assist other bad actors, and so that will remain a priority for the department. Fourth is anti-corruption. In December of 2021, President Biden announced that international corruption is a national security risk for the United States and called for an all-of-government approach to that. And so DOJ is continuing, focusing primarily on the FCPA, but also other anti-corruption tools as part of that all-of-government approach. And then finally, fifth is anything related to the PRC. It's true that the DOJ no longer uses the term China Initiative, which we used in the last administration. However, we can see that not a week goes by without a significant case with ties to the PRC being announced. So that remains a priority for the department as well.
It's interesting but not surprising that both China and Russia loom large in the thinking of U.S. law enforcement, and it follows the trend of internationalization of sophisticated U.S. Law enforcement. So, Rich, let me stay with you for a second. So I think most people in the room and online are familiar by now with the U.S.'s policy towards incentivizing companies to cooperate, to self-disclose, to get credit, leniency for having presented facts and other things to the Department of Justice, also to the SEC. What's the status of that today? How has that changed? What kind of efforts is the government making to incentivize companies to come forward and self-disclose?
Well, the DOJ and the U.S. government as a whole has long focused on 3 things when it comes to companies and how to resolve issues they may have. They look for disclosure, cooperation, and remediation. The emphasis, however, has changed over the last few years. When the new administration came in 2021, they issued some memos and had some public pronouncements that they were going to take a hard line on corporate misconduct. That has softened somewhat. Some of the provisions that they suggested or insisted on was having compliance officers sign off on reports to the U.S. government saying that the company was meeting its requirements. They're also emphasizing clawback provisions in executive compensation plans. But within the last few months, we've definitely seen a softening of that. That may be a result of the decline in voluntary disclosures. But we have seen, for instance, leading DOJ officials say that even if a company has a significant history of misconduct, they may, if they provide extraordinary cooperation, still be eligible for a declination. So we're seeing a shift, certainly in tone, and I think ultimately that will be a shift in results as well.
There are different opinions on whether these efforts are working. What do you think about whether self-disclosure is happening more now that the DOJ has given additional incentives, or if companies are still reluctant to come forward if they found some evidence of wrongdoing?
These developments are fairly recent, so I would say we probably saw a decline in self-disclosures in 21 and 22, and as a result, these new policies. So it's going to take some time for them to have a real-world impact. Reality is no company wants to be the one that steps forward to see how real the DOJ's commitment is to giving companies a second or perhaps a third chance when they find themselves engaged in misconduct.
Well, you know, we're in an international conference. We happen to be located in South America, but there are people from 82 countries tuning in here, and I think they have vastly different cultures in all those different countries. I mean, what is it? Why should, in some of those countries, executives worry about U.S. law enforcement if they're safely ensconced in their home cities and they don't really feel like they're particularly subject to U.S. jurisdiction? Why should they worry if there's some technical hook for the DOJ to use?
Yeah, well, the risk, of course, is that the U.S. takes an expansive view of its long-arm jurisdiction, both in criminal and civil matters. We've seen that time and time again. Obviously, FTX is a recent example. FTX was headquartered in the Bahamas. Sam Bankman-Fried was living outside the United States. Other examples of large-scale U.S. cases built by the DOJ include 1MDB, which was done from our old office. All of that happened in Asia. There's almost always a U.S. bank, a U.S. wire, or a U.S. victim involved. As long as that's the case, U.S. authorities are going to feel that they have the appropriate tools to reach out, even though evidence and targets, witnesses may be located overseas. But that does give an opportunity to companies, because the fact that this evidence is overseas, witnesses are overseas, creates an opportunity for companies to cooperate by trying to help make that evidence more available to U.S. authorities, and then you can get some credit for doing that.
I totally agree. You know, just as a quick aside, I wrote an op-ed, a column several years ago in Argentina's newspaper La Nación, and I said, and tell me if you agree, that, you know, you could be on, if you're part of an investigation and they know who you are and you're safely ensconced here in Buenos Aires, you take your family on vacation to Disney World, you may get a knock on the hotel door from the FBI. What do you think about that?
Yeah, I don't want to discourage tourism to the United States, but a fair number of people get arrested while they're on vacation in the United States, or even just passing through. There's so much international transport. Obviously, here in New York City, we have JFK and LaGuardia. And there are a lot of people who don't realize they have a problem. There might be a warrant, there might be a red notice. And even if they're just changing planes in the United States, they have an issue. So I certainly don't want to discourage travel. Please come to New York. Please come to the United States. But there are issues there that companies and individuals need to consider.
Great. Well, companies in the United States and abroad have much more to consider than just the current state of U.S. enforcement and U.S. investigations. There's a lot of preventative work that comes in. Obviously, this is a compliance conference. Kim, let me turn to you. And I think one thing on lots of companies' minds is cross-border transactions. And I think that, you know, we all sort of know there's got to be due diligence done in these transactions, but you do a lot of this in your practice at Kirkland & Ellis. You know, tell us what you're seeing, what the concerns are, what kind of advice you have for, you know, U.S. and international companies in terms of transactions and due diligence.
Well, first of all, hi, everyone. It's nice to be with you today, and thanks, Dan, for the question. International transactions have for many years presented sort of potential U.S. enforcement risks, and those risks are sort of continuing, particularly now as international regulators have become more sophisticated at understanding the nuances of these sorts of transactions. And as markets have become in the past year, I think, you know, maybe more stressed, that has led to what I've seen is some maybe more aggressive deal making, right? Or kind of potential counterparties doing deals that maybe a couple of years ago they wouldn't have considered. And those present potential enforcement risks, whether it's from an anti-corruption perspective, a sanctions perspective, a money laundering perspective. And when international investors are considering making an investment in a Latin American country, let's say, I think U.S. regulatory requirements are that companies consider and conduct appropriate due diligence to understand the risks presented by that transaction. There's no one size fits all, though, on that. It needs to be targeted to the particular risks of each business and each transaction. And so what that would mean is what I think is the most important requirement for anyone contemplating an investment or buying a company is to know the counterparty, know the company you're buying, assess those risks, assess what jurisdiction it is in. Does it present a heightened risk for sanctions risks, anti-corruption risks, or the like? Know the industry and understand the regulatory requirements and the government contacts associated with that particular industry. And then lastly, I think every investor should consider the nature of the investment or the control position that you're taking as you're making an investment. But if you're a strategic company, a global company, and you're buying, 100% of a company that might be based in Argentina, you're going to then control that company entirely. If you are, on the other hand, an international investor who is making a 5% equity stake investment in a company, you may not take on as the same level of risk. That doesn't mean diligence shouldn't happen, but the risk profile of a transaction would be different.
And if you control the company, correct me if I'm wrong, you're buying the liability as well, whatever happened previously.
Absolutely.
So what do you say that was great from the perspective of a U.S. strategic or private equity firm looking to invest in? You said Argentina, could be anywhere in the world. What if you're the company in the exterior country? Let's use Argentina since it's the example you used, and you're very red on Delia's map. You guys weren't here this morning, but the chair of Transparency told us about their corruption perceptions index, and how should you sort of prepare your company for the acquisition and due diligence process if you want to sell yourself and pass muster when Kim Nemiro is representing the acquirer? What do you do?
That's a great question, and one that I often don't get. So I think the way to really think about it is to ensure, one, to probably anticipate that if you're receiving an investment or doing a transaction with an international investor, you're going to get this sort of international risk, anti-corruption, sanctions-related due diligence question. So you have to anticipate that and be sort of open to it and transparent about sort of the nature of your company. That's probably first. Second, I think it would behoove any company to ensure that they have the sort of compliance program from an anti-corruption, sanctions, money laundering perspective that would be commensurate with what an international investor would look to see. I think, and sort of make sure that you've kind of dotted your I's and crossed your T's on that compliance program. And I'm happy to talk about some of those components of what that might look like. Of course, that could be the subject of an entirely full other 3-day panel.
It can be a week-long seminar. But let me ask you this: since you actually delve into these countries, so focusing on regions that have a lot of red countries, South America, Africa, some places in Asia. Are they taking it seriously? I mean, what are you seeing? Is their compliance program just a tick-the-box exercise, or are you seeing that things have changed in recent years and you see some robust controls put around the various risks?
I think the reality is I have to give the sort of standard lawyer answer, which is it depends, right? And it does. I think for some companies that might be based in some of the highest risk jurisdictions, they have built compliance programs that are more than just sort of paper check the box programs. Whereas I've seen other companies that really haven't, right? And that instead have a policy, have a training program, but don't have the sort of culture of compliance. And culture of that. And that comes from the tone at the top, right? That comes from understanding the resources needed for any sort of compliance program, right? It can't be just, a slap a policy on that's the standard boilerplate policy. You can't have that. But I have seen many companies that operate exclusively in what some people might classify as high-risk jurisdictions actually having kind of meaningful compliance programs. And those programs can go a long way towards making an international investor or sort of, a counsel who's assessing that risk really comfortable in those situations.
You gave a tantalizing suggestion that you can tell us what's important in a compliance program. We don't have any near that time, but if you could say one thing to people in non-U.S. countries, to make their compliance program better, what would you say?
I think an effective compliance program starts from the culture. Right? So whether that's, sometimes it's classically called tone at the top, sometimes it's called making sure you have the right kind of compliance resources. I think if you can establish a culture of compliance through that tone from the top, through a dedicated and sophisticated compliance resources, through a culture that encourages and acknowledges speak up or complaints coming forward, I think you'll be a long way there.
I used to say, as a quick aside, I used to say that tone from the top, obviously crucially important. Tone from the middle, I find, is very important too. That grizzled veteran who everyone turns to, if that person rolls his eyes at what the guy from the top says, it's not going to be very effective. If you can convince those folks who are real influencers inside, to use a social media term, inside the company, that's very, very helpful as well. Thank you. I was going to ask this question of you, Kim, but since I have Lucas here, I want to ask him before we get to the topic of international litigation and commercial arbitration. I want to ask you, do you believe, in your experience in investigations with the U.S. authorities, do you think they get the difference, the cultural differences between companies that are based, say, in Canada or New Zealand, some clean jurisdiction, versus, the ones that are more red? Do you think the U.S. really gets that, or do you think they just want to impose their view on everybody?
Thank you, Dan, and many thanks, Marval and Gustavo Morales Oliver, for this invitation. It's a pleasure to be here with you all in my native and beloved Buenos Aires. So I think the DOJ basically accounts for that. Considers that the cultural differences. Of course, sometimes it depends on the prosecutor, but I think that at the very end, the DOJ is interested on the remediation, and cooperation, and how timely the companies do that, and basically the compliance programs that they have and how they have implemented them.
Yeah, I agree in my own experience. I think it depends on who it is. There is an ethnocentrism to our adopted country. But yes, I do think that the more sophisticated prosecutors do understand that. And I'm sure, Rich, I would ask you, but I don't think we have time. I want to move on to ask Lucas about. So now there's a DOJ investigation, an internal investigation. It's shown problems with corruption. We generally think, okay, criminal disposition, maybe the SEC. Are there implications beyond that for commercial litigation, arbitration, international disputes that are civil in nature?
Thank you, Dan, and that's a great question, in the sense that usually when things, corruption issues come up, basically companies think about potential DOJ proceedings, investigations, investigations in the local jurisdiction, and basically in the U.S. or Switzerland or other jurisdictions, but they don't think initially on what are the implications of that in commercial or investment disputes on. And I'm referring mostly on basically the implications on their ability to exercise and to enforce their rights under contracts, under investment contracts, under international law or investment treaties, to protect, the assets that they have in the jurisdictions where they have invested, right? So Kim earlier referred to basically due diligence, when in acquisitions and when you're investing in a country, usually foreign investors, they incorporate a company, let's say in Argentina, in any other Latin American jurisdiction, or they acquire that business, right? And that business and that company owns an asset, project, a big project, right? And And what happens, right, if basically you procured that investment or you made that investment, through corruption by paying bribes or any other like undue influences of the government officials, and at the end, basically your investment is affected or you have a breach of contract, and you need to enforce your rights in that jurisdiction. And there's where the problem comes. And sometimes, the companies are not aware of this, but basically, as you know, the law cannot protect and does not protect corruption, right? So basically, the bottom line is the company could be prevented, from enforcing those rights and pursuing claims to protect those rights. And I will start with in the case of investment
Can
disputes.
I clarify one quick thing, though? Are you talking about acquisitions that are obtained through a corrupt act, or are you talking about honest acquisitions where you acquire a company that has a corruption problem that they didn't disclose or they lied about?
It could be both.
Okay.
Sometimes there's a direct investment, right? So you basically incorporate a company. You started from scratch. You incorporate a company in the local jurisdiction, and you make the investment. You acquire the project, or you're granted with a concession contract, right? Just to put a simple example. The other one is when you acquire the company in the local jurisdiction, right? And that company has been involved. Maybe you didn't do like an adequate due diligence, right? And then things, and issues about corruption come up afterwards. But in both cases, you have the problem, right? In both cases. So how this basically comes up in investment disputes, I will start with investment disputes under like international law or a treaty, an investment treaty, usually a bilateral investment treaty that protects basically that investment from the actions of the host state that affects that investment. And the problem there is that, of course, the host state can raise a defense based on corruption, basically objecting the admissibility and the jurisdiction, the admissibility of the claims and the jurisdiction of the tribunal, right? Why is that? Because, of course, corrupt practices in the making of the investment or to procure that contract, let's assume that this is a concession contract, basically, the international law and corruption is against, public policy, an international public policy, right? And investment treaties do not protect investments procured by corruption. They only protect legal investments, right? And I'm not going to get technical here. It has to do with the definition of in investment. It has to do with the definition of investment in each treaty, which basically most commonly provide that the investment has to be made basically in accordance with the laws of the host country, right? But that is one thing, and this could go to the merits or could go to the jurisdiction. In the case of when this issue goes to the merits of a dispute, that happens when the corrupt practice is made not in the making of the investment, but during the operation or the course of the investment. Basically a basic example could be when you obtain the contract, and then you have, and we handle these cases, and they are quite common in Latin America, when they have like companies or investors have basically receive extortion threats by government officials, soliciting bribes, basically to grant a permit or to grant other approvals, or basically to just provide security, which is their obligation that they have right under an investment treaty. And sometimes investors refuse to do that, and the states, take retaliatory actions that affect the investment.
So, and what kind of evidence do you use in these international proceedings? Is it from the corruption investigations? How do you prove this stuff?
That's a great question, because of course there have been like divergent decisions in this regard. There's no uniformity. In the investment side, tribunals have gone through and have applied different standards. They have gone from requiring clear and convincing evidence or irrefutable evidence to basically requiring that the evidence should prove corruption with a reasonable certainty. And then they have gone also and applied another standard, which is basically the most commonly used standard in the civil context, which is preponderance of the evidence or balance of probabilities. And even applying like the hard standard of clear and convincing evidence, they have considered circumstantial evidence or inferences. And what's interesting about this, that this has happened over time, and it's even happening like nowadays. There's no uniformity. That is something, in my view, that is quite concerning, and that the arbitral community needs and investors needs more certainty in that regard.
Well, it sounds like a cutting-edge issue. We'll check in with you next year. It's also a good follow-up to Kim's due diligence, right? This is what happens when due diligence perhaps doesn't go right, perhaps through no fault of the lawyers involved.
And then, sorry, and one more comment, because I didn't say this, but on the commercial side, on like sort of not investment disputes, but commercial disputes, there is one simple remedy. Basically, if you have issues of corruption, basically in procuring the contract, which is basically that the contract is deemed null and void, and basically you might have a claim, but the tribunals basically would not let you enforce that contract because it was procured under corruption. I can share an experience with one case that we've handled and is public, where we were able to overcome that defense, and we were representing the claimants. But I'm just considering the timing, and I will just let you.
Although hugely important topic, obviously these deals, if not hundreds of millions, they deal with billions of dollars. So it's very, very important. So Alison, I want to go to you from Ishkondareya in London. I want to ask you what's coming down the pike. Obviously, we all are familiar with the Bribery Act 2010, the UK Bribery Act. What's coming down the pike in the U.S. In the UK, in the area of fraud and corruption compliance?
Thanks, Dan, and good afternoon from London. So a couple of reactions to things people have already said to join things back up a bit. I just wanted to come back on the comments Rich helpfully made about the slight decline in self-reporting, which we're also seeing here in the UK for numerous reasons. One of them, no doubt, because the old phrase that if America sneezes, the rest of the world catches a cold is probably still true. And if companies are not self-reporting in the US, then they're not going to be self-reporting simultaneously here in the UK. So we are seeing a slight decline in enforcement action at the moment. For numerous reasons, pandemic being one of them, and staffing changes, which I might talk to you about a little bit later. So in terms of what's coming down the pike in the UK, I've got to talk about legislative changes. And if this were ChatGPT, I think you could assume that all legislative changes took place in March 2023 in the United Kingdom, because there seemed to be an almost whole-scale revolution of changes coming into force or being looked at here in the UK. The biggest and most important, the one that if we were to talk about what must you walk away knowing about here in the UK, is that we are going to get a failure to prevent fraud offence, which will be relatively similar to our failure to prevent bribery offence under the Bribery Act. So we will have a situation where if a corporate has a person associated with them, an employee or an agent, that commits an act of fraud intending to benefit the corporate or the corporate's customer, then that organisation may be automatically liable to an offence of failure to prevent fraud, unless they can show that they had reasonable procedures in place to prevent that fraud. There are differences to the Bribery Act offence. This has not become law yet here in the UK. We're expecting it to become law in the summer and not to come into force probably until next year, although the UK government is saying that they want to bring it into force this year. Main difference being that it only applies to large organisations, so organisations with over 250 employees, more than a turnover of more than 36 million or more than 18 million in assets. That is still up for debate and is very, very unpopular in certain camps within government, so it may go. But my take on it in any event is that it will affect smaller organisations, because just like the UK Bribery Act, because companies are responsible for their associated persons, anyone that is servicing a large company in the UK will, by contractual obligation, be asked by that UK company to sign up to compliance with this Failure to Prevent Fraud Act offence. So it will either come in through direct liability or through contractual liability. The jurisdiction point is going to be interesting. Of course, the very wide jurisdictional nature of the UK Bribery Act really put the UK on the map to a certain degree in terms of enforcement. And there was a lot of work to be done to make sure that policies were compliant, not just with the FCPA, but with the UK Bribery Act. And we all remember the times when we were finding how much wider the UK Bribery Act was than the FCPA because it covers private bribery. So there does not need to be any state official involved.
Alison, if I could ask you, more than just whether it covers commercial bribery, do you believe that it will apply to the same kinds of companies that the UK Bribery Act broadly applies to, including sisters, affiliates, etc., or do you think it'll be more narrow?
It will apply in a very similar way because they've used that same associated person definition. So anyone, any company that's performing services in the UK will have a risk directly. The jurisdictional hook that's currently in the Act is slightly different, but if you have any part of your company outside of the UK that does business in the UK, you're likely to have a risk. If there is any potential for there to be victims of fraud of your employees located in the UK, you're going to have a risk. But you're also going to have a situation where if you perform any kind of services, your company performs any kind of services for a UK company, then there is potential for you to be required by that company to comply. So the jurisdictional reach will probably be slightly less than the UK Bribery Act, but not by much. And because of the very complicated nature of the jurisdictional hook, if it remains as it does at the moment, I think there will be good sense to be had in making sure that if you are required to be UK Bribery Act compliant, you're going to need to be compliant with the failure to prevent fraud offence as well.
Alison, we have you for about another minute, and I wanted to take advantage and ask you about if the UK authorities and the US authorities are doing a parallel investigation, how should companies, wherever located, think about that?
So in a minute,
yes,
I would say big factor always in investigations is that our laws of privilege are different, and how we maintain privilege in investigations is very different indeed. We have a very narrow definition of client here in the UK. The sort of head in hands moment for me as a UK lawyer that is involved later down the line is where that's not been appreciated early doors. Secondly, our interaction with law enforcement is very different. I spent 10 years inside a US firm as the London office, and that was a constant source of discussion is how we engage with UK authorities is very, very different. When I first began inside a US law firm, had never heard of the term proffer or reverse proffer, because that's just simply something we do not do with the UK authorities. So engagement is different. And timelines can be very different too. They are more structured and rigid in the UK. And that means thinking very carefully about how you're going to have parallel discussions with both the UK authorities and the US authorities and keep the process moving.
We'll talk offline about a full-day conference about UK-US investigations, Alison. We're out of time. Unfortunately, as I said, we were so lucky to have this amazing group of panelists. Unfortunately, we had them for a very short time. Para los que están acá, vamos a proceder al primer piso al almuerzo.
We are going
else, thank you so
to
much to the
lunch
panelists. Really great job,
in
guys.
the
Thank you.
first floor, second floor.
Thank you all.
Thank you.
Und alles, was ich höre, ist Sunny. Yesterday my leaves was still raining. Sunny. You smiled at me as the leaves. Now the dark days are done and the bright days are near. My sunny one shines so sincere. Sunny one so true. I love you.
Reckon if I focus my energies, I can become something. Am I gonna work there much longer? No, I'm not gonna work there. I'm a driver, I'm a winner. Things are gonna change, I can feel it.
full of contraband. Swimming underwater like I'm Aquaman. I used to drink gin, now it's vodka, man. Boss dog is a baller, no propaganda. Pop your band, don't try and stop the plan. I rock your land, step back and pop your man. Spaced out, caked out, no bubble boo, flipped out, ripped out. Nigga, what it really do? Time brings change, so I changed my name. Trying to take flight while they clipping my rings. Groupie ass niggas see you tripping the game with nothing to gain. Plop, plop, popping out, bang. Can't let her, hawk a snacker, hip happer, click clacker, tip tapper, hip slapper. Ain't trying to act up, don't wanna act up. My nigga back up, nigga back up. Hey baby back up, baby back up. My nigga back up, nigga back up. Hey scoop the view, turn your track up. 30 days later, I'm back on the streets. Got a batch of bomb beat shit. I'm trying to eat feet to the pavement. Money, I'm craving it. What about the bitches, dog? Are you saving? Are you saving? Are you saving? Are you saving? Are you saving?
What is soul to soul? We're a sound system, an amalgamation of dance music. There's three of us from the north side and two from the east. And through our style, people just came to recognize us as the Funky Dreads. Well, trust has always meant a lot to all of us. For us to stay together, where one would make a decision and the rest would follow. I don't know, the way we talk, the way things should be, I guess the way things should go, soul to soul. I don't know, it took us a real long time to get things together, but hopefully we're on our way.
glow. The music gives me sun when winter starts. She told me at the baseline, everything will be alright. She told me that the beat is mine, it will rock us through the night. And where I go, can't explain, I'll never know, but it's beautiful. You can't take this away from me. Oh, the way I hear the melody, the waves bring clarity, running through me. Come on, y'all. You can't take this away from me. Oh, the way I hear the melody, the waves bring clarity, running through me. Rio bonito, alegre, festivo, amigo. Rio de sol, de chuva, de verão. De praias bonitas e meninas também bonitas. Samba, futebol, amor e carnaval. Rio da alegria geral. Festa na cidade, festa no morro, festa na cobertura, festa no barraco, festa no clube popular, festa no clube fechado. Rio, Babilônia, Babilônia, Rio. Rio, eu sou mais você. Rio, onde tudo pode acontecer, meu Rio. Rio da vacation every single day, cause I love my occupation. Ay, 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 I'm on vacation. If you don't like your life, then you should go and change it. Ay, 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 I'm on vacation every single day, cause I love my occupation. Ay, 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 I'm on vacation every single day, every single day. Every single day, every single day. Every single day, every single day. Everybody sour like a lemon tree. I'm just smiling down upon my enemies. Do the shit.
Okay, we are back after lunch for a panel to discuss how to come back to business, right? After going through a big corruption scandal. As you may all know, Odebrecht was involved in one of the biggest corruption scandals in the world, and it settled the cases, I would say, with the authorities. Rafael Gomez, he's the Chief Compliance Officer for Novonor, formerly known as Odebrecht. Richard Bistrom, to my right, he used to be top international sales executive. He developed a very successful career. Later on, he was convicted for corruption. Nowadays, Odebrecht is back in business. Richard, you have become a leading figure in the compliance, I would say, practice around the world. So the key point is to discuss with both of you guys how to make that transformational journey possible. Okay, you have been through a lot, the company and the individual in this case. It's a fantastic opportunity to have both of you together. When we were preparing the panel, we identified some points in common and some differences as well, but both were emphatic in identifying cooperation as the first step into, let's say, remediation, okay? How we get out from that and make it an opportunity. Rafael, let's start with you. What can you say about cooperation in the Odebrecht case? What did cooperation mean?
Muchísimas gracias por la invitación.
Thank you for the invitation. It's a pleasure to be in Buenos Aires. For many years, I was responsible for a company.
Thank you for the honor to be here with Richard. Yeah, well, when we talked about, what from the moment you start cooperating is the moment you start healing, and it's the moment you start dealing with the issues. And then that's, depending on how you do it, it will define how much success you're going to have in what comes later, which is, okay, it is past us, it's behind, but then now we need to go to the different stakeholders and make sure that we're welcome again, that we're, that we're actually going to have projects and we're going to be able to build, new highways and airports and refineries and whatever, the challenges that may come. And I'm not sure if you know that in terms of, just for one example, Odebrecht built in distance highways that could connect Buenos Aires to Moscow.
Wow.
And then you have other examples like having built 4 huge hydroelectric plants, power plants, in 4 different countries at the same time. And there are companies that have never been able to build one that size. And now this is this uphill battle to make sure that we regain trust, that we reopen doors, that we tell people what we have done in the past 7 years to fix, and to be accountable for the mistakes and to fix, many of those, and a total, reform in the company in terms of having the priority to act, with ethics, integrity, and transparency. And this is the journey we've been on for 7 years now.
Wow. So, I'm used to hearing enforcement authorities talk about cooperation as a key element in achieving a successful result in any of these cases. I'm not so used to listening to, a representative of a company like yours that has been through a major case being so emphatic about how cooperation is the first step, right? So this is truly valuable, at least from the corporate side. What about you, Richard, as an individual?
As an individual, I would, well, first, it's such an honor and pleasure to be here, Gustavo, and to the Marval team and Rafael, and to join this interesting individual and corporate perspective. And as Rafael said, when you make the decision to face justice and not to delay it, it's a line in the sand moment, because from that point forward, your life, your behavior, everything you do is going to change. So there was a great quote from the Hiltrud Werner, who was on the supervisory board of Volkswagen at the time they went through the diesel scandal. And during a press conference, she said something I'll never forget. There are 3 stages of this process. Shock, when you get a call from the Justice Department and UK authorities that you're the target of a criminal investigation, there's the shock. And then comes the shame. And there's no way to mask that. You are filled with regret, you're filled with shame, and from an individual perspective, like I found that I had to embrace that shame and embrace that regret and not to try to say, well, it wasn't that bad, because it was that bad. And my behavior was that bad. And I think when you go through those 2 steps and embrace them and don't try to engage in ethical spinning, right, then change becomes possible. And I'm talking about, like you've been sharing, we're talking about real change on a personal and professional level.
So you would also say that cooperation is relevant in terms of starting that journey into change?
Absolutely. When I got a call from my attorney that I was the target of a criminal investigation, he said, oh, well, we have some choices. We can challenge the government's evidence, or, you know, we can cooperate. No offense to the attorneys here, but I said to my defense attorney, can we just save that billable hour? Because I did it. You know, I engaged in a decade of misconduct. And I said, I didn't take this international job to end up in prison. So, you know, it was an emotional decision. And I said, if I wanted to change the trajectory of my life, I need to face justice. And that meant telling the government crimes that they knew about. But you look at my plea bargain, most of the crimes that are on my statement of defense are bribery conspiracies that I told the government about. So as the Justice Department said to me, you either cooperate or you don't cooperate. There's no such thing as midway cooperating.
Selective cooperation.
Selective cooperation.
It doesn't work. And it's one of the things is that once you start that process, it may be that you don't, as a company, it may be that you don't even know how much is going to come up, right? And how bad it's going to turn. But once you start, there's no going back. So you cannot just say, no, oops, I changed my mind. No, and then with that, you end up providing information. As we were saying, the countries and the businesses, they're not contained within walls. And so you're doing business internationally. You have operations in 23 countries at the time. The problems could be, you know, anywhere and everywhere. And then comes the problem with, I think that there was a question here today about how the UK and the US, there's an investigation and it's in parallel. So think of dealing with 20 or 10 different jurisdictions, different maturity of compliance-related laws. Some don't even know what a leniency agreement, you know, was at the time. They wouldn't know, and they wouldn't have procedures, and their prosecutors wouldn't be allowed to bargain. They cannot agree on a lesser charges or something. Oh, I'm obligated to go, you know, and all in, and then it's okay. Then it doesn't work. You know, kind of cooperation is this? There's nothing in exchange, and so this ended up where we are today, where the company has reduced probably about to a tenth, if you think of the engineering and construction business. There's some other businesses that have different dynamics, but in the engineering and construction business, one of the biggest customers is government. And if not, you have projects that are financed by multilateral banks, and then you're also not going to participate in those, and you're going to be banned in some countries. Some other countries are going to treat you just like expropriate your assets and seize your accounts and freeze your accounts, and you're just simply, you're gone. And some other countries, we were able to sit at the table and try to come to, you know, to terms. And we're still, you know, still doing that, still reopening doors. Still, my agenda is 2-3 times a week. It's an international bank that is financing a project, in Peru or in Africa, and wants to know, what do you do about all that mass, right? And we're telling the story and explaining how our compliance program has evolved for 7 years, and how the compliance program has become a part of our day-to-day of our work. Our employees know what they're supposed to do, what they're not supposed to do, and it takes a lot of energy to keep that, up, because it's not like, okay, we're done. No, you're never done, right? And we're investing, and we've invested $100 million in our compliance program in 6 years, the group. So, and we're not stopping. I have 20 people on my team only for the engineering and construction business, and we keep pushing for, for improvement, and to make sure that compliance that people embrace the culture of compliance.
That's a clear message, for sure. And it's interesting, I can relate to your description on how investigations for these big cross-border corruption cases go, where companies, in the end, face a team of prosecutors from different countries, a team of judges involved, a mix of different regulations, and I really loved what you said, with different levels of maturity, right? And those prosecutors have different types of capacities to settle. Some of them can, some of them are not allowed to settle. So it's really, really complex. Again, it's fantastic that you mentioned that.
Different levels of political will and resolve as well.
Absolutely. So we've read, and there is a lot written about the Odebrecht case, right? And there are documents available, so lots of information out there. But Richard, in your case, there isn't that much of information out there, but you've been through a lot, right? We have talked about this many times. You were under investigation by the US authorities and the UK authorities, and still you are one guy, right? You're an individual, you're not a multimillionaire, right? So you had to make quick decisions on how to behave, and you were able later on to capitalize on those very, very tough times and use that to somehow explain to companies the situation that Rafael is explaining, along the same words. How was it for you to be under investigation by the US and the UK at the same time as an individual?
It felt like a lot of trains were heading at me at once.
A lot of trains, a lot of trains.
The least.
And those were big trains, right?
They were big trains. And Dan earlier in his panel talked about parallel investigations. It's nothing new. I was carbon copy prosecuted by the Crown Prosecution Service and the Department of Justice. But when you're cooperating, that's a lot easier, because then at least I was able to sit with my attorney, with the Department of Justice, with Crown Prosecution Service, including HMRC, Revenue and Customs in the UK, and we were all there to work together to come up with a settlement and a charging document where both the United States and the United Kingdom authorities felt like justice was done. And in my case, it meant that some of the trade violations that occurred, because the UK nexus is that I was living in the United Kingdom for part of my 10 years as a sales executive. So they wanted to charge me with trade offenses. And the way that they work together is the United Kingdom said to the United States, as long as you put those trade offenses in his US charging documents, we're satisfied that justice was done and that he'll pay the price for what he did when he was over here, as opposed to opening up a new case in the United Kingdom, which would have made a lot of things complicated.
Wow. Which is a difference from the corporate side, because on the corporate side, because there are lots of penalties to be paid, damages potentially, and contracts that are to be earlier terminated or not, when unilaterally, fairly or not, it doesn't matter. In the end, those, there's not the same principle doesn't apply, which is one country charges you, maybe the US, the Swiss, and the Brazilian authorities split the first big fine, But then again, each and every country wanted their piece, because there was also ramifications here, and you have to pay for what you've done here. So that's a multiplier effect of those consequences.
Yeah, certainly complex situations, right? So Richard, you know that investigations is one of the big topics for this conference. I mean, it has been over the years. And we have discussed how stressful the situation was for you when you were interviewed by US authorities, UK authorities, and also by the company during the internal investigation, right? And you were able to draw some important notes there on the investigation or the interviewing techniques, I would say. Without departing from the main topic of the panel, give us a few comments on this point particularly.
Yeah, and I would reflect on what Florencia and Maria had to share earlier today about the soft skills of conducting interviews. So when I got called in that I was the target of a of a corporate investigation, like I knew what was going on. I wasn't surprised by the call. And Dan and I have talked about this before. I was relieved. That's not to say I was happy that I got caught, but there was some sense of relief. So I walked into a meeting with internal counsel, external counsel, internal investigators, and external investigators, and me on a Sunday. And remember, I'm wanting to tell my story. And I think the external investigators wanted to demonstrate the value that they had to their corporate client by yelling at me and shouting at me.
That's value.
And trying to catch me in a lie, right? Instead of like being patient and let's peel one layer, he's talking to us. And it was a miserable experience. In fact, so miserable that I said, my attorney said, if you want us to continue to cooperate, those external investigators can no longer be in the room because they're not serving any purpose. He wants to talk and they're preventing him from doing so. So really think about the soft skills, because I think there can be mutual respect. Even in that shock moment, I think both parties can respect that, okay, everybody has a job to do here. It's not going to happen quickly, but let's be patient. And that was the opposite experience I had with the prosecutors, who were very, very patient.
Were you given an upjohn warning in that situation?
I didn't even know what upjohn was until I started going to compliance conferences.
Yeah.
And then I'm like, I never got one of those. Yeah.
Yeah, so that's also something that there's this book called Trapped by John Hagen, I think, where he explains how sometimes when companies are trying to do what the government expects the company to do, so they believe that they're acting legally in the correct way, how ethically they are just throwing people under the bus and just disregarding rights, basic rights, and things that should be observed as the upjohn warning before starting asking questions about something that could potentially incriminate that person later on.
Absolutely. One of the points that we raise every year at this conference is that an internal investigation that is poorly handled will put the company into much more trouble than it had before, right? So an internal investigation is a tool. You can use it for good or for bad. I mean, it's no guarantee that it will work unless you use it properly. That being said, let's dig deeper into the steps to recovery. Both of you have a clear idea of where to start and where to continue. So, Rafael, let me give you what I think is in people's mind on how to turn around the company that has been through a huge, massive corruption case. Simply replace everything and everyone. Is that the way?
Well, first of all, that works for a company that is a true corporation in the U.S., where shareholders and the executives have no relationship, right? They're not the same people, they're not the same family, and so on. So, in a situation like ours, it isn't that simple. We have actually had 75 of the top executives of the company leave the company Some of them immediately after the cooperation, the settlement. Some with a timeline because they were the people who knew the business. They were the people who you cannot just throw the brain of the company away and think that the company will continue to work. It is not, right? And so it took a couple of years until all those 75 left. But that's one part of the problem because sometimes the person who's been through it, it could be that person would be less interested in getting involved again than anyone else who hasn't, right? So you're not talking, as we have been studying in behavioral, economics and studies show that people do not do bad things because they're bad, right? They do stupid things because they get into traps. And I think your experience is amazing for that, is how is it that you get entangled in that situation in a way that when you see you have crossed the line and way crossed the line and many steps beyond the line. And that is a challenge to understand that it is not only about firing people, right? And say, now we're a new company. No, because the people who are working underneath those people and the next level, they have all been in the same company. And then that's where the culture has to play, a big part. Is how is it that you make compliance a part of a culture in a company that has not had that for decades, right? Or at least not in the form of what compliance, we understand compliance today. And so I think this is one of the biggest challenges, was to lead people to understand that survival for us means being compliant forever. So there's no third chance, right? And even the second chance is not that easy, so you don't want to have to come the second time around and say, we did it again. No, that's not going to work. You're done, right?
Yeah, absolutely. So Richard, you completed your, let's say, transformational journey, to use the words we chose for the title for this panel, by becoming a consultant, and again, a leading figure in the compliance practice around the world. When did you start thinking about that? How to take those trains coming at you and turn that situation into an opportunity and own what you had done, right? What was the moment in time in which you decided to go that way?
It was almost an accident. And when I got home from prison, it was December 2013. So in early 2014, Gustavo, I'm diving into the compliance field. I'm just so interested to see what's going on. And I saw that there was no shortage of well-experienced, fantastic practitioners coming from the legal profession, the forensic profession, the investigatory world, and then just general practitioners. And what I didn't see is anyone talking about what it's actually like out there to be tasked with commercial success in high-risk and volatile regions and environments. So with no business model at all, I just started to write about it. And we're talking long, like 3,000-word pieces, and putting it out there. And I'm like, if this story can help organizations look at their culture, like, are we incentivizing people to do the right thing, or are we giving them mixed signals, right? I'm happy to talk about what that looks like. And after about a year of writing, it's sort of when we connected on social media, and I was asked to speak at compliance events and anti-bribery conferences. And by the way, my judge, I could not travel during my supervised release. So it wasn't until 2017 that I had my civil rights and my passport restored. And I got caught in 2007. So this was a 10-year journey from start to end. And at that time, I was being asked to come to organizations and speak to their compliance teams or their commercial teams. It was sort of a cautionary tale type of presentation or workshop. It's much different now. Now I have the honor and privilege of flying all over the world, talking to leadership teams. And what am I talking to them about? Culture. Not you need a better third-party risk management platform, or you know, you should look at your due diligence. It's how do we shift this conversation from risk to responsibility? And that's a business responsibility, not just a compliance responsibility. So in some, Gustavo, for what I do now, it started off just by blogging in 2014 and seeing if it could help organizations and people avoid the situation that I was in because it was totally avoidable, and it's also not all that unique.
Well, we can say that was very successful blogging, okay?
Okay, thank you.
So
The culture, about culture, Gustavo.
yeah, I was about to ask about culture, so go
Yeah,
ahead.
so this is something that when we look at what happened with the company from 2016, when the company starts cooperating, and mid 16 also, there's this commitment that is signed by all executives that we will from now on comply with, you know, there's this acting ethically with integrity and transparency, and then there were like 10 commandments that were signed by, you know, the top executives in the company, and that was the first push of that program that for 6 years now was monitored. First, the monitor worked for the Department of Justice for 3 years, and one of the things that they would do is interview people from all over, all hierarchical levels, all departments, to understand how is it that people perceive the compliance program, how is it that people perceive the message that they're receiving, if it's clear, you know, what they're to do, they're not to do, where to go for help, where to go for, you know, with a tip, with a whistleblower, etc. And that has been happening for 6 years now, and we've just received the final, you know, report from the same independent monitor who worked for the Department of Justice and then for the World Bank and the IDB, and stating that the company has actually embedded the compliance program into its day-to-day operations, and this is what they found. And that is, I think, the most important. What was the question here? Someone asked earlier today, you know, give me one thing. I think that one thing is culture, and I think this was the answer earlier today.
Yeah. And so, are you done with culture at the company?
We're never done.
You're
We'll never be done.
That's the point. That's the point. And indeed, it's interesting because in the end, that's the standard that is expected from any company, that the compliance program really lives within the culture of the company. So it's nothing special because the company was involved in a massive corruption scandal, right? That's what should be expected from a compliance program. Try to influence people's behavior by becoming embedded in the company's culture. So, Richard, I'm asking the 2023 Richard now, okay? So, it's the international expert in these kind of topics that not only learned from his own experience in the past with the authorities that we just discussed, but also learned from discussing these topics with other leaders around the world, major companies and other experts in different regions of the planet. So what would you say are the key elements for a company to achieve the type of culture that a compliance program requires?
Yeah. It might be worth it to take a survey using one of something that Maria shared earlier today, is to ask your business teams, do you feel that ethics and compliance is adding value to your work, adding value to your company? So I think one of the measures of this is really how this is all embraced by your business peers. And I think that's where we're a little bit stuck, because we've built these great risk and compliance platforms, right? But they're still stuck in the ethics and compliance department. Mm-hmm. And that's been a bit of a problem, because I don't think leaders appreciate, and now I'm speaking a little bit as former commercial Richard, that when ethical expectations are coming out of the voice of business, not just the voice of compliance, that it sounds so much louder, because like you talked about, Rafael, doing what's right isn't a support function around here. Doing what's right is how we conduct ourselves, and that's a corporate narrative, not a compliance narrative. So very often I'm asked by a compliance leader to try to help empower their business peers to appreciate that now the great risk platform and box has been built, Now it's time to hand it over to them to help them make better decisions, right? To help them with decision making so that they have a balanced mindset between risk and innovation, which go hand in hand, especially now in a time of economic uncertainty, where people might think of three things if they think their job is on the line: me, and me.
Yeah.
So that power of the corporate narrative is so powerful right now.
Absolutely. So you both mentioned that enforcement, right? Investigations, regulation in different countries may differ a lot, right? What about culture for a cross-border company? Or in your case, I mean, as an expert, you have discussed this topic with many companies. In your case, you are living it, right? So how will the fact that the company operates in different countries impact in the goal of building this type of culture?
Wow, we've just faced that with, we put out this very comprehensive Respect Transforms campaign. And it's, you know, about promoting respect for, you know, for the colleagues and the employees, and respecting the workplace and all of that, and avoiding workplace issues and harassment and discrimination and other issues that we may find. And when we were looking at that campaign with the eyes from the perspective of someone in São Paulo, Brazil, and then thinking, okay, but does that message resonate in the Northeast, or in the Amazon, or in a construction site in the middle of nowhere? And how about Africa? How about Angola? And so one of the things that we've tried to make sure we have in that campaign is that we invited people from Angola, women and men from Angola, to try to understand at what stage they were discussing some of these issues, and whether we would not sound like, you know, bringing something extraneous that they would look at and say, what are you talking about, right? And we felt that with compliance programs from the U.S. in Brazil 20 years ago. You know, they would bring the program packaged and say, you know, this is what you're doing, this is what you, this is the message, and you would receive that feedback. It was like, you know, it doesn't, you know, it doesn't resonate with us, right? And so that effort of having to, you know, try to understand where that, you know, society is in terms of the, you know, respect for women and the place that women has in the society and all of that. And of course we have our rules, and we want to push for that within the walls and within the company. Those are the rules, but we also need to understand that there's some steps that they are yet to take, and when maybe we can help push for those steps to be taken.
Absolutely. Richard, any
I'm glad
comment?
Raphael went first, because I totally agree with what you just said. Just say no to bribery. I don't call that a policy. I call that a wall poster, right? Because that's not operationalizing ethics and integrity. And like Raphael just shared, like, this looks different in different parts of the world. It's not a one-size-fits-all problem or solution. So my experience with corruption in LATAM was much different than it was in the Middle East. And I think by inviting those teams in and having an open feedback loop is critical, because who knows risk best? The people who work in the middle of it. So by inviting your teams to say, okay, tell us about the stubborn and persistent risks, but more importantly, what are the emerging ones? What are we not thinking about? So we can help calibrate our code and our policies, our campaigns and our messages to the real world risks that you face. But if you don't tell us what they are, we're not going to know. So I think we really need to take the extra step of understanding, as Raphael shared, what does this look like where people work, and are we giving them the tools that they need in their operating environment to ultimately say no? But how you get there, that's much different.
You know, I remember a time years ago when we started the practice at Marval. There were cases in which you were facing this question. Okay, this person, you know, we have reasonable suspicion that this person has been involved in bribery. This person is a member of a company, right, an executive. So should the company fire that person or not? There were many positions that could be adopted. But listening to what you say, there should be a different question nowadays, which is, we have this person or these persons who cannot adapt to the culture of the company. So how do you identify those persons, and what do you do about that?
Well, I think first of all, the way we have divided the team and the functions within the compliance department is that we have those who work on the processes, like managing the hotline, or carrying out due diligence background checks, or the continuous monitoring of key sensitive transactions, high-risk transactions, and all of that. And so it's kind of more of back office type work. And then there's the field compliance officers. And so those are the people who are closer to the business. They are involved early on. They're looking at what's in the pipeline, what are the projects we're pursuing, and they are observing who are those business people that are truly in line and understand what we expect and bring issues up. And that's something that in the question of to what extent we add value, we have been more and more, we have been seeing people look for the compliance department to help them, manage a risk or manage a situation that they identify and that they know that it could potentially become a problem later, and they want to deal with it early on. And then there are those that let's say you present the result of a due diligence report that is all bloody, right? It's more than red. And you say, no, we cannot hire these people, right? And then you still see people saying, I heard that such and such company uses them, or that, maybe, well, it's not yet a final decision, unappealable, or what. It's like, come on, you start to notice who is it that's on board and understood and gets it, and those who not. And I wouldn't say that they do not fit. I think that there's also a lot of education that goes on using the cases and the situations to show that, you see, you were going to get in trouble with that. This was going to hurt you. And now you see, we didn't use these guys. Now we're on the TV, and then they're, all over the place, and thank God we're not using them.
Absolutely. Guys, we are reaching the end of the panel. We have 2 more minutes to go. So I will ask both of you to take 1 minute each and give the audience any final comments on this particular topic that we are discussing today. Richard, you can go first.
Well, I think, one of the things we really need to think about in our compliance journey and our cultural journey, which has no end, it's like cycling uphill, we have to keep doing it, is to really think about the current environment that people face right now. We've got economic uncertainty, anxiety, and stress in the workforce. We have more of a remote working environment where people might feel disconnected from the company, and they might be more willing to take a shortcut to show their virtual value to the company. So I think this is an important cultural moment to really focus on the workforce. And if you know the anxiety and tension exists, why not proactively address it? And if someone's not calling you with a problem that should be, maybe this is the perfect time to just pick up the phone and see how people are doing and see how they're managing and establish some really foundational relationships without a crisis.
Thank you, Richard. Rafael?
I think that the tension has been, growing and growing in terms of all the risks that we see. We have, the war in Ukraine and what else could happen, and you have, global warming, and you have all this crazy world where you don't know what's true or not because people just, distribute, facts or whatever, and in that environment, for you to try to get people focused on doing, the right thing and doing their job and not distracting with, everything else, and also mental health, which is another issue that we see that is terrible, and it's a growing problem, growing issue that companies need to cope with.
Absolutely. So thank you both. It's been quite clear that culture and people are the keywords, right, to keep from this panel. Thank you again. We will be back in 1 minute for the panel with forensic experts.
Right, good afternoon. Thank you for staying. And by the way, congratulations to Marval for putting on a fantastic conference. Welcome to everyone who's online here. And I have to say that it feels really, really good to be able to sit down. It's for those of you who've been standing up, thanks for your patience there, but it's been very nice to be in the back and now to be here in the front. So I'd like to introduce our panelists here today. Joining us from abroad, Carol von Tassel. I think you're based in Houston. If you're not, then please correct me. But Senior Managing Director from JS Held. We have Drew. He's based in Philadelphia and is a partner at Forensic Risk Alliance. And here joining me is Amanda Rigby, Vice President from CRA, and Michael Cullen, Senior Managing Director from FTI. I'm Geert Albers, partner at Control Risk, and I think that's about all the introductions you want to deal with. So let's dive straight into the panel. The idea, and when we discussed preparation for this, was maybe to share with you some of the new things that are happening, some challenges as well for investigators. So all of our firms, we conduct forensic investigations. Many of you have probably engaged with firms like ours. You probably don't want to, but sometimes it's necessary. And we'd like to just flesh out a couple of topics. We have a full 36 minutes, so it's about 9 minutes each. We'll speak very, very fast because there's a lot to cover. But I wanted to first start perhaps with a general backdrop around what's happening in Latin America and how that may have influenced or how it may be influencing particularly the corruption landscape and the types of investigations we're seeing. So for a number of years now, America's Society and Control Risks have put out a report called Capacity to Combat Corruption Index. Essentially, it measures the capacity countries in Latin America have to prevent, detect, and punish corruption. And I won't dwell on the report. We have another issue coming out at the end of June. But suffice to say that over the past few years, we've seen a regression in that anti-enforcement environment. And the reason I state that is because where we have less enforcement, and I do take Gustavo's comments to heart in his opening, that it's not just about enforcers, it's also stakeholders that influence company and individuals' behaviors. But obviously when enforcers are not as forceful, so to speak, behaviors tend to change. In parallel, and not necessarily correlated, we've also seen in Latin America since about 2018 the elections of leftist and populist governments. So Mexico, Argentina, Bolivia, Peru, Chile, Colombia, and Brazil. And I say not necessarily correlated, but obviously when you have political winds change like that, that does affect the corruption landscape just generally. And that's actually the first topic I want to chat about, and Michael, be interested in your thoughts there. So to the extent that that's actually a phenomenon that you also see, how is that changing the corruption landscape? And if it's not just a corruption landscape, just generally, how are the types of investigations you're currently looking at different given these political changes here in the past few years?
Okay, thanks, Git. It's great to see you again as well. Thanks, everybody. I think it'd be useful just to step back a little bit and look at what's happening in Latin America. But before we do that, I think it's interesting to address the issue of we're going through a time of really intense international geopolitical tension. So there's a hegemonic shift that's taking place internationally. And usually when that takes place, I know there's a lot of amateur historians in the crowd. We as lawyers, I think because of the precedent system, the stare decisis, etc., we like going back into history. And if you look at where there's hegemonic shift historically in the world, there's usually major conflict as well. So hopefully that doesn't happen. But one thing I do know, after I live in Colombia, in Bogota, but one thing I do know about this region is that overall global dynamic is going to have serious implications for Latin America. And especially in terms of supply chain nearshoring, which we all know is a big issue and we're all dealing with at the moment. But also the fact that copious commodities that are going to be critical for the energy transition now and in the future are based in this region, whether you're talking about copper, whether you're talking about lithium, rare earth minerals, etc. The other thing that we're dealing with on a global scale, which I think is pretty fascinating and also comes back and affects us here in Latin America, is the United States at the moment is very politically fragmented and polarized. So that is making the United States very inward-looking, and any external capacity it has to look at the outside world is becoming a Pacific obsession, not so much a Latin obsession. So if you take, let's unpack and unpick what's happening in Latin America at the moment, because I think that's interesting. I'm not going to go too much into history here, so just stop me.
I'll cut you off.
Yeah, I know Git will cut me off, but the Monroe Doctrine has survived in this region from the time of Simon Bolivar and the Argentinian and Chilean hero San Martin. And that was kind of the US's message from the Monroe presidency onwards, that you don't touch this region, right? Europe, back off, you don't touch this region. But because everything that's going on geopolitically, that has come off. So from my own personal experience, having worked 15 years in Bogota, Colombia, and in Colombia generally, if you look at the major infrastructure projects that have been won over the last few years, the majority of the major projects have been run by Chinese companies. So if you look at La Primera Línea del Metro de Bogotá, if you look at El Metro de la 80, if you look at La Autopista del Mar 2, if you look at all those projects, they're run by the Chinese, and it hasn't even raised an eyebrow in Washington, D.C. So the question then becomes, what does all this dynamic mean for corruption and enforcement in Latin America? And very quickly, before you throw a coffee at me, I think what it means specifically is three things. First of all, nearshoring is a big thing, right? Three things happened in the world that made nearshoring a really important aspect. One of them was COVID. COVID happened, and everyone's like, having our supply chain over in the other side of the world is not just logistically difficult, but it's kind of difficult geopolitically now. So that's going to be a problem. The other big issue was the emerging tension. China was the world's factory, and how do you replace that is a big question a lot of our clients are asking us at the moment. And the last thing is ever dependable Europe. Europe, the one we could depend on for all our handbags and leather shoes, was such a dependable location for supply chain. Unfortunately now, war is knocking back on their door in the form of the Ukraine and Russia. So what we're doing at FTI at the moment, how that's changing our work is we're setting the bedrock for multinational companies to come in and set up their supply chain. But they're worried about certain things in Latin America. They're worried about child labor. They're worried about environmental contamination. They're worried about antitrust. They're worried about all these issues. And yep, they're worried about corruption. Because as Geert was saying, those surveys show that it's a real issue here. And we know that because we've investigated in this jurisdiction for a long time. The other big part that's going to happen here is we're going to see a lot more Chinese business in this region. And that's going to lead to more issues of corruption, not necessarily from the Chinese companies, but from the Canadian companies, from the American companies, from the German companies, the French companies, who are trying to keep up. The motto, the maxim, and we're hearing this in our investigations at the moment, that's going to be prominent in those organizations is, we need to bribe to keep up. How do we get even with that? And that's going to become a major issue in those situations. So I'm going to stop there because you know me, I could talk for hours about this subject. I can get quite nerdish about this. But a question for you, Geert, which I think is really interesting, is the US, as they compete in Latin America for resources, for geopolitical influence, etc., they can either go down two paths as I see it. They can either use the Foreign Corrupt Practices Act as a weapon against their competitors, one competitor in particular, who'll go unnamed, or they can turn a blind eye to their own countries, their own companies' activities to try and level the playing field. And I'm interested which direction. I don't know the answer to that, and I'm super interested in it. And I think the more important question is how much of that decision is based on the winner of the 2024 US presidential election? Yeah. That's your question.
That's a question, great. So we have another 34 minutes, so I won't get into that. The one thing I would state, and I think you made an allusion to that, it's not it's not only about FCPA anymore. Of course, there are many other regulations here in Latin America, and I think Gustavo spoke to that in his opening. We're not just looking to be compliant with anti-corruption legislation, so FCPA continues to be, obviously can be weaponized. We've probably seen a little bit less of that of late. Since we're expecting maybe increased enforcement since 2021 or so. I think it's still waiting to come in some respects. But certainly, to the extent that there are interests in this region and that geopolitically they're becoming significantly greater over the last couple of years, I'm sure the U.S. will use all methods at its disposal, to be able to exercise influence here. So FCPA may be one of them. On the investigation side, just to get more granular, one of the topics, which is a really hot topic right now, and all of you in the audience will know about, are ephemeral messaging. So basically those messages that conveniently disappear, right? You send it and conveniently disappears. So we're talking about Snapchat, we're talking about Telegram, Signal. WhatsApp jumped on the bandwagon about 2021, and these are really proliferating, and there are good reasons to use them, sometimes not so good reasons to use them, but they do create significant headaches for investigators and enforcers. By very nature, they're there not to be detected. And one of the questions I have for Drew, because I know this is something which the Department of Justice has also issued guidance on. Drew, how are you actually dealing with this? What kind of guidance are you providing companies? How realistic is, in your view, the DOJ guidance, and how applicable is it? And perhaps talk about some of the challenges and maybe some successes where you've actually managed to recover information, because we all know emails nowadays are only used for legitimate corporate purposes and pretty useless for investigation. So, Drew?
Yeah, thanks, Geert, and hello, everyone. And I'll just step back because there's been a lot that has gone on in the last 15 months around this particular topic. So a bit of background, I guess in the past decade, we have witnessed exponential growth in the use of messaging apps. WhatsApp is the most used messaging app in the world, with over 2 billion active users and more than 100 billion messages sent each day. WeChat and Facebook Messenger round out the top three. As we've seen with newer modes of communication, such as SMS text, the ease of use and familiarity slowly transitioned into increased adoption within business over time. The pandemic and work from home era accelerate this proliferation. as virtual communications became the norm and lines between personal and business time further blurred. So you might not be surprised to hear the first order of business to organize for this very panel was to establish a WhatsApp group chat to communicate. This uptake has not gone unnoticed by the DOJ or the US regulators, as access to critical business communication on these apps continued to stymie investigations. In 2017, the DOJ issued guidance within its corporate enforcement policy to prohibit the use of ephemeral messaging applications not archived. In 2019, this restriction was removed if the company implemented appropriate guidance and controls around the use and retention of these apps. This guidance went undefined until the 2022 Monaco memo expanded on the DOJ's position, requiring a risk-based and robust compliance program, not only ensuring collection and retention, but also monitoring for and enforcing of policy violations. Meanwhile, on the civil enforcement front, back in December 2021, JP Morgan was fined over $200 million by the SEC and CFTC for having unpreserved business communications of their personal devices, including texts, WhatsApp messages, and personal emails. This was viewed as a statement fine within the industry and not just the cost of doing business. Just days after the Monaco memo release in 2022, an industry sweep settlement was announced where 11 of the largest banks and brokerages were fined for unpreserved business communications through messaging apps. Combined with the JP Morgan settlement, 12 firms were fined over $2 billion by the SEC and CFTC for these practices. And finally, in March of this year, the DOJ formally added ephemeral messaging policies and controls within its evaluation of corporate compliance programs, to be reviewed as part of any corporate resolution going forward. So, in terms of challenges, many companies continue to struggle how best to control, given the pace of technological change, encryption, and varied data privacy laws globally. There are middleware tools in the market, such as Fairwords, Telemessage, Movius, that preserve and monitor third-party applications, but by and large, the market is still developing, and there is yet to be a technological silver bullet. So yes, financial institutions have increased risks with the securities record-keeping requirements, but it's clear regardless of the industry, all companies need to deploy a thoughtful, meaningful, and risk-based approach to keep up with DOJ expectations.
So just on that last note then, a thoughtful, risk-based approach, what does that mean in practice? So I don't know, Amanda or Carol or Mike, I mean, what are you seeing? How are companies actually dealing with this? Because if you combine, which many of, I guess, your companies as well have, bring your own device, right? You bring your own company or personal device and you use it for company email traffic. You layer onto that encryption, and then you put some pretty bad intention over that as well. That's a bad combination for companies, right? So how do you actually deal with these types of things in investigations? Because I'm working on the assumption that, as we already discussed previously, emails are not particularly the most helpful source of information anymore for evidence gathering. I mean, you can't not look at them, but certainly the chance of finding something really problematic there is increasingly diminished. So I don't know if Carol or Amanda have any thoughts?
Carol, would you like to go?
Sure. I'll just say that for any investigation we're doing anymore, the collection and review of the ephemeral messaging is part and parcel of everything we need to do, and that's expected. when you're reporting back to the government. And when we're assisting clients on compliance programs, that is one of the things that we're highlighting is their need to have a compliance program that addresses that specifically so that it can be tested, that they're testing it on an ongoing basis, and they're collecting that information that they need to. And we do some testing around that. So, Gert, I'm still surprised what people will put even in emails, but it's fascinating what they put on the messaging boards. So,
yeah, it's scary what they put in messaging boards, actually.
We had one investigation in Japan, and all of it was through WhatsApp. All of the bad actions came out that way.
Yeah.
So it's just become a regular part of an investigation.
So I think the lesson here is that prevention and having clear policies in place is basically expectation, right? Clear policies around archiving and because as I said, ephemeral messages, you can program your WhatsApp to disappear after 7 days or 30 days, or for my personal messages, like 2 seconds. But for other issues, obviously a little bit longer. And it's important to have clear controls around those, including for archiving, so that they're not as ephemeral as they are, but they remain a very significant challenge and a growing one for us across the region. On the technology front as well, there's another, I would say it's kind of become an old theme, but it keeps evolving, and we had a conversation around artificial intelligence this morning. Artificial intelligence, we heard, is not new. But the applications of it are. But more specifically, there is a growing focus, and also from the regulators, an expectation that companies are conducting ongoing monitoring of pretty much everything: communications, transactions, anything that enables you to, in a more real-time, flag if there are problems in the company, as opposed to looking in the rear-view mirror when you do an investigation, find something happened 3 years ago. So Carol, on the data analytics front, because that's a large part of that effort, the guidance from the DOJ has come out for some time already. Companies have adopted. What have both sides learned? So what have the regulators learned in terms of how realistic it is and what they can expect? What are companies actually doing? And if you have some examples of where, for example, those types of monitoring mechanisms have worked or even spectacularly failed, I'm sure the audience would love to hear.
So, first of all, thank you for having me here, and I'm glad to be a part of the panel. And on the data and the analytics, I think it's been, a long time message, but the emphasis has changed, and the expectations, as you talked about, the expectations of the regulators, the DOJ, SEC, and those in countries around the world. We've seen this, if you look at we already had a panel talk about the DOJ and SEC imperatives, but if you look at FCPA at least, the ephemeral messaging was a big issue. Financial incentives or disincentives related to compliance programs is a big issue. And the third was data analytics. And you've seen a change because they've brought people in like Matt Galvin, who was at AB InBev, had very much a focus on this kind of continuous monitoring. So I think what has changed is it's been talked about for a long time, but the expectations that it be part of your risk-based approach has really changed. I've seen that not only from the DOJ, but from Latin American countries where I look at document requests, and these are usually where there's either a Brazilian or Mexican from Mexico or other countries that they're in conjunction with the U.S. Working on a corruption matter. And if you get the information, a lot of it relates to what are you doing, because it's great to try to detect it afterwards. What are you doing from a data analytics perspective to try to prevent it? And so I think that's become more and more important for the regulators, and they talk about it in every panel that they're out there. Several years ago, I asked the question of whether DOJ expected continuous monitoring, and they said we would never tell a company what they need to do as it relates to their risk-based approach. It's all risk-based. And now they're being very clear that they want to see that as part of the risk-based approach. So
Karen,
I think
on that front,
yes.
though, what would you advise? Because data analytics or these types of tools, I mean, they're widely available nowadays, but companies at different stages of maturity in terms of their compliance program. Some have pretty archaic legacy systems still. It requires quite a lot of reorganization on the infrastructure front to be able to, at least the IT infrastructure front, to be able to run analytics successfully. What are you kind of advising companies that are kind of willing but not really yet ready, and how do they get ready in a way that will satisfy the enforcers, for example? Obviously, they're not looking to get into trouble, but we operating in a world where it's increasingly difficult to stay out of trouble. So I think it is. Yeah.
Yeah, no, well, what we're telling, companies from JS Held's perspective is that they need to be incorporating these into their risk-based approach, and that, the problem is, particularly for acquisitive companies or quickly growing companies, just the data, being able to obtain the data is a major problem. So I think, what we're telling companies, some companies don't know where to start. I mean, there's so much data. Do you want to talk about the data that comes out of the hotline? Are we talking about financial data? Are we talking about email records, ephemeral messages? What are we talking about analyzing? So I think, we're telling companies to think about the questions that they want answered. What kind of questions do they want to see? For instance, if their hotline is working and the message is getting out across the world, that they can record and provide information on issues around the world. You can have a continuous monitoring of that to see if it's always coming from the same countries, or if there's some countries that are just not reporting. Obviously adjusting for size and everything. But I think what I've gotten, I was on a panel with Matt Galvin and took the time to ask him some things. Some of the things they're looking for is consistency. Just recently, I think it was a DOJ official was asked about the use of AI in data analytics as part of the analytics function. And they said, listen, if you're using AI in other parts of your business and you're not as part of your compliance function, that's a problem. We expect consistency. And in doing that, what they look at is what information is available to the operations, or what information is available to HR, what information is available to others, and is compliance utilizing that information and making it part of what they do from a risk assessment perspective. Some things that I've seen work very well have been when we've done monitorships for companies, some out of Brazil, one out of Mexico. We've used data analytics to look at, whether there's any recidivism, and they've continued the bad practices. And it works very well to be able to do that. Where I've seen problems with it is we had a company that received a settlement agreement from a Latin American country, and they requested them to do continuous monitoring. Well, continuous monitoring is not the first step that you take in a data analytics program. You kind of have to walk before you can run. And so they were trying to do continuous monitoring. They couldn't even get the data together. Yeah. So I think what we tell clients is take it one step at a time. Make sure it's consistent with data you're using in other parts of your business, and don't try to overload the system and try to do continuous monitoring where maybe some data analytics and some ongoing monitoring is just best used in risk assessments, those kinds of things.
And the just a question for all of us here is essentially, it's one thing to have, resources, have your infrastructure set up for example, ongoing monitoring. But there are obviously significant differences between several companies in North America and many here in Latin America, different levels of maturity, different levels of involvement. Some are extremely advanced here in Latin America and probably more so than many companies in North America and vice versa. So are there any particular themes or ideas or experience you have in Latin America? And I'm looking at you as well, Amanda, because I know you used to oversee the Americas in a previous life. Any particular themes or any recommendation you make for companies here in Latin America, maybe not have all those resources and still have that kind of expectation on them?
Well, I think the biggest component is, where is your data reside? And so what do you have access to, and are you actively leveraging all of this data that you're collecting? And so as I look at a number of clients that I serve today and have historically served, it's really being able to help you understand what it is you have access to, what it is that's of interest to regulators, and where might you want to apply a consistent approach to be able to monitoring that data as it comes in. And I would tell you, once you start, it continues to evolve, because there are going to be data elements that are more important to your business today than that will be important tomorrow. So I think it's just staying current on what do you have access to, what's coming in, what is telling, and for some of it, it's what is the root cause of this information, and why do I have deviation in the information I have?
All right. I want to get to a very mundane but really important issue and challenge we all face, not just as investigators, as companies as well. And this is a reality I think many of your companies deal with. As a matter of fact, I'm going to first ask if any of you here have significant compliance budgets and you have sufficient, meaning you have more than you need, then please come to me afterwards and we'll set up a crowdsourcing for your colleagues, because it's absolutely a critical issue we're seeing across the globe. Then when we look at, for example, a couple of years back, right, in the midst of car wash, Lava Jato, massive anti-corruption enforcement, quite frankly, companies didn't really have a choice but to investigate. The regulators were pressing. Economic circumstances have changed quite dramatically since then. So, obviously there are many different countries across Latin America, but generally speaking, no country is really booming. Budgets are under pressure, and this is a real, I think this is a real challenge. You uncover something problematic, you flag it, or it's, through a whistleblowing line, it comes up to the, management, or to, maybe to your counsel, and you're forced to take some form of decision that you do need to investigate, but budget is an issue. And budget sometimes is a bit of a proxy, right? We don't really have budget for that. It's a proxy for I don't really want to investigate that, but let's assume that the client does want to investigate, but simply does not have the resources, or is willing to put the resource on the table to fully flesh out how you as investigators would like to or suggest to based on best practice. How do you kind of circumvent and work with this challenge? Because it's a real one. It comes up all the time. You submit a proposal and say, that would be great, but if you could make it like 30% of the value you submitted, we'd love to do all of it. Other than that, we're just going to find a different way to go about investigating. So, yeah. Amanda.
So I think it's...
If there's anybody from Guyana in the audience, I apologize for Geert's comments about no country booming. On behalf of the Guyanese, the panel apologizes.
On a small basis, right?
So I think it's important that we all recognize that, a timely and thorough investigation, it is a hallmark of any effective compliance program. So, it's not that you can do nothing. Your compliance program, ultimately, you need to follow the policies that you have set. So I will say, in a time where there's little enforcement, from a compliance perspective, it's a time of reflection and reviewing your investigative policies and the procedures to ensure that they're current. And one, looking at, does this match the risk tolerance today? And does this policy take into consideration the historical events, historical investigations that we've seen over the past several years? And does this reflect the root cause analysis that we, the organization, has performed? And if your policies are not current, I certainly encourage you to sit down with your compliance officers, with legal, and bring those current. Because first things first, When an allegation comes in, you want to look at that to say, does this need to be investigated? So is it a violation of regulation, violation of law? Does it involve financial statement? Does it involve executives? Is it something where we need to put forward the resources? And that takes place during triage and planning. So what is it we're going to do? Who's involved? Or is it something where an interview can be conducted? You absolutely can gain the information you need to glean through that conversation, and you can move forward. The next piece of that really is scoping. So once you've determined that, yes, this investigation needs to take place and that we potentially have a violation, or we have an executive officer or manager involved and we need to understand the background, you want to look at that and say, where am I going to get this information? You know, Gert just shared that we've all been part of large investigations where we would go image every laptop, we would image every phone, and we would talk to individuals 2 layers above the alleged and 2 layers below. We would collect vast amounts of information, really, really expensive. In today's world, you need to understand what is the information that you need. Who am I going to get that from, or where am I going to get that information? If the allegation involves a third party, it's likely going to be in some text chat. It's not going to be on a computer. So is it that we need to image someone's computer? Likely not. So you want to go and really understand, what is it that we want to get out of this information? What is it that we need to collect? The next piece is then to identify who's going to do this. I know for many of my clients, they've seen significant budget cuts. That means they've seen significant resources exited from the organization, and they have decisions to make. These investigations still need to be conducted, but who does them? So I think you have to look to say, one, it's frequently most efficient to have one resource complete an investigation from beginning to end. And so you look to say, do you have that resource internally? Also, is it technical in nature? Does it involve accounting? Does it involve the review of financial documents? If you don't have that subject matter expertise on your team, it's likely you want to outsource that. And then last but not least, certainly I know many of middle management have left organizations, moved on. We now have junior members of the team. I've seen far too many clients giving the entire investigation to the junior level resource who has no understanding of how to conduct that investigation. You are so much better off to identify a resource who can do an end-to-end investigation as opposed to using those junior level resources. Because do understand the cost of their compensation and benefits sometimes significantly outweighs the use of third parties, whether that be a consultant or whether that be legal counsel. And last but not least, I will say it comes down to reporting. Again, needs to connect back to your investigative procedures and your policies. But at the end of the day, far too many organizations are expecting that there are going to be complete reports. Gone are the days, unless regulatory matters require that it's a full report. An executive summary is likely sufficient. Again, you want your legal counsel involved in the type of reporting, but I've seen far too many clients relying on sufficient reporting that's extremely expensive when all they really need is to have the scope documented and ultimately what the allegation was. So I encourage all of you, take the necessary steps. Just know what the scope is, what do you expect to get out of it, who's conducting that investigation from end to end, and what do you need the final report to look like.
And yeah, focus I think is really important. And one other thing, having done quite a lot of that type of work ourselves and seeing clients obviously who are pushing back on pricing, there's and this is an expectation not only from the regulators, but I think it's also a reasonable expectation. One thing is conduct an investigation to find out what happened and root cause and like, as you correctly mentioned. The other is, of course, what it teaches you to remediate. And I think very often that part is underappreciated. Very often the compliance, head of compliance or head of investigations, whatever, needs to seek approval internally. They don't have the budget. They may need additional budget. So helping them clarify what the benefits of conducting the investigation are beyond just finding who done it, I think is very helpful. coming to the end of this session here. I don't know if there are any closing remarks. We have about 40 seconds, so I either speak very fast or we just bring this to an end.
Can I make
yes.
one closing comment, because I think it's important. I think for people that are coming outside Latin America into this region, be very conscious of the fact that you have unconscious, maybe sometimes conscious, but subliminal bias with dealing with a Latin American investigation. They're very sui generis from jurisdiction to jurisdiction. And I think in these kind of audiences, as a person that's lived in Latin America for decades, it can get a little bit overwhelming. People, foreigners coming and telling you how corrupt you are and how to fix it. But let me just leave you with one example about institutional integrity.
You got 4 seconds.
Donald Trump, I'll finish there. Donald Trump is currently facing prosecution in 6 different proceedings. If he is found guilty in one of those proceedings, he can still run for the presidency of the United States of America in 2024. Don Bolsonaro, the former leader of Brazil, has 15 proceedings against him at present. If he's found guilty for one of those proceedings, he cannot hold office in Brazil for the next 8 years. So be careful of your own bias when you come down into this jurisdiction. And I say that on behalf of all Latinos in the room.
On that happy note, Drew, Carol, Amanda, Michael, thank you very much.
Great.
Thank you.
Thank you.
Thank you.
Bye-bye.
Good afternoon, everyone. Thank you for joining us, those who are attending in person and those who are via streaming. Now, in this panel, we are going to discuss public procurement, criminal law, and compliance. Let me introduce our panelists. First of all, I will introduce Christopher Dukins, a professor of government contracts in the George Washington University and of counsel in Arnold & Partner, LLP. On the streaming, via streaming, we will be joined by Fabiola N. Rodriguez, head of white collar crime and defensive investigations area at the Marist Abogados. Fabiola will discuss together with our partner, Andres O'Farrell, head of our white collar and corporate crime practice area, about criminal issues related with public procurement. And for those who do not know me, my name is Lorena Schiariti, and I am a partner in the Administrative Law Department in Marval, O'Farrell and Mayral. Well, first of all, I will be summarize a description of our current regulation in procurement and compliance in Argentina. In general terms, our regulations are very modern. They address the main issues regarding compliance and public procurement. We have in the corporate criminal liability law provisions providing specifically that certain agreements with public entities should only be awarded to companies who have an integrity program. We also have a penalty of disqualification for entering into agreements with the government for companies who are convicted for a criminal crime. And in our procurement regulations, we have also provisions disqualifying companies that have been even prosecuted, not even convicted. If the company has been prosecuted for a crime against the federal administration, that company is not allowed to enter into an agreement with the government. This is the general regulation that we have in place in Argentina. But the issue that we are trying to discuss today is how effective these regulations are. In general terms, although the regulatory standard is very high, or is appropriate at least, the enforcement is not so accurate or not so deep as we would like it to be. From a local perspective, we are usually faced with companies which are have to decide whether to participate in a public procurement proceeding that they know is being performed in breach of the applicable regulations, or decide to challenge such regulations. They may also decide to go forward with those agreements and face the risk of the annulment of this agreement because of the breaching of the procurement rules applicable to it. In general terms, the companies currently are in Argentina, at least, are have a very different vision today to these issues from those that they had, for example, 2 decades ago. Currently, companies know that they face, if they move forward with a procurement proceeding which is not being carried out properly, they may face the annulment of the relevant agreement, they may face reputational damages, and as Andres will explain, they may also face the risk of being investigated for a criminal judge or a criminal prosecutor. So what is, which is the issue that we have if we may say that we have the proper regulations, but we do not have the proper enforcement? In general terms, what we see is that it's very difficult in Argentina to try to monitor, audit, or control in any way public procurements. First of all, because it is difficult to have visibility of these proceedings, even when the proceedings are being carried out by websites or platforms, public platforms. They usually do not include a lot of requirements that should be made in order to move forward with direct contracting in a public procurement process. That is one of the main issues that currently private companies face when they want to enter into an agreement with the government, and they know that the applicable procurement rules are not being fulfilled. And why is this problem also so difficult to solve? One of the issues is that we have means by, for example, administrative challenges or injunctions which may be filed at court, but usually those proceedings do not enable any party to make effective control of the procurement proceedings. Injunctions usually take too long, and when they are rendered, they are usually too late. The agreement has already been granted, so the injunction becomes moot. And we also do not have any process for particular private parties to analyze or challenge this agreement. Any administrative agreement does not have any suspension effect. So the procurement process goes on, and the particular does not have any chance to challenge this decision. That's why the conclusion of my description of the current regulations is that there is room and there is a need to improve means of control by private parties of procurement proceedings, and that we should find the way to make more transparent any procurement proceedings for any party to make all the filings, challenges, and suspend a procurement proceeding that is not being carried out properly. Well, now this is my view from the local perspective, and I will ask now Chris to enlighten us with some questions. Chris, how would you say that compliance, corporate compliance standards evolved in the United States?
It's a really interesting question. Again, I'm from George Washington University. I like to say we have the best public procurement law program in the United States, because we have only one procurement law program in the United States. So we've spent decades focusing on these particular issues. We just published a book called Ethical Dilemmas in Defense Procurement, and the chapter that I wrote in the book is Oxford University Press. It's available. What I wrote about was the history of compliance in the U.S. industry. What you saw in U.S. industry was in the 1960s, the major defense contractors, which would today be, for example, Lockheed Martin or Boeing, the major defense contractors had developed their own compliance systems inside as a way of gaining a competitive advantage with the government. Because at the end of the day, a government shares reputational capital with its major contractors. If Boeing is engaged in corruption, it undermines the position of the United States. So governments like compliance systems. They like to see the compliance systems. As a result, in the 1960s, 1970s, 1980s, the major defense contractors developed these compliance systems, and many of their lessons were carried into the compliance systems that were published by the U.S. Sentencing Commission in the sentencing guidelines published in the 1990s. So literally the lessons from the defense industry were carried into the sentencing guidelines, into the compliance standards that you're familiar with here. And those compliance standards then were adopted by U.S. industry in general during the 1990s. In the early 2000s, we started saying, well, what's going on here? The U.S. government doesn't impose compliance requirements on its contractors, but all other American corporations are racing ahead with compliance requirements. And that question had come up during the Bush administration, but during the Bush II administration, Dick Cheney, who was then the Secretary of Defense, had killed compliance requirements for the defense industry, partly, again, because the largest defense contractors were gaining a competitive advantage from having compliance systems. It wasn't until 2008 that those standards were applied more generally across the industry, and then there was an extra little fillip that was added in 2008. Not only the compliance standards, and the compliance standards that you're completely familiar with, the same compliance standards all over the world. Not only the compliance standards were applied to contractors in general, but also mandatory disclosure. Mandatory disclosure for major corruption, fraud, bribery, a significant overpayment. There are specific categories of misconduct that have to be disclosed on a mandatory basis. And that was in 2008, December 2008. In the winter, 2 years later, in the winter after the Brits passed the UK Bribery Act in 2010, we knew that they were writing standards for compliance in the UK. And so there were lawyers flying back and forth between London and Washington and New York over that winter of 2010, 2011. And we asked the question, okay, you're going to probably adopt our standards, which is what they did in the UK, but are you going to also impose mandatory disclosure? Are you going to say that when a compliance system coughs up a corruption, the contractor is legally obligated to disclose that, basically self-incriminate. And the British response from the Serious Frauds Office was, no, no way, we are not going to impose a mandatory disclosure obligation. So the American experiment is not so much on the compliance side, because the standards in the United States, both in corporate America in general and in the defense industry, the government contracts industry, are the same compliance standards. The interesting experiment in the United States is mandatory disclosure. How has mandatory disclosure worked? And is it a good idea to require companies to disclose corruption? Right?
Thank you very much. And how do you compare the U.S. standards vis-a-vis the European standards or Latin America standards for this kind of matters?
So if you look at the U.S. The FCPA guidance, the Foreign Corrupt Practices Act guidance, is published by the U.S. Justice Department and by the Securities Exchange Commission. Around page 53 or page 56, around in there, they talk about what a compliance system should look like under the FCPA, and they have these footnotes that are like this long. Because the compliance standards, what they're doing is they're citing compliance standards from around the world. The African Development Bank, the World Bank, everybody has the same compliance standards. So to answer your question, they're all basically the same. It's sort of a miracle of transnational exchanges among lawyers to create uniform compliance systems. So if you look at Brazil, you look at France, you look at all of the emerging standards around the world, they're all basically the same. The one in Mexico is the same because I teach with Max Kaiser, who's a professor, an anti-corruption professor in Mexico. I teach with him in Vienna. He stole my slides, went back to Mexico, wrote the Mexican law, and it looks just like the American standards. It's all the same. So the great news is that they're exactly the same. The difference between the European approach and our approach in compliance is as soon as a contractor is hired in our system, boom, they're supposed to have a compliance system in place. In the European, the European Procurement Directive, Article 57, which is really written with a lot of input from Siemens after the Siemens scandal, Article 57 only calls for a compliance system after something goes wrong. Selbstreinigung, self-cleaning. So that's what's built into the European approach. So you only, under the European Procurement Directive, you're really only doing compliance after something goes wrong. Americans, the Protestants, we believe in original sin. We believe that contractors are bad from the start. They should have compliance systems in place from the start. And interestingly, if you look at the UK, you look at France, you look at the member states, or the former member states in the European Union, they are uniformly requiring compliance system from the start. They're not waiting for something to go wrong. Now, so that's where the Europeans, we think that the next European Procurement Directive will take a more international approach and will require compliance systems from the very start. What's very interesting, though, and I really want to emphasize this point for you, Lorena, what's different in the American system versus the European procurement directives. In the American system, if you look at the sentencing guidelines, you look at our federal acquisition regulation, there's just a whisper about victim compensation. While in Article 57, in the European procurement directives, it's a blast. If you want to get back into the public procurement system, you have to make sure that victims are compensated. And I talked to the best expert. I talked to Siemens' former lawyer. I talked to Hans-Joachim Priest in Germany. I said, is this serious? Is this really serious? Do European contractors think that they have to compensate victims before they can get back in? And he said, yeah, absolutely. And if you see the things that are generated by the Commission, they're consistent again and again and again. You have to compensate victims. And that's remember, we started from talking about the fact that compliance is kind of a legal miracle, where you have these uniform rules being adopted all over the world. Well, if that's true and the Europeans are ahead on victim compensation, we can anticipate that victim compensation will be a very important consideration in public procurement systems all over the world. And that's a really important human rights issue. It's worthwhile focusing on thinking about.
Yeah, thank you. And how does this shape the corporate's global response to these policies?
So I think, and I start from the position that I've been a practicing lawyer and a professor at the same time over the last 30 years. So I kind of have a perspective of what a lawyer never wants to lose control of negotiations. A lawyer goes into negotiations and wants to know what the outcome of those negotiations will be and wants to shape them. if you're going into a system where victim compensation is going to be part of the settlement, if you're representing a company that is engaged in corruption and you know you're going to have to pay victim compensation, you want to figure out those ideas ahead of time. You want to figure out who the victims are, how they're going to be paid, and how they're going to be paid credibly, so that from a public perspective, remember the government shares your reputational capital. From a public perspective, it looks like victims are really being compensated, which means that if you're a transnational lawyer, you're facing an instance of corruption, you're facing a prospective negotiation with enforcement officials, you want to have that solution put together. Who are the victims and how are we going to compensate them? And it's not just the government. It's people who were on the bridge when the bridge collapsed in Genoa. Those are the victims. How are we going to compensate those people? Because otherwise the settlement, which in the United States, for example, is fully public, the settlement won't be credible.
Well, thank you, Chris. And now that we have analyzed or discussed these procurement proceedings and compliance standards applicable to them, Andres and Fabiola will talk about the risk that may arise from procurement processes that are being performed not properly.
Thank you, Lorena. I'm going to start, echoing your thanks to Fabiola for joining us today. Fabiola, I'll start with a very straightforward question, just jumping into the topic. When does sidestepping the administrative procurement regulations cross the line between a regulatory violation and a criminal violation? And I ask this specifically because I know that in Brazil, piling on of criminal and administrative sanctions is quite a hot topic at the moment.
Yeah, so thank you for the invitation. It's an honor to be here. And yes, Andres, it's a very nice topic. So when you think about between the administrative infraction and the criminal infraction, sometimes the legislator here apply both. So we have both sanctions. So we need to analyze the intent. And of course, if, for example, if the individual, again, an unfair competition, unfair advantage, okay, cross the line to the criminal. If I have a false information or false document, cross the line. If I have a collusion with the procurement side, the government side, cross the line. But sometimes we have, when we analyze, for example, the new laws, so the new administrative law and the new public procurement law, now we touch the basic topic here, the main topic, which is the non-bis in idem, which means the double no double punishment for the same cause of action. And when we talk about it, this topic, we know that nowadays we put a lot of pressure on the individuals and the legal entities to present, which Christopher touched, which means that we present it's mandatory to disclosure. And when we present the evidence, we have both sanctions. So in administrative level, the companies can receive huge penalties and the individuals for the same side in the criminal sphere. And when we discuss that, we always think about the guarantees of the individuals. And the base of the guarantees in terms of criminal sanctions, it's severe because we have restrictions of life. But in terms of, as Christopher mentioned too, in terms of recovery or pay the damages for the victims. And we know that our authorities nowadays in Brazil put a lot of pressure in terms of repair the damage. And we also establish it doesn't matter the evidence, the best way to achieve the non-prosecution agreement. So what was happening in Brazil is we face a lot of multiple agencies present some charges against legal entities and individuals for the same facts. And we don't have yet a good solution. So sometimes we have a guidelines between the Attorney General Office and the Public Prosecutor Office, so how to deal that. And maybe the best solution could be both authorities present one section based on the evidence.
Interesting. Maybe here in Argentina we'll soon be facing a similar problem because the distinction between administrative violation and an actual crime is becoming a little bit blurry at the moment. So traditionally, Argentine courts held that the mere failure to comply with administrative procurement procedures did not amount per se to a crime, so prosecutors were actually required to bring additional evidence showing criminal intent, sort of say bribery, undue benefit to a specific bidder, collusion between the bidders, or actual fraud. But there's been a very, very recent precedent by the Federal Court of Appeals based here in Buenos Aires that upheld the indictment of a public official exclusively on the basis that he did not comply with the mandatory administrative procedures to award a contract. So the distinction between crime and administrative sanction has become a little bit less clear now in Argentina, which will probably put both public officials and private bidders on alert, because the risk of criminal investigations into these proceedings has become a little bit higher after this precedent. But now, since we're talking about the criminal investigations, Fabiola, can you tell us something about how these investigations, criminal investigations, normally begin in Brazil? I'm sure you have some interesting stories.
Yes, we have multiple ways, multiple circumstances that we have multiple agencies and bodies that can start an investigation. So mainly we have the internal auditing that after the Clean Company Act, so we have a lot of internal audit that face misconduct, face of fraud that we can present or not. So one important point to tell you that in Brazil, it's not mandatory to present a crime or a fraud or everything to the authorities. So the company can start an internal investigation, they can found misconduct, but not necessarily present to the authorities. In case they present, we have a criminal investigation. Another way is the whistleblower. So we have a lot of, in the internal channel that we provoke, a lot of incentivations to the individuals present charges. So they can present charges to the company. If the company starts an internal investigation, the conclusion satisfy the employee, it's nice. If it's not, the whistleblower can go to the authorities, to the public authorities, and present the charge. Third, we have the complaint in general. So doesn't matter, each individual or legal entity can present a denounce. We always recommend to present a petition to write what was happened, collect the evidence, and then go to the authorities. Third or fourth, have the media. And the media in Brazil is something very, very, very dangerous sometimes because they present a lot of things without confirm if it's true or not. And when the company face, for example, a search and seizure in the television, they start internal crisis, and sometimes one solution is conduct an internal investigation, or we just go to the authorities that present something in order to collaborate. So we always incentivize that one good point is try to collaborate with the authorities. It doesn't matter if you have a lot of enough evidence, but this is a good position in terms of to mitigate in the end of sanctions.
Interesting. Very, well, quite similar to the situation in Argentina, except self-reporting. I would say that it's not one of the most common ways for these investigations to start, but I will also say that government auditing in Argentina is also one of the main triggers for criminal investigations into public procurement. We have specific agencies charged with auditing government contracts, and their findings can and do lead to criminal investigations. We also have a lot of cases of fortuitous discovery of irregularities, so much so that one of the most notorious cases of public procurement corruption in the early 2000s started with a completely unrelated investigations, with tax investigators literally stumbling upon a massive corruption case while following the trail of fake invoices for tax purposes only. International cooperation, I would say, it's one of the growing triggers of these investigations in Argentina. We have our own local version of the Odebrecht case, or spin-offs of the Odebrecht case here in Argentina, and a lot of them are fed by information shared from Brazil. Thank you, Fabiola. And we also do have investigations that have been triggered by whistleblowers, as is in the case with Brazil. Our own Odebrecht scandal, the Cuadernos or Notebooks case, actually started because the former wife of one of the co-conspirators decided to bring the case to the media, to an investigative journalist. So, how's that for a tipster? And finally, one of the main reasons that these investigations starts is because of the complaint filed by a competitor. When you know a bidding company loses a bid and they feel that the successful competitor obtained the award through unlawful means, they have every right to bring a criminal complaint, and that could definitely trigger an inquiry. So I guess that Fabiola, the reason, the lesson for both our jurisdictions is that these malfeasance in procurement, you can never bet that they will fly under the radar. It's a gamble. So now that we know how these, the difference between an administrative sanction and a criminal action, we know how these investigations begin. What type of crimes do law enforcement agencies normally look into in these investigations?
Okay. After the famous car wash operation, almost every investigation have corruption. The focus investigation and procurement irregularities, and because we have basically we have the Brazilian anti-corruption law, the improbity law, the public procurement law, and the penal code. So all this legislation touches corruption. And we have fraud, again, fraudulent activities. We have money laundering that they put together, and organized crime that increases a lot the measures to obtain evidence, and also the speed to press the individuals to confess. And we have some cases related to cartels. So this is not exactly what our authorities is enforced nowadays. They base mainly in money laundering, which touches almost every type of crime.
Interesting. So similar to what happens here in Argentina, it looks like prosecutors in Brazil have a very broad menu of crimes to choose from when investigating these type of activities. In Argentina, what I could say is that public prosecutors tend to look at different crimes according to whether they are investigating the public official or the private entity or individuals that participated in the bid. When they investigate the conduct of the public officials, they normally look into crimes such as abuse of power. That is, if the public official unduly exercised an influence over the results of the proceeding, regardless of ostensibly complying with the formalities. They look into conflicts of interests. That is, whether the public official in question has a vested interest in the result of the procurement. They look, of course, into bribery, the most obvious of the crimes that could be involved in these investigations, but also one of the hardest to prove. And they also look into what acts as a sort of catch-all provision, which is failure to comply with public duties, which they apply to when they cannot find evidence for a more serious crime. And when prosecutors look on the side of the private bidders, they analyze, of course, fraud, which is not necessarily tied to pricing or quality. I mean, fraud can also be committed by misrepresenting qualifications, misrepresenting experience, capacity, or by collusion with other bidders. So fraud is, of course, an element that they look into on the private sector side, and of course they look into bribery. And what we have seen is that there's also a specific crime that they're starting to apply, that prosecutors are starting to apply, when the companies involved are publicly traded or they publicly trade the securities. Because when these companies secure a government contract, say through bribery, and this contract has a substantial impact on their financials and therefore on the value of the stock, the company executives could face charges of securities fraud, and we are actually handling one such cases, one of these cases at the moment. So again, either in Argentina or Brazil, the type of crimes that can stem from these investigations is very broad. And finally, to close, because I see that we're running out of time, and I want to be respectful of the schedule. Fabiola, in Brazil, who faces criminal risks when a government contract is found to be awarded improperly?
Okay, so we have various individuals and entities that may face criminal risks. So it depends on the involvement of the wrongdoing. So basically, we have public, same in Argentina, probably. We have public officials that is really directly responsible for the procurement process. So such as government officials, politicians, and public servants, they may be involved. We have the private sector, the contractors, so the private individuals and representatives, and what we can call the intermediary. So the guy of the facilitates the contact between the acts and the illicit activities during the procurement process and the private sector. So these little guys that we don't have here in Brazil any regulation about lobbies. So sometimes these guys are involved in this type of crimes and it depends on the evidence. So one point I would like to call attention is the companies only follows the compliance mainly topics, which is almost the same around the world, but we need to emphasize the documentation. So how to prove that you are not involved, how to defend the company, defend the individual is based on the document. Sometimes they don't pay enough attention and it's really hard to not be involved in this type of investigation.
Interesting. Similar situation here in Argentina. Of course, public officials can be held criminally liable, and I don't mean the public official that actually signed off on the contract. Any public official that made a substantial contribution may face criminal liability. The same with the individuals on the private sector. I mean, although prosecutors tend to target high-ranking corporate officers, they have very broad discretion to bring criminal charges, and they can target any employee of any hierarchy or seniority if they feel that they had a material contribution to a crime. So there's basically no seniority threshold there that will protect the individuals from prosecution. And also something that I think that it's different from Brazil here in Argentina is that legal entities face criminal liability themselves, and actually quite important ones. So basically, everybody is exposed to criminal liabilities with basically no limitation, which leads to the last question now that we're running out of time to see if we can get it in. Is there anything that individuals and companies can do to mitigate these risks?
Yes. So yes, we have reason. We don't have corporate criminal liability in Brazil yet, but I believe that when we analyze the individuals, we don't really analyze the conduct, but if we have the cause of, if we have the link between the facts and the company, we can punish the individual. So in another way, we have corporate criminal liability because we have a lot of administrative sanctions. So in a practical way, yes, we can punish, but not in terms of corporate criminal liability. But answer your question, almost the same. So compliance programs, due diligence and trainings and internal reporting, and again, document retention. So this is one point that I would like to really emphasize. And when we start an internal investigation, sometimes we need to find more evidence to conclude in a way or another. And of course, to present this evidence to the authority to collaborate, to mitigate sanctions. So this is one point that I really would like to call attention.
Excellent, excellent. Well, similar here in Argentina. Of course, we work with our clients to build this evidence for the hopefully unexpected case that we need to prove to a prosecutor that the company actually had a genuine culture of compliance in place. So that is one of the main strategies, of course, that brings about a lot more detail that we cannot get into today. But building evidence towards showing a culture of compliance is a way for the companies to mitigate their own exposure. And in terms of individuals, this is also that there are also certain strategies that we can take at a corporate level to mitigate liability, which is essentially structuring, documenting, and actually enforcing division of tasks, division of roles, and division of responsibilities. So to create firewalls, so to speak, to avoid prosecution spreading to different areas of the company. So essentially, we have good mitigation strategies that we can work with to not to avoid, but to reduce the impact of criminal risks. And I think we're just about out of time.
Yes,
So I don't know,
yes.
Lorena, Chris, Fabiola, if you have an additional comment. I think we've managed to cover all of our topics.
Yes. Now we have the break, so we are finishing this section, and you may take, I think it is 15 minutes for the break outside. And thank you very much.
Thank you all. Thank you, Fabiola.
Thank you. Thank you all.
Bueno, continuamos con la segunda parte de este evento de compliance, investigaciones y anticorrupción. Primero que nada quiero agradecerles a todos por mantenerse ahí del otro lado de la pantalla viéndonos. Hemos tenido speakers de renombre muy interesantes, temas realmente interesantes discutiendo. Y ahora tengo la fortuna de encontrarme con Amanda Rigby, que es una de nuestras speakers de hoy, que habló en un panel hace un ratito. Hello Amanda, how are you enjoying this event?
It's a fantastic event, and wow, and surprised by how many people are here today. Certainly I know when Gustavo reached out to me to say that historically you've gotten 2,500 to 3,000 participants, I thought, well, okay, that's a significant amount of people to participate. But to actually be here and recognize that many are participating virtually, but to have another 300 professionals in the audience is, I mean, just a credit to Marval and being able to host an event of this size. You don't frequently have an event that is streamed where you have 300 attendees with another 2,500 to 3,000 participating virtually.
And we were just talking about how long you've been working in this area, and with your experience, how do you find the dialogue that we kind of try to generate here in these networking spaces, for example?
I have to say that this is one of the most relevant events I've been to. So as you just alluded to, I'm coming up here, I'm fulfilling my 26th year of being in forensic services. So compliance, investigations, litigation, e-discovery, cyber. And through the years, it's evolved over time. And what it meant, back in the early days to what it means today, certainly regulations have changed, laws have changed, the requirements of the compliance officer and the general counsel, they've all changed. But certainly, as I joined about 9 o'clock this morning and still here this afternoon, every panel has been relevant to my background. Every panel has been either with clients or with counsel who represent clients of mine, talking about topics that are near and dear to the agenda to most compliance officers, the general counsel, and of course the board of directors. I also love that you've been able to translate every panel. So naturally, Spanish, I am not fluent. I can understand some parts of it, but to actually be able to have the headset to have it translated directly into English has been really beneficial, and I would tell you I'd encourage anybody in the compliance and investigations space to attend next year.
Well, thank you very much. We talk about evolution in every single event we've had. This is the sixth edition, and every time we talk about evolution in this area, we talk about different things. So with your experience, what would you recommend people looking forward to what's coming next to confront evolution and to confront future challenges?
So it's been interesting because I think much of the theme of today has been around AI, it's been around ChatGPT, but also focused on continuing to have an effective compliance program, recognizing that budgets are being reduced and the constraints that provides for a compliance organization and a legal organization, but recognizing the regulators have expectations. And so I think what's been good today is talking about practically how do you have an effective compliance program, knowing budgets are being cut. What is it that you can do as a compliance officer or as counsel supporting a compliance officer in ensuring that there's still quality and that there still is monitoring within an organization, even with a reduced budget? As you talk about AI, and today several of the panels have said, well, AI is not new. That's correct. AI is not new. However, we use AI more today than we ever have, and that's going to continue to evolve. What we don't know is with the presence of ChatGPT now, will that be regulated? And will regulations impact how we use automation? And time will tell. So certainly I'm guessing it'll be a topic for next year's program as well. But I do think, as you think about planning for future summits, it has to be around data, the use of data. Data's the future, there's no doubt. We heard that 10 years ago, it's here today, we have to use it. We need to continue to use it. But I think for many of us, we don't necessarily know where the data resides. We don't know what the story is it tells and how to leverage that to our benefit.
Great, so some interesting points of view about the future, the present, and your experience. Thank you very much for being here. We are honored to have you as a speaker and as a guest here in Marval. So I hope you enjoyed the rest of the conference.
Thank you very much. I really appreciate being invited, and thank you to Gustavo for hosting such a wonderful event, and I look forward to next year.
Thank you so much, Amanda. Thanks. Ok, gracias. Thank you. Ahora se acerca Diego Fernández, que fue también es socio de Marval O'Farrell y además un speaker acá en dos de nuestros paneles hoy, ¿no? En dos de nuestros paneles realmente dinámicos y muy interesantes. ¿Cómo viene la conferencia? ¿La va disfrutando?
La verdad que sí, muy bien organizada me parece, los temas muy novedosos, algunos yo no hago tanto compliance en algunos aspectos, así que me pareció súper interesante, me gustó mucho la internacionalidad, hay speakers de todos lados, me parece que no está restringido solo a la Argentina, así que disfrutándolo un montón.
Hablando esto de quizás hay gente que hace más compliance, gente que hace menos compliance, pero todos tocamos una lista quizás del tema. Por ahí la gente del otro lado no sabe que se tratan varios temas, no solamente compliance, no solamente investigaciones forenses. Este diálogo de diferentes áreas que se genera, ¿crees que es enriquecedor, que nos sirve a todos como para aprender, tomar quizás de las experiencias de otras áreas y cómo trabajan?
Sí, definitivamente. Todo confluye de alguna manera en compliance, porque es la idea. Pero, por ejemplo, en mi caso me tocó hablar de ciberseguridad, que tiene que ver con compliance, me tocó hablar también de inteligencia artificial, algo bastante más novedoso, algo que no se venía dando tanto y charlando. Me parece que sí, porque como decían hoy al arrancar la conferencia, compliance se empezó siendo algo muy ligado a la anticorrupción y después se empezó a ampliar muchísimo y hoy los temas que uno ve dentro de compliance son mucho mayores de lo que se veían antes. Por eso que para mí ves la variedad de speakers que hay hoy. Hay speakers que hablan de derecho criminal, privacidad, tuvimos gente haciendo, como decías vos, forensics. La verdad, súper completo y creo que sí, que sirve un montón.
El panel justo de inteligencia artificial ha sido furor, por lo menos en estas entrevistas y con la gente con la que hemos estado charlando. Es un tema que está realmente en boga y realmente en la mente de todos pensando en el futuro. ¿Hay algo que nos puedas decir así como un resumencito por ahí para la gente que no lo llegó a ver en vivo y lo va a ver después? ¿Algún tema específico, algo que no queremos que se pierdan de ese panel?
Lo primero que diría es que tuvimos la suerte de tener a Agustín Huerta de Globan, que fue... Agustín no es abogado, Agustín es un técnico, una persona que sabe mucho de inteligencia artificial, y escuchar de primera mano ese tema, además que lo hizo muy divertido, creo que fue, estoy de acuerdo que fue un highlight del Summit. Después que vimos estamos en un estadio todavía donde se está viendo de qué se trata, de cómo se va a aplicar, cómo va a impactar en los negocios, en las compañías, en el compliance, y estamos justo en un momento donde están mirando tal vez los países un poco más desarrollados, Estados Unidos, Europa, si hace falta regular o no. Argentina está mirando también como todos los otros y creo que en definitiva lo que se va a venir, un poco como se decía en nuestro panel, es todavía no vimos realmente lo fuerte de la inteligencia artificial aplicada a los negocios. Yo soy un entusiasta de la tecnología, me encanta la tecnología, así que lo sigo de cerca a título personal y creo que viene por ahí, viene por un desarrollo, todavía hay que darle tiempo y hay que esperar un poquitito para ver cómo evoluciona y cómo va a afectar y cómo nos va a ayudar. En definitiva creo que ayuda muchísimo más.
Ahora vamos a aparecer ahí. Muy bien, ya estamos de regreso para el siguiente panel. En esta
Hello, we
oportunidad
are back for
tenemos
the next panel. Now we
la
have
suerte de contar una vez
the
más en la
luck
conferencia
to
con la
have
oficina
once again, as part of the conference, the Anti-Corruption Office, Veronica Gomez, the director. Thank you. Thank you very much. Thanks for your invitation. And as we were talking, when we prepared the panel, I told you that the Anti-Corruption Office has participated in each and every summit that we hold, and the institutional role that it plays in the fight against corruption in Argentina is very special. So we always welcome this opportunity to listen to what's going on at the office in the voice of the head of the office. So thank you. Along this line, my first question to you, and to start the discussion in these 25 minutes that we have. By now, the Anti-Corruption Office has an important number of projects and programs that are up and running. Some are related to sworn statements of public officials, not just the tax returns and asset returns, but we also have the RITE, which is the voluntary record of integrity programs that really was quite surprising. The National Integrity Plan, the Public Ethics Bill, the Network of Integrity, so on and so forth. So my first question to you is, which of these programs do you think caused the highest impact in the fight against corruption, and why? Well, it is hard to think about the impact that each program individually can have, because all programs are conceived under the logics of a comprehensive policy that wants to address prevention. So, of course, we do not exclude the investigative task that the office carries out, but we try to promote measures aimed at identifying risks and mitigating corruption risks, to promote good practices, and at the same time include a perspective of transparency in public administration. So these are not isolated tools, but rather connected tools. So if I had to choose one program, I would choose the National Integrity Strategy, which is, let's say, the result of the previous anti-corruption program. And I think of this strategy as one of the most important policies, because this strategy is a comprehensive, systemic proposal that allows the different government areas, organizations, entities, so on and so forth, can take ownership of certain basic principles and translate them into their own proposals, and that also can use for the benefit of their own needs. So this strategy has two main advantages compared to the previous plan. First, it is not conceived as, let's say, specific initiative with a beginning and an end, but rather a strategy that can include new initiatives or new entities and improve existing ones. And the other advantage that the strategy has is that it does not result in abstract commitments. That is to say, it is intended to include concrete initiatives that can be measured through indicators. Today, after several years since the strategy has been operating, 50 entities are participating, including ministries, And there are 90 initiatives, 430 specific activities as part of the strategy, and more than 1,000 indicators that citizens can monitor and track through a map, the state map, which is a very valuable public administration tool that citizens have at their disposal. So, this is worth mentioning because it is related to a conception of corruption that no longer thinks about corruption in a single side approach, but rather puts the focus on the crime itself, of course, but as a complex structural phenomenon historically situated that involves other actors and players as well. And this is very valuable because the state and public policies are not only perceived as a cause of corruption, but can also be thought as a contribution to solving this problem. And I choose this national strategy because all the other tools that you mentioned are under this strategy. So in the ministries, for instance, most programs were created based on this national strategy. The integrity network is also related to the strategy. The Integrity and Transparency Registry also helps us open up the perspective and encompass other stakeholders in the private sector. So I believe that the national strategy is one of the most valuable instruments that we've had. This is very interesting what you say, having this comprehensive perspective and view of the office, how each program makes and forms a whole. And it's not that you try to solve one specific problem disconnected from the rest. So there's an idea of looking into the future with a continuity of the office's efforts. And this point that you mentioned, the importance of having indicators to measure results. This is very, very concrete. And I wanted to also go back to the RITE. That is an instrument that was created as a registry where companies can spontaneously submit information about their integrity programs on a voluntary basis. Recently, one organization or one entity decided that some businesses, for instance, NASA, should be under this registry to operate appropriately. So how does the office take these type of decisions? Is there any communication? Is this an independent action by the SENASA entity, or is it different? In particular, the National Food Safety and Quality Service, SENASA, in Argentina. So RITE is a registry for integrity and transparency that Argentina developed together with the World Bank, the IDB, and the UNDP, that provides businesses a tool to promote and improve the company's integrity programs, and also NGOs and any legal companies and individuals, and provide state players more tools about who are their counterparts, that is to say, who participate in processes of procurement processes, so on and so forth. So this RITE platform was conceived to stimulate this type of actions, and there were some past experiences. For instance, the Ministry of Health inviting suppliers to join records and registries, or the National Procurement Office, that an integrity program according to the law could also be given through the RETEC or under the RETEC instrument. SENASA, the National Food Safety Office, well, we discussed this with SENASA, and it will be a challenge because it is something new, and we will have to evaluate. We will advise SENASA along the process to what extent these companies can comply with the registry. So, and we must say it, according to the resolution, it is a step-by-step compliance purpose. Now, the plan is to start with the bigger companies. There are some details to consider, but it is a challenge because it will be useful as long as businesses can comply with it and also get some value from it, as long as they can have and implement a good integrity policy at their companies. That would be a good advantage from it. So this is good news because we see that the organizations and entities are taking hold of this instrument, and it will be good to create a culture of integrity in Argentina. So that is the advantage and the good thing. But then we are waiting to see how the results are. Okay, so in the next year's summit, we will see how this registry has evolved. Yes, that's right. The challenge will be how we can work with the companies so that this is not an extra burden in their operations, and that it can be a good tool for the benefits of their integrity. You know that one of the topics that we've discussed today is artificial intelligence and its impact on compliance. You know more than me that the office has interacted with the foundation. So, in the light of using technology and AI as a help to our work, what do you think? Well, we have a collaborative agreement with the foundation with the purpose of developing mapping, interconnection, and data prediction model with public information produced and stored by state entities. This is public information which is today quite scattered and dispersed among different sources. So it is available, but we need to connect it. So in practice, this plan is intended to create a system of early warnings so that they can detect potential risks of non-compliance or potential conflicts of interest, and in this way improve the office's operations in preventive resolutions and case resolutions. So this agreement is still starting. It's very incipient, but I think that we are going to get to the end of the year at least formalizing the design of this tool. And we hope, as we know that this happens with technology, we can quickly have a critical analysis tool that can improve the capabilities of our analysts. And the other advantage that it has is that it will contribute to improving active transparency. The idea is not only to use this tool at the office, but also to make this available to the public. So this is fundamental to us. Today, an analyst needs to resort to many many databases to solve cases, which is what we are willing to formalize with this agreement. Great. So this is another point to continue next year to see how this agreement has finally turned out. There is another aspect of the office that sometimes we sort of ignore, and it is the role of international organizations, or the office's role with other organizations, international organizations, and the OECD. So what is the impact of the Anti-Corruption Office and its engagement into the engagement with other organizations? Our engagement and interaction with other bodies and entities is on a daily basis. The UN, OECD, for instance, we work with the Ministry of Foreign Affairs, and that is a constant and permanent exercise. We are challenged by a permanent dialogue with these entities to account for facts, to collect information, and to improve the level of compliance with the commitments assumed by the Argentine state. So that includes municipalities, provinces, and the other powers of the state. Now, in late July, we are going to have an on-site visit from the United Nations, and it is a huge effort organizing this visit, particularly from our Office of Institutional Relations. So, by the way, I want to thank them, because they are trying to organize as much as possible. But well, this has an impact on our policy development and policy making, because we are constantly checking all the standards that the international treaties have. For instance, the preventive approach that the office has assumed in recent years. So the centralized monitoring of initiatives of the strategy, citizens' participation in this process through a council of experts, and the liaison network, all these mechanisms resulted after the recommendations of the OECD in the last integrity report that it made for Argentina. So more work, right, for the office? Yes, of course. And let me ask you something else about the office in relation to Law 27,401 that penalizes businesses that incur in bribery and related behaviors. So the office published all the guidelines related to the implementation of integrity programs. Some time has gone by ever since the effectiveness of the law. We know of no cases where the law has been directly applied. But in relation to the office, is there any interaction with the judiciary in the sense of providing training, perhaps, in relation to the enforcement of this law? Because in the legal field, there is interest in starting to know cases where the law has been applied and enforced, and it will be challenging. So this law was very important, of course, and it is recognized as an advance. However, despite that, despite the consensus that it gained in general terms, we know of very few cases where the law was mentioned but without reaching any sentence. So, unfortunately, we cannot interact in terms of individual cases. The office has the integrity and transparency registry to provide, because that would be good for companies and organizations to develop their integrity programs in relation to the law, based on the law. If you ask me, I believe, and by the way, today I met the people of the think tank of the Universidad del Noroeste of Buenos Aires, and they said that one of the challenges that we had was to disseminate the scope of the law. Many legal operators are not aware of the importance of this law. They do not even know that it can, or how it works, how it is structured. So we need to perhaps first create a sort of law promotion group, let's say, so that we can explain publicly why this piece of legislation is so important. And we should also perhaps make a more academic group to study the law in depth, to think whether there is something in the text of the law that is preventing it from operating as we would like. I think that perhaps we should give the law an opportunity to work, because it was a hard work. It was progress for the country. And I think it would be important that the courts could really fully assume this law and use it. But well, that is really at an embryonic stage. Okay, it was interesting. So we have only 2 minutes left. Please tell us, how do you see the anti-corruption office, and how do you think, or how would you like it to be in the future, in 5-10 years' time? What are the strengths that we should consider to sustain what is done well and to expand and allow the office to improve in the impact in corruption fight?
What a question. Let's see. I think that the office as I see it, and if I must envision its future, is to dig deeper into this preventative stage in its scope of action. I think that one of the major challenges that we face has to do with having to sustain as state policy the national strategy of integrity and the liaison network that allows for this strategy to have its full force, and then to overcome the different changes in administration and then strengthen the federal scope of a strategy in a stronger connection than the one we have today. We do have it, but it needs for further it calls for further strengthening with the different municipalities and different provinces. Now, as for the office, it is in a position to take that leap of an anti-corruption office or bureau into an integrity office or bureau. And that is a good thing. I think it is indeed important, because the power or strength that it may have has to do with the incorporation of its technological tools to its preventative role. And it was much discussed, and it's still in an ongoing discussion, whether or not the office should have a higher level of independence, autonomy, etc. And it is my perspective, or in my view, thinking about this as an agency outside of the executive branch would be a mistake, because today there are lots of things that are being conducted or implemented when it comes to judging specific cases of corruption. So if you were to prevent the office from its capacity, would miss an opportunity for an agency within the public administration, national public administration, not really executive branch, in broader sense, to undertake the difficult task of promoting policies of integrity and transparency. This doesn't mean that everything is great or looking great, but I think that it would really be beneficial for the office to have its own public employment office, to work better with its own employees, and then also to have its own IT department or office, because today we work with the support of other agencies from the IT areas of other agencies, mainly Ministry of Justice, Secretariat of Innovation, the IRS, that is AFIP here in Argentina. But in spite of all of their support, we still find restraints with regards to possibilities of action. So I think that the challenge of our office has to do with developing its own admin structure and cease to depend on the Ministry of Justice, as is the case today. Very clear. We've made the best of each of the seconds allocated to this panel. We wanted to share what the office has been doing and where it's heading for. So with that, we're going to wrap up this panel, and we will meet in a minute with our next panel on compliance and M&A deals.
Hi, everybody. My name is Macarena Garcia Mirri. I'm partner of the corporate and M&A team here at Marval. We're going to discuss in this panel compliance matters in M&A transactions. We have here today Howard Kleinman from Decker LLP. Hi, Howard.
Hola, ¿cómo estás? Hello,
Hola,
how are
¿qué tal? He's a partner of the Corporate and Securities Group in Decker and focuses on M&A. And we have also Laura Olati Cristofaro, partner of the M&A corporate team here at Marval. Hi, Laura.
Thank you, Maca. Thank you for the introduction.
So if you agree, we can start with the panel. Howard, let me start with you. What do you think is the current level of demand for compliance due diligence in M&A transactions?
Macarena, I think we all know as practitioners that there's been a tremendous increase in the demand for compliance, due diligence, and M&A transactions. It's interesting. I think that people are just unwilling, or clients are unwilling, to accept the level of corruption as a legitimate way of doing business. And there's an increasing importance to protect the reputation of clients. And I think there's significantly more regulatory requirements and a greater sophistication in the markets. I think these factors have all made clients much more aware and concerned the risks facing transactions and the relative relevance of compliance due diligence. I think we also sort of take into consideration there are a lot, local, I mean, when I talk about in each country, there are a lot of local regulations that punish board members and incentivize a more thorough and complete due diligence with respect to compliance matters. I think we realize on a global basis, corruption is a serious issue for companies doing business in many parts of the world. And more recently, we had a lot of experiences with how corruption impacts transactions and doing business in emerging markets. I mean, allegations under anti-corruption laws such as the U.S. Foreign Corrupt Practices Act and the U.K. Bribery Act can have potentially, they could be basically crippling consequences on the form of government investigations, sanctions, prosecutions, reputational damage. Furthermore, I think recent laws and legislation has incentivized compliance due diligence. And additionally, self-regulation within the companies, especially in case of the boards of global and more sophisticated companies, has contributed to these trends. In fact, there has developed a whole sort of whole category of legal services devoted to these matters, which help clients to create and update their codes, procedures, and policies. Consequently, in essence, a failure to complete an effective due diligence does not only mean the buyer is exposed to overpaying for a target, but also could basically impose or the client could effectively be committing a criminal offense, which is obviously something we really want to advise against or structure against.
Yeah, so I'll give my point of view as well. So I hear Howard, and I absolutely agree with what he's saying. I think in our jurisdiction, we also need to point out other factors. I think one of the factors is, as I think you mentioned this, Howard, is there's a lot of countries that have recently enacted regulations on anti-corruption that basically didn't have it. So when we conduct due diligence now, we don't only focus, let's say, on gathering facts for review of corrupt potential non-compliance with regulations of other countries, but also local regulations. Then we also need to mention, of course, the high-profile corruption cases in Latin America. I think that has definitely given the matter a further boost, such as, of course, the Lavallato or the Notebook case in Argentina. And then I think clients have become more conscious that there's a lot of countries in which it makes actually more sense to make a deeper due diligence on these matters. There are many countries that are highly regulated, and then maybe the macroeconomic conditions are not so stable. So at the end of the day, what happens is you've got companies that need to comply with a lot of regulations, but they don't have the resources, or they cannot allocate sufficient resources to comply with all of the regulations. So I think that in those countries in particular, clients have become more and more aware that it's more important to conduct due diligence. But I think what the good news about this is that for us as practitioners, the fact that we've been having a lot of cases has given us the experience to provide more efficient advice to clients and, be able to spot the issues right away and try to provide solutions to make M&A deals possible, even in this context.
Yeah, I actually agree with you both, and probably because we have a lot of clients that are public entities with a higher exposure to risk management, corrupt cases, this will lead to a higher demand of this kind of due diligence. And I'll go to the second question, and this is something that we usually get from clients, and it's why it's so important to conduct the pre-closing due diligence on compliance matters. Laura?
Yes, totally. I can pick that one. Okay, yeah, that's a question we get from clients a lot. Is why should it spend money, on this due diligence? So, at least in our jurisdiction, the fact that you've got an M&A does not in any way kind of diminish the liability of the target entity. So at the end of the day, you need to do the due diligence because it's a company you're buying. And if sanctions that could be imposed on the target entity are not limited to fines, you've got, of course, reputational risk. So that's something, the buyer would like to be aware of. And then you also can have other sanctions that could have impact on the target's business going forward. For instance, if it's a target entity that's dealing with with the government or providing services to the government, one of the potential sanctions could be to be struck out from the list of governmental providers. So, they're relevant sanctions in addition to fines. And also it could have impact on very relevant agreements of the target entity and also of the buyer. So in this context, we usually advise clients to conduct due diligence, to do it as soon as possible so that they have time if anything is spotted, right? Buyer will probably have internal processes to run to see if they want to move forward with the transaction or not. If they want to move forward, we need to consider potential adjustments to the structure. We need to consider potential mitigation measures. So at the end of the day for us, our advice is that they conduct due diligence as soon as possible. Howard, what do you think about that?
Yeah, I totally agree. I think that due diligence has become an essential part of the M&A transactions, and certainly compliance due diligence has played a significantly larger role in our due diligence. I mean, when we think about diligence, and you said when clients ask why all this work on diligence, it's essential because it always allows us to obtain additional information, helps us determine what the deal breakers are, if it's something that we determine that's so material, do we pull the deal? Do we determine or renegotiate the purchase price? It helps us sort of how we draft the SPA. Do we have to add specific types of indemnities, covenants, reps and warranties? Maybe we structure the deal with an escrow or other type of ancillary agreement to deal with specific result of our due diligence. We may need material information on the target for negotiation of the deal. It also allows us to consider any potential litigation that could be associated with the transaction. And finally, we want to protect the board, and part of our due diligence allows us to think about how we do that as well.
Okay, and I'm sorry. Yes.
No.
And
that's
probably,
Macarena.
I think I know the answer to this one, and probably we all do, but do we advise the same level of review to all clients and all targets? Do they all have the same risk profile when facing an M&A?
It's an interesting question. We always say it's very important to carry out compliance due diligence on all targets. But we would sort of generally say we recommend enhanced due diligence on regulated industries or cases where the target has a close interaction with the government or government-related officials. This includes cases whereby the target entity has relevant public contracts, was awarded public concessions, has a high dependence on certain regulatory permits. These are the type of transactions or targets that we really have to do our best job on, given sort of the nature of potential risk.
Yeah, so I couldn't agree more. So it's very relevant to understand the business of the target. Then on top of that, when you do the due diligence, you sometimes try to get more information about other relevant interactions that might not be linked to the core business of the entity, but sometimes the target entity has obtained a very important permit to start operating a facility, or there are some cases where you've got IT companies that basically have their software. Their main software was developed jointly with some governmental agency. So you've got the industry, and then you need to do a little bit more dig in to see if there's other relevant interaction. And then in my experience, the profile of the buyer also determines a little bit what's the scope of the due diligence. There are types of buyers that are a little bit more concerned about this matters than others. I don't know, Maca, your experience there.
Yeah, fortunately, I think we've done this for a very long time now. So usually we get a rapid diagnosis on what to do, what kind of due diligence we offer, depending, of course, on the client as well. So following the last one, we do have different levels of review because we already answered that, but what kind of levels of review we usually recommend or we get on the starting point?
Yeah, so we usually start with a questionnaire, reviewing the policies that the company has. We review the type of litigation that the company has, and then we usually do some research in public databases regarding the company, its main directors, officers, etc., just to have a general overview of the risk profile of the target entity. If there are some findings, then we might advise some interviews. But what we usually try to do just to check compliance in general is to have at least one or face-to-face or video conference with the target entity. Due diligence processes are really hideous for managers. They hate it because they need to continue operating the business, right? So sometimes you send very long Q&As and they answer to a lot of questions by saying not applicable. So do you have a compliance policy? Not applicable. So I think it's really good to have face-to-face meetings or just to have a video conference to get a little bit more information or insight on how the company actually operates. So Howard, I don't know if you have a view on this one.
Yeah, absolutely. And Laura, having worked with you, I don't think when somebody tells you as a practitioner not applicable, you're necessarily going to take that response and not dig deeper to get the real response there, especially with a client that may have a government contract. Yes. In any event, The following we a bunch of questions that we would typically want to ask is if the target maintains any policies, procedures, or training regarding compliance, anti-bribery, or economic sanctions or exports. What is the body of compliance at the target? It's very important. We'd also obviously, based on our previous discussion, as we said, we want to know if the target holds any registrations, licenses, or authorizations. It's really important to understand that. Also, if the target is involved in obtaining any export or import, customs clearances or fees when running its operations, it's all part of the same question in Q&A. If any notifications or approvals are required in connection with the contemplated transaction, also it's a very important question if the target provided anything of value but not limited to gifts or sponsored travel, entertainment, or hospitality to any government officials in any country. This is an extremely important question, especially with local regulators. Does the target use third parties, agents, or brokers to interact with government officials? That's really important as well, to understand that relationship. And finally, if the target is aware of any actual potential violation of compliance regulation involving itself or third parties acting on its behalf. Look, the reality is if the nature of the finding dictates the extent of the diligence and level of review required, we need to identify the business affiliations, the directorships, the partnerships, the shareholding. We actually do background information, prepare questionnaires to assess the compliance commitment, the implementation, and the implementation of the special measures. We could actually talk about mitigation strategies and the development of any integration plan to address the risk that we identified. I think it starts off where you said, Laura, in terms of basics, and then we get very specific for the more that we learn.
Okay, I'm just seeing the time, and we already discussed this. I'm going to skip the question number 5 that we had, and I'm going to go with the next one. And if we get any red flags in these kind of matters, is it always a no-go for the transaction, or can we do something?
It's a funny question, Macarena, because I think that you could say that every relevant finding is a deal breaker or deal adjuster. But it's really unusual, in my experience, having done this for a long time, to find a deal breaker because not every diligence finding requires the transaction be terminated. There are typically ways to protect the client from the risk. We can, again, talk about covenants, guarantees, reps, warranties, indemnities. We have earnouts. We could potentially think about ring fencing or price adjustments, or allowing for deductions from the purchase price. Mostly, it's all about how we manage the risk and how we allocate the risk to protect our clients.
Yeah, so I agree with you. So in our experience, it is possible to reduce the exposure and to continue with the deal. There are probably 3 factors that are measured. Let's say one is the relevance of the finding. The other one is it an isolated finding, or is it something that's a widespread conduct in the company? It's a completely different situation. Again, I think the risk profile of the buyer is also very relevant. So I think that our role as counsel is to try to find solutions, to be able to make the deal happen. And we need to consider those in the context of the actual transaction. For instance, when there's a red flag, one of the things you always consider is, we should separate the people that were involved in the potential corruption practices, right? Is it possible in this transaction? I mean, are these the key people that basically our client is buying the target for? Can we in some way modify the perimeter of the transaction in a way that we can feel more comfortable, etc., right? So our role as counsel would be to try to provide efficient solutions for the deal to be able to move forward.
Yeah, I actually agree. We had cases in which we apply ring fencing mechanism to delimit the contingencies that were included in the target company. So probably that is the way to go, and the deal breaker is hopefully know the solution. We're gonna go to the last 2 questions, and Laura, if you agree, I will go with you. Which do you think are recommended pre-closing mitigation actions?
So again, I'm going to repeat myself, but I think it's very important to conduct your due diligence on compliance matters. And once the due diligence is basically done, there's going to be a lot of things you're going to need to pick up in the SPA and during negotiations, kind of these measures that we've been discussing to try to protect the buyer as much as possible. Then another thing we usually do is if there was no time for due diligence, sometimes we include that as something between signing and closing, sort of a CP. And even when there was a due diligence, we sometimes include as a CP that there has been no, the company has not been notified of any potential corruption action between signing and closing, etc. So that's between signing and closing. That's usually the things that we contemplate. I don't know, Howard, if you probably have a lot to add to that.
Yeah, I mean, I think it's exactly right, and this is where we get to have a little creativity as lawyers, which is sometimes rare in our careers. But one of the things that I've seen done recently, we worked in Brazil in some transactions where the company itself was strictly liable for the actions that were made by some of its employees, and we were able to actually take the assets out of the company and transfer assets to a new company without having to deal and keeping the liability at this sort of company where the corruption, the non-compliance occurred, and those things like that are things that we sort of deal with all the time. How can we do that within with the local regulation? And so I think we have to deal with the structure, and we also have to deal with the contracts, as you actually pointed out, exactly right.
So for the last one, what about post-closing actions? So probably.
So you're saying.
Yeah. What about if we buy the company, even if we acquire the 100% of the company or if we get a JV, what do we usually do?
Well, I think that after Laura and you guys have done your diligence, we've negotiated the contracts, and basically we're done. I think we've been smart enough, knowing that we've been doing this for many years, to, in our purchase agreements and in our shareholders agreements, provide for typical mitigation of those risks, hopefully. So, for example, I think we would have reps and warranties declaring that for a certain period of time, and that to the knowledge of the sellers, the owners, directors, employees, or any agent has not made any bribes. So basically, there's a sort of a tail for those types of reps. We certainly have indemnities for breach of those reps associated with some of those actions that really, to the extent there's a breach. Sometimes we could add into the purchase agreement with the contracts special obligations for implementing policies and procedures to make sure that the target and subsidiaries, its employees, are conducting the business in pursuant to applicable regulations. We also think it's very important post-closing conduct compliance training to make sure that once the target is acquired, it understands what the proper compliance is by the purchaser, assuming the purchaser has its own compliance policies. And also we would recommend compliance audits as well to make sure the company, now that it's been acquired, is acting in the way it should be acting and meeting its obligations.
So briefly, because I think our time is almost over. So so I agree with Howard. We usually have a lot of protections in standard SPAs, and then the client needs to do its post-closing due diligence, try to find who are the people that have relevant interactions, and agree with them a way of working, have their policies in place in the new target. And I think that's basically what we need to do. In the case of the JV, we will likely include all that in a shareholders agreement, grant the parties audit rights so that everybody feels comfortable, and sometimes, foresee what could happen if any of the parties incurs kind of in a corrupt practices, and give some rights to the non-compliant party, so that the non-compliant party to the compliant party, so that the compliant party might have a way out if they want to, some liquidity rights maybe. So that's basically what we find. Okay.
Okay. Well, we can come back a second to the question we skipped. What are the usual detected red flags that we get in due diligence? So we have like 30 seconds, and we can go.
So for sure, if you've got a proceeding, basically that's the obvious one, and then with lower relevant level of importance, of course, if you haven't got policies, if the answers show that you've got like very poor consciousness of what compliance rules are, and I think it's basically those. Sometimes also if they are reluctant to provide information, but and here. A comment to close this. We've been talking about buyer side all the time, but sometimes you get to advise the seller. And it's good to know that in many cases, M&A teams of the companies are not aware of ongoing internal proceedings that may be going on when they're actually selling the target. So that's something to also consider. Sometimes sellers also need advice on what information to provide and how to provide it. Depending the stage in which it is, basically in the company, that something is being investigated. Depending on the stage, they might need some advice as well.
Okay, well, I think our time is up. Thank you very much,
Thank
all
you.
of you, for joining
Thank you.
us. Thank you,
Thank
Howard.
you.
Thank you,
Thank you.
Laura.
Thank you.
We'll come back
very
in a
much. Thank you,
minute.
Macarena, Laura, thank you.
Thank you. We'll come back in a minute
Bye-bye.
with the following panel, Vision on Law Firms in Latin America. Thank you, Gustavo, for organizing this and inviting us.
Yes, thank you.
Thanks.
Bye. Thank you.
Okay, we are back for the final panel of our conference today. We will be discussing trends in compliance and anti-corruption throughout Latin America. Particularly, we will be discussing Mexico, Chile, and Brazil. I will provide what I can from the point of view of Argentina, okay? So that being said, let me start with Chile. Rodrigo Campero. Let me start by introducing all of you, right? So Rodrigo Campero from CMS Kerry and Allende from Chile, Marcelo Sengler from Tosini Freire, Brazil, Flavia Leardini to my right from Matos Filho, Brazil, and Luis Danton from LEC, Mexico, right? So it's a wonderful panel to close our conference today. Now let's go back to you, Rodrigo. So there is a new law in Chile regarding economic crime, right?
Mm-hmm.
Which
correct.
is going to provide lots of work to you and to
I
your
hope so.
team, right? So tell us a bit about that.
Okay, thank you. First of all, thank you, Gustavo, for the invitation to this wonderful event. As you said, the Congress ended passed a bill about economic crimes. The bill has not been promulgated yet by the president, but it's a matter of weeks or months. So it will be a reality in a very soon time. And this law will change a lot the landscape of economic crime. In a matter of compliance, that is to say the liability of legal entities, it will change a lot the way how the companies will have to focus their risk management. Currently, a company can be found liable if the offense is committed for the benefit of the company, for a person belonging to the company, and if the offense was a consequence of a breach of from the company of its duty of supervision to their people. But according to the new law, the requirement of benefit to the company will no longer be enforced. So if the offense is committed by somebody fulfilling a role, a function within the organization, and if the offense is a consequence of not having an adequate compliance program, the company will be found liable. So it's a very big change. It's not a strict liability, but it's very, very, very near to that. So the compliance programs will not will be focused just to chase the fact if the company is being benefited from the offense. Instead, the company will have to do a real risk management and to determine which of the offense contained in the law may affect the company. And then the very intimidating part of this is that the catalog of offenses that may affect a company will be is increased very relevantly. Now a company may be liable for 28 crimes.
Mm-hmm.
Now more than 200.
Wow.
So obviously not the company will not be liable of anyone because some of them are very specific. For example, environmental law or fishing law or things like that. But there are some offenses that may affect any company. For example, infringement to securities law, banking law, tax law, collusion, financing of politics, cybercrime, IP infringement, etc. So will be a big impact to companies' operation, and of course a great opportunity to compliance lawyers.
Yeah, absolutely, absolutely. I mean, it's interesting to see, to compare what you are describing with what we have in Argentina, because the key element for a company to be liable for bribery in Argentina, and we only have like a short list of conducts, not 20-something or 200, right, like you do, but is that the company benefited from that conduct. So Chile is going the other way, right?
Mm-hmm, absolutely.
Simply removing the requisite of benefit. That will be a huge change. So how do you anticipate compliance programs will evolve to try to catch up with that change? Do you see any differences in the near future for compliance programs?
Yes, the focus will change because, as you said, now the company has to determine whether, for example, the bribery gives a benefit to the company. But now the mere fact of the bribery will make the company liable, and the same idea for for the remaining 200 crimes. So now the focus of the compliance program will be of risk management. That is to say, to correctly identify which of the 200 crimes will affect your company, and after that, place the efforts in the places where the risk are higher and structure your compliance program from that point of view.
Very interesting, very interesting. So now that we are talking about compliance programs, Marcelo, I know that when you make presentations, you make differences between compliance programs and integrity programs, and you can link that to what this difference means under Brazilian law, the real impact, right? So what can you tell us about that?
Thank you for having me, Gustavo, to be here alongside these great professionals, Flávia, Luis, and Rodrigo. Actually, Brazilian law doesn't use the expression compliance because of a constitutional requirement that Portuguese must be the official language of Brazil. Our legislation since 2013 has always used the expression integrity programs to address all those requirements that we use in compliance programs, such as tone at the top, codes of conduct, training, due diligence, etc. This ended up generating some confusion in Brazil because many professionals began to use integrity programs as a synonym for compliance programs. However, it's important to note that there are distinct differences between them. And I have consistently, as you said, endorsed that integrity programs are richer in elements than compliance programs. Many companies implement their compliance programs only to fulfill the legal requirements and escape serious sanctions if illegal practices are detected. They are not really concerned with cultivating a clean business environment or preventing their employees from engaging in crimes or misconduct. These programs are often implemented superficially to conceal the company's and old vicious practices. That's why the goal of an integrity program is more ambitious: to promote the correct conduct of all stakeholders to strengthen the reputation and image of the company. And as Richard said, enhancing what is right goes beyond merely avoiding what's wrong, which means that an integrity program is wider in scope than a compliance program. At this point, the distinction between one and the other becomes evident. The integrity program is concerned with making the organization operate in line with very high standards, while the compliance program is only concerned with protecting the company against potential sanctions. Therefore, the goals of an integrity program are much broader than simply preventing illegal practices against the company or the public administration. They must be linked to the perpetuation of ethical values. Whenever I try to establish this difference, I'm reminded Luis Moreno Campo, who was the first prosecutor of International Criminal Court, who classifies the members of an organization in three types: a person of integrity, represented by greens; the honest, represented by yellows; and the dishonest, represented by reds. To illustrate this concept, Moreno Campos says, let's imagine a closed room. In the center of this room, there is a table. On the table, there is a pile of money. And in the corner of the room, there is a camera recording everything that goes on inside. You can leave a green, a person of integrity, inside that room for 1 hour, 1 day, 1 month, 1 year. You can turn off the camera, and he or she will protect the money to return to the real owner. They will always do what is right, regardless the circumstances and personal benefit, because he or she adheres to a culture of integrity. The yellows, if they are sure that can embezzle some of that money and that no one will find out, they will. The important thing for yellows is to keep the image of honest and not do what is right. And the reds, as we know, will take all the money and will take the camera too. No matter codes of conduct, training, or monitoring. Moreno Campos says, based on his experience, we generally observe a distribution of 15% of greens, 15% reds, and 70% 40% of yellows in organizations around the world. The representation of colors is very important to confirm the importance of the tone at the top, because when we have people of integrity in high administration, the tendency is for yellows to turn greenish. The opposite is also true. When we have the red ones on the top, the tendency is to increase corruption. In Sweden, we're having an old quotation: a fish rots from the head down. It means that when an organization fails, the leadership that is the main cause. In short, I could say, this precious explanation from Moreno Campo, the goal of a compliance program is to keep the yellows honest, while the goal of an integrity program is to increase the number of the greens into the organization.
Yeah. Very good illustration, right? Using colors, quite easy, quite clear, right?
But so, nothing connected with politicians. Okay?
No way, no way, no way, no way. We leave politics aside in the conference, okay? So, but people can draw whatever conclusions they want to draw. That being said, there is a new decree, right, regulating the Brazilian Clean Companies Act. What can you say about the impact of this decree, how it changes the landscape somehow in anti-corruption in Brazil?
That difference between compliance programs and the integrity programs, Gustavo, they are very important to highlight the main change produced by the new decree 11129, which began to emphasize the promotion and maintenance of the culture of integrity in the organizational environment as an element of the concept of an integrity program. It is the Article 56, Item 2. It means that from now, companies will have to demonstrate that they encourage, disseminate, and have ingrained the foundations of the integrity culture. By doing so, they must prove that they have an effective integrity program in full operation. Integrity can be developed within a corporation using different motivational models, which must start from institutional, social, and cultural contexts. This makes it possible to link the role played by each employee with institutional loyalty, emphasizing values, principles, and virtues with a professional conduct. For example, the importance of awareness of being bound by professional rules or standards of behavior. An environment of business integrity will also make employees become true defenders of the company, including naturally supervising their colleagues and reporting facts through the reporting channel. In fact, the significant increase in the number and quality of reports is a clear sign that employees are acknowledging that they are part of one company with a culture of integrity. All employees become supervisors, and therefore the frequency of misconduct decreases. Organizations with a strong culture of integrity create trusting relationships with their stakeholders, employees, customers, and suppliers. At the same time, this helps to build positive relationships with public authorities and also helps to attract long-term investors. Finally, an effective integrity program ensures optimal performance for the company to the long term and run. Moreover, the culture of integrity cannot be limited to the company's internal procedures. It must ensure that the company establishes an honest dialogue with the community where it is located, including developing or providing support for diversity and social programs. This tendency to obtain social respect involves the idea of citizen corporation. That's why I consider ESG policies as an element of an integrity program. Can a company with zero corruption but no corporate governance be considered a company of integrity? Can a company with excellent profits but that pollutes the environment and uses slave labor in its supply chain be considered a company of integrity? Of course, the answers to these questions are no. And for this reason, I believe that Brazilian legislation is on the right track to consider the culture of integrity as an element of Brazilian integrity programs.
Thank you, Marcelo. So now let me turn to you, Flavia. You know, Brazilians became famous for many reasons around the world, right? Great place to visit, soccer, maybe. But also because you were able to
You
thoroughly.
know the truth, so
No,
we are the best in football. So
let's discuss that later. But you also became famous because you conducted, you, Brazil, conducted the car wash investigation, right? The huge, massive investigation. So what is going on right now in terms of investigations by the authorities in Brazil? What type of activity can we see in Brazil these days?
So first, thank you for having me here. It's a pleasure to be in Argentina, and it was just a joke because we love to joke with Argentinas, and because of soccer, of course. And I'm here today to talk about soccer. So
really, later.
Yeah, this is the case. It's about soccer. But I also want to say one thing, that I'm just checking my phone. It's not that I'm deleting, Gert, my WhatsApp message. It's just because my notes are here, and we are not talking about Lava Jato case today. And I think that it's a great moment, because after like almost 9 years, you know everything about Lava Jato. I think the world has learned everything about Brazil and Brazil proceedings and how the prosecutors is doing their job. So, but I was thinking what I will say to them, and what's going on in Brazil after Lava Jato. I think that is the relevant matter here. And I was thinking that we are seeing like cases of corruptions, of course, because Lava Jato has ended, but the corruption, has not, for sure. And we are seeing like cases in federal levels. For example, last week we had an operation in Brazil. Of course, that it's not similar to Lava Jato, but it's a very important case. It's a very, I think it's a very important case because the targets of the operation, and it was on bids, frauds and embezzlement and money laundering, because in Brazil, I don't know exactly how it's here in Argentina, but for example, if a state needs to invest funds in a school or in a hospital, and they need money for these type of activities, they will apply for the federal funds, and the funds needed to be applied in this type of activities. And so we are now following this money, and we are seeing that, they are not being applied in somehow, it's not being applied at all, like in some cases. So this is one type of operation that we are seeing. And as you mentioned before, Marcelo, as you know, in Brazil, you are seeing like our federal prosecutors' labor, that it's a civil cases and civil responsibilities, are focused on investigating companies for, I will name, modern slavery. And we saw like so many cases in Brazil. It was sad to see these cases in Brazil, but this case become like a criminal case, so we are following these type of activities as well. But I would like to say that a new case, there is a new case in Brazil, and I was here to talk about soccer, and I think that it's very interesting because we are used to say that in Brazil you have not private corruption. And I think that it's the first case that we will see or discuss a private corruption, because we have a crime in Brazil connected with soccer,
It's very similar to corruption, and a lot of people will say that it's a private corruption, and it's to bribe players to, for example, to change the results of the game. And I think we've never seen like a case like that. And it's the first time that we are facing this type of investigation. I will say the fact it started in the state of Goiás. And one guy who is the president of a very small club in this state in Brazil said, "Oh, I think that something is wrong in my team, and the guys are receiving money for example, yellow cards in the games." It was not our national championship. It was like Series C, I don't know, or B in Brazil. It was not the elite of the football. But the investigation has started with this fact. And how they use, like, this organization is receiving money. They learned during the investigation that they were like paying these players to receive, as I mentioned, like red or yellow cards during the games. And through the betting platforms, this organization, this criminal organization, were receiving a lot of money. And so this investigation started to go deeper and deeper and deeper. And now we know, we just learned it, that a lot of players in the elite of the football in Brazil were involved, and a lot of players has just plead guilt and paid the fines to avoid trial in Brazil. And this matter become, as you can imagine, like soccer in Brazil is, I think it's more serious than here in Argentina, or it's similar. But I think all the America Latina loves football, so this is something very important. And now this investigation is a congressional inquiry in Brazil. So our House of Representatives is investigating the case as well. And this Monday, the congressman has just voted on and approved all the requests for the representatives of this company, these betting companies, to be heard in the congressional inquiry in Brazil. So we will have, and I don't know if you know that, but in Brazil, gambling is not allowed. It's a misdemeanor, but it's a criminal conduct. So probably we will discuss this matter for a long time in Brazil, and I think that it's a new case that can bring like a lot of discussion, and it's good to have this now in Brazil changing somehow the matter of the discussions.
Absolutely. So we are talking about corruption in soccer.
Yeah.
And it's not FIFA.
No, it's not FIFA.
Amazing.
Yes, amazing.
Amazing, amazing. So that being said, in terms of settlements with the authorities, right? What is the current landscape in Brazil? What are the challenges that you see companies are facing nowadays?
I will start with, I just mentioned that some players just settled an agreement with the prosecutors in the state of Goiás in Brazil. This is a new agreement, so I will start with this. It's like a timeline here. If you remember that in 2013, Brazil enacted a law regulating better the collaboration agreements, but we don't have, or we haven't had like another type of agreement as the U.S. has, that is non-prosecution agreement. And in 2020, I think, Marcelo, it was the law came into force, and now we have this type of new agreements in Brazil.
And as you know, we tested a lot our collaboration agreement during Lava Jato, and now we are testing this new agreement in Brazil. We have a very different system from the US, but we are seeing like so many cases end up in settlement. So from a criminal perspective, probably we will see more and more cases ended in this type of agreement. From a civil perspective or administrative perspective, I think that it's a very great moment in Brazil. The CGU has just settled 3 huge cases in Brazil last December. Probably you have heard, Marcelo, I'm sure that you heard about BRF case in Brazil, and the settlement is around I think 600 million reais. So it's a large penalty applied. And we have 2 more cases, and all the case regarding corruption. So in the administrative is very with the CGU. And I think that the new minister of CGU, who was just appointed for the new government, he's a very well-experienced guy, and who has a large experience in leniency agreements. So probably we will see more leniency or negotiation agreements in Brazil. And just one thing more, I think it's very important. He just started in the role, but he how can I say this? He's put together 3 sections in CGU. He put in one same section. The name is integrity, privacy, integrity. And now you can have, in the same place, you can have administrative proceedings, leniency negotiations, and you can have the compliance programs as well at the same section. So I think it's something very good, and you are, I think, in a good administrative time in Brazil to settlement.
Very interesting. Thank you, Flavia. Luis, for the final part of the panel and the final part of the conference as well.
Yes.
I'm turning to you to discuss Mexico. Okay.
Yes.
So what's going on in Mexico in terms of anti-corruption enforcement? What are the main challenges, roadblocks? Tell us a bit about it. You are deeply involved in those matters.
Thank you very much. Well, first, even if it's the end, I want to thank you for inviting me. It's been an incredible experience, and I've learned a lot. And this morning I've enjoyed very much listening to Delia Ferreira talk about the obstacles for anti-corruption enforcement, and in particular of prosecutors. And she highlighted 3 things. One was the independence of prosecutors, the other was resources, and the third was authority. And I think for me, it was very interesting to hear that there were other prosecutors that were created legally from scratch and that were given no budget on the first year, which was the case of Mexico. Mexico spent a long time debating the creation of a system. What prompted the establishment of this system was a scandal involving the prior president. He bought a house from a supplier, a government contractor, and that created a great scandal that effectively ended his administration. He was a lame duck since that moment, and of course you always want an anti-corruption system, a new one, to be applied to your successor, not to you. So what they did is conceive a grand national anti-corruption system at the federal level that will also be replicated at the state level, and that would take forever to implement. And that was the case. It took his entire administration to pass a constitutional reform, to pass the laws, time for the laws to enter into effect. Then there was a political disagreement as to who should be appointed the new independent prosecutor. A new prosecutor's office was created
that was at least constitutional, at least in the paper, independent, and it took forever. There was no consensus. So there was not a decision of who would be the prosecutor and who would be the chief anti-corruption prosecutor until after the election. And the angst, the anger, the negative feelings that society had towards the corruption that was prevalent gave an extraordinary victory to the current president. So everybody expected that there would be more resources dedicated to it, more enforcement. And what has happened is that there was an agreement of who should be appointed the new prosecutor, but the overwhelming majority in Congress of the president resulted in the appointment of someone close to him or someone of his liking. And that goes to the first point of Delhi, of independence. In terms of resources, I know because I'm close to the action as a practitioner and go to the Attorney General office. For the first year, you would see that there was no line item in the budget, and the federal budget, for the new Chief Anti-Corruption Prosecutor's Office. So it took 1 year without resources. The second year, this office was given the personnel that belonged to a former unit that prosecuted government officials. Something that makes more complex the enforcement is that simultaneous to the creation of this system, Mexico moved from a written process to an oral process. And the effect of that is gigantic, because you have to train lawyers, you have to train judges, you have to train a lot of people to understand the new reality, the new procedural reality. So that also complicated things, and this staff obviously was not up to the challenge. The third year there were changes in the staffing, replacements. I think now, looking at the Fiscalia, it has a relatively young staff with a very high number of women and a good number of people that speak English and that are able to understand and access what's happening in the world in the practice of anti-corruption. So you have a team, and then the fourth year of the prosecutor's office, the DOJ acknowledged Mexico's cooperation in a case, one of the important cases that were concluded last year, Stericycle, which involves Argentina. It's it involves Argentina and Brazil,
as well, yes.
and Brazil. It's a case where small government contracts for trash disposal. There were smaller bribes paid as a percentages of the contract to lesser government officials, and the point of the DOJ in prosecuting this is it doesn't matter if they're small, if they go to low level government officials. We care, and there was a settlement. Mexico cooperated, but then it's not yet the full-fledged cooperation and joint investigation that we want to see. But being close to the work of the prosecutor's office, I have now with my firm 5 cases before them. What I can tell you is that they are working in other cases now, and that cooperation is already underway with their U.S. counterparts. And I wouldn't be surprised if we see, maybe next year, maybe this year, progress in the same direction. I said this in an event last week in Mexico City, and someone said that I was giving a free pass to the Fiscalia. But I'm really not. I am an optimist, and I think that creating from scratch an office in these conditions is something very difficult, and that it's bound to give results at some point in time. At least we have this in place. With Gustavo, I've discussed many times that we think in Latin America that just by coming up with a new law, we solve a problem. But the laws that form the anti-corruption system have serious flaws, including, for example, we incorporate the concept of compliance in one article in the National Criminal Procedure Code, Article 421, and arguably it's unconstitutional because one of the principles of criminal law is taxatividad. I think it's the same in all of our civil world. It has to be precise, the concepts have to be very specific, and the way we refer to compliance is not as integrity programs, but debido control, which I struggle to find something more ambiguous than that. And that needs to be changed. We don't have a definition in the criminal code of the elements, and we don't have any indication of what the benefits are going to be. So there needs to be clearly a legislative amendment to many of the aspects of these laws. We don't have the legal basis for a settlement in anti-corruption matters. We use that of delitos patrimoniales, which is clearly not the same. Currently, because of the structure of the Fiscalía, money laundering cases are handled in one area that doesn't speak well with the Fiscalía Anticorrupción and vice versa. So they need to be prosecuted, including all of the elements of the offenses. So there are needs that there are things that need to be reworked, and I see that time is running. And that I'm getting close to the mark. But if I can conclude this on a positive note, that I think, given the vicinity with the U.S., we're going to see joint prosecution not in a very distant future. Thank you.
Thank you so much, Luis. That concludes our panel. So again, thank you, Rodrigo, Marcelo, Flavia, Luis. And it also concludes our conference this year. So a big thank you to everyone who has collaborated at Marval to make this happen. A big thank you to all of those following the live streaming in many places. Our marketing team reports that more than 3,000 people connected to the live streaming during the day. And to all of those here in our auditorium in Argentina, it's been wonderful. We look forward to seeing you all next year again. Thank you.